pronunciation?
No,
Okay, so I'll do an introduction.
Right.
But we're the Internet Numbers Registry for the Asia Pacific region.
Oh, okay.
IP address is
Yeah.
the connectivity for the providers. So in Singapore,
Right.
with the different mobile operators, ISPs,
Oui.
they are members.
Hello. Okay.
They get the addresses from us. And then
So we will
they
begin our workshop immediately. Please sit it. Okay.
Before we went out.
All right. Thank you.
Yes. Yeah, I saw the announcement. Europe has run out of IPv4. It's quite a thing. The price just went up very sharply, I think.
Okay. All right. So good morning. Thank you for attending our workshop this morning. I think the time is early. And my name is Li Yuxiao. I'm the Secretary General of the Cybersecurity Association of China. This morning, I'm the host and happy to welcome you to participate in our workshop. And this workshop today is about the different parties' rules in the personal information protection practices and attempts in the view of Asia-Pacific region. Since we are all concerned about this issue, okay, thank you. We're honored to create this panel to, I think, these 2 points. Firstly, effectively publicize. Yeah, just begin. Okay. Okay. This is just begin. Okay. So firstly, we created this panel is to effectively publicize the method and the practice of personal information protection in the Asia-Pacific region. And secondly, enhance participants' many understanding on the role that different subjects can play in the personal information protection. Right now, let me introduce about our fantastic guest here, and they are Professor Wolfgang Kellewaters.
Wolfgang is enough.
Wolfgang is enough. Okay, we know him very well. Yeah, he's so famous in this internet governance area, and I think that it's very important to hear about his idea in this area. And also, I want to introduce the CEO of Epinic Foundation, Mr. Duncan McIntosh. You're welcome. And Mr. Henry Gao, Associate Professor of Law, Singapore Management University. You're welcome. And Dr. Hong Yanqing, Senior Researcher at Law and Development Economy at Peking University. You're welcome. And another speaker is Asia Data. He's founder and CEO of Data Sagan Technologies, who is now joining us remotely. And another one, I think, is Professor Joanne, and he's executive director of Diplo Foundation, and he's also the secretary of the UN High-Level Panel on Digital Cooperation. I think later he will join us. And so I think that since we talk about the personal information protection, this is a very seriously problem or questions for us when we face a lot of new technologies and new policies appeared in all the world, and we must think about what's the basic principle for protect the personal information. And first, I want to share some ideas with you and introduce about our association's activities in the past few times. Right now, I'm the Secretary General of the Cybersecurity Association of China, and we call it CSAC, CSIC. It's the first nationwide no-profit social organization in the field of cybersecurity. which is founded in 1916. And so far, we have 280 unit members and 300 individual members, include Chinese leading IT enterprises and cybersecurity enterprises, universities, research institute, and industry expert. The protection of personal information, I think that has always been an important issue of concern to our association, and our member has been actively promoting the protection of personal information of China. This effort are not only direct to relevant government department and the legislative branches, but also to the general public. In 2019, China launched the special governance actions against the mobile apps, which collect and use personal information in violation of laws and regulation. And I think Dr. Hong will introduce it later. And our association has deeply involved in these APP actions, and we have achieved very good results. Since its establishment, our association has also been carrying out an activity called Cybersecurity Tour in China, which aims to raise the public awareness of information protection in various provinces all across China. And since we talk about the personal information, I think that it's a really complex issue, especially engaging emerging technologies such as AI, 5G, IoT, and big data has continuously promoted various information services and turned on all connected users into consumers who has highly rely on internet services. In the past time, many services providers have the formulations of data technology and the internet rules, but lack effective governance mechanism, especially the monitoring and responsibility determination mechanism. The public policy makers and the regulators lack effective tools to implement personal information protection and the ability to judge the possible risk that the information service pose to the personal information protection, as well as facing huge pressure from the public. They are consensus but still not convention in the international community. In the absence of the mechanism for the international, Professor, you're welcome. The institutional difference between countries have become the source for the corresponding data flow. Obviously, enterprises, services, and personal data flows globally. However, supervision and laws has national boundaries. What we are facing is structural issues, in fact, which not only require time, but also the participation of all parties. Moreover, civil society should take on more roles. So in this regard, I would like to make some following suggestions. I think that is just three. Firstly, in the absence of the global personal information protection rules, each party should clearly define its responsibility in the protection process. We see more and more countries are formulating corresponding laws to protect the legislative right and the interest of users. And in EU, the GDPR is a typical case, but it only protects the right of EU citizens and take efforts to the EU's benefit, but also for the Asia-Pacific user cannot be fully protected. Under one world, one night, do all the internet users have some of the same rights? Does it include the right to protect personal information? Are there no responsibility and lacks of protections because of regional difference? Obviously, the necessary communication channels need to be established between the government, enterprises, and the community to solve this problem. I think it's the first. And secondly, compare with the EU, US, and other regions where personal information protection has been practiced earlier, Asia Pacific can do much more in terms of personal information protection in the future. We created this workshop arm to discuss this topic in depth. And we also hope to promote the improvement of the personal information protection in Asia and the Asia Pacific regions. Think of facing the 4.2 billion people and 2.27 billion internet users in Asia, we realize the huge difference and the difficulties. Civil society, I think, should actually organize and publicize the best practice cases and experience of personal information protection. Through this, we can jointly improve the level of personal information protection and work for creating a regional or even global applicable rules on personal information protection. Civil society in various countries should further stringent communication and mutual recognition mechanism for the protection of personal information can be established between countries. Perhaps the Asia Pacific countries can take the first steps to protect the cybersecurities of Asia Pacific regions and avoid extensive internet fragmentations. Europe has always been at the forefront in this field and other areas also. And I think that it's worth it for our more research and study for the Asia countries. And thirdly, but not maybe there's something more, not least, the legal protection of personal information should become the basic right of every citizen, and the protection of people's information to consumer should become the basic responsibility of service provider. Civil society should serve as an important platform. On the one hand, we should increase the input to formulate standards for personal information protection in the industry and to restrict it to the collection, use, transmission of personal information through industrial self-regulation. On the other hand, civil society can encourage members, companies, to develop personal information protection tools and provide services to protect personal information usefully. For example, our members include many leading cybersecurity companies. As guardians of the internet, they have natural advantages and while responding to traditional cybersecurity problems, they can treat personal information protection as a very promising market. So at the level of personal information protection, I suggest that exchange in the Asia-Pacific regions should be richer and more effective, and the exchanges between civil society and communities in various countries should be more active and in-depth. Meanwhile, we also will welcome companies, research institutions, and experts from all over the country and to conduct a dialogue with us and provide valuable policy suggestions to governments and the international communities. We also hope that the local governments will fully consider the reasonable claim of our members' company and the internet users and give them the necessary protection. So this I want to share to you all, and thank you. And later, I want to introduce Mr. Duncan Merchant to give us a few words. Okay.
Thank you very much. Good morning, everybody. Let me begin by thanking the Cybersecurity Association of China and congratulating Li Yuzhao and his team for putting this workshop together. I'm very pleased to be here on behalf of APNIC. For those of you who were looking for Paul Wilson, the Director General of APNIC, Paul's had to stay in Australia because of the bushfire situation there around his home. So I'm here as the CEO of the APNIC Foundation, which is closely affiliated to APNIC, and we work together very closely. So we're very pleased to have this chance to join this panel. And I'm going to give you a specific example of the challenge of managing personal information. But before I do that, I'll step back and introduce APNIC. For those of you in the audience who don't know APNIC, it's the Asia Pacific Network Information Center. It's one of 5 regional internet registries around the world responsible for managing and distributing IP addresses, internet protocol addresses, the fundamental number or point of connectivity in your device. If you go to settings, everyone in this room, take your phone, go to settings, you'll find the IP address that your provider has provided dynamically on a daily basis when you log on. And that address provides the point of connectivity for your device on a daily basis. And that address is provided by one of the 5 regional internet registries. Here in Europe, it's RIPE, which is based in Amsterdam. We obviously are APNIC in Asia Pacific. There's a LACNIC for Latin America, an AFRINIC for Africa, etc., for the regions. And the model of operation for the Internet Numbers Registries is a non-profit membership organisation. So APNIC as an organisation is actually a secretariat serving a membership. And the way it works is, as a mobile phone operator or an internet service provider or a data centre requires internet IP addresses or AS numbers, the address resources needed for connectivity in their networks, they will come to us, to APNIC, and request a supply of number resources. We provide those, and in that process, that network provider becomes our member. In the Asia Pacific region, we have around 16,000 network operators as members. These are divided into direct members to APNIC, or indirect members, as in the case in China, where there is a national numbers registry, CNIC, that provides this number resource services to all the network operators in China. And there are several other national registries around the region. We're not a large organisation. We're about 80 staff managing this particularly fundamental piece of the internet infrastructure at the very foundation, if you like. But the management of the addresses is, of course, a fairly large exercise because there's billions, literally, of addresses. For those of you who follow the registries, you'll know that in Europe this week, they actually ran out of IPv4 addresses in quite a big announcement, but that's another conversation I can have with people separately. The responsibility of managing the addresses is really the really key aspect of APNIC's operations. And when we distribute or allocate or provide address resources to a network operator in each economy, and in our region we have 56 economies, so they include obviously China and India, very large economies with some of the, well, not some of, the largest mobile phone operators in the world, in the case of China, down to the smallest ISPs in the Pacific Islands, for example, in places like Vanuatu or Tuvalu, where the ISP is servicing 8,000 people. But in each of those 56 economies, which is from Afghanistan to the Pacific, we have this responsibility to provide these addresses, but then to always be able to identify who is managing those addresses. And this is the key bit about personal information, because what happens is if I'm a network operator in, for example, Indonesia, and I may have an issue or a concern with another network, because obviously everybody's network is very closely integrated and connected. That's how the internet is. It's a network of networks. So it's very important that each network, as it connects with another network, has a point of contact in that other network. So if there's a cybersecurity incident or any other issue or a peering request, one network is able to contact another network. And this is where we get into personal information. So it's our responsibility at APNIC as the Regional Internet Registry to run a database that provides this information. And we call this database the WHOIS. And the WHOIS is a publicly searchable database detailing address usage within the Asia Pacific region. Anyone can go on and search through WHOIS. The results are provided purely for operational purposes. We very tightly control it around it can't be used for commercial purposes or anything like that. But it's very important that it's the authoritative place you can go to find the contact, the technical contact for a network that's operating in your economy or your region or anywhere around that. And so as we allocate resources to those 16,000 different networks, we work very hard with each of the members to make sure that personal information is up to date and is available. And as I say, it's a publicly accessible and searchable database. So when GDPR came along a few years ago, even though we do not operate within the European Union jurisdiction, it was very important for us to be able to look at the publicly available information on each individual who is the corporate contact and make sure that we fulfill the requirements of GDPR when we were aware of it. And I think that's really the key message that we have, that in the process of ensuring the privacy of individuals and their information on the internet, you have an example here of it's fundamentally important that that information is available for other people. If it's not available and I can't contact another network, that's a major technical challenge. So we've got to be able to provide the safeguards that the chair talked about in his opening remarks around personal information, but at the same time not restrict the efficient and secure operation of the internet by blocking contacts between network operators. And that's frankly is a big challenge, because it's not just GDPR, of course. As we move forward, and each economy in the Asia-Pacific region now is developing their own privacy legislation, and each jurisdiction, all 56, over the next few years, we can see moving towards their own national priorities in terms of privacy protection for the individual and privacy regulation. And the case that we bring to each of these economies and each of these discussions, and why I think this forum is particularly useful today, is that there must be recognition that there are communities where access to information on an individual is very important for its operation. And the challenge is, how do we ensure the effective implementation of good legislation to protect a person's privacy, but at the same time allow for the efficient operation of something as fundamental as the internet itself? Because we do require in the WHOIS this need for one network operator to contact another network operator. And as I say, you lay over the GDPR and then the national legislations, and it can become increasingly complex. And we frankly don't have an answer, but we do find it very important that we have a voice, that the technical community that we represent, the network operators, can come to forums like this and have this discussion and say, yes, we understand your priorities in terms of managing personal information and the need to protect it, but we also want you to understand the needs of the technical community in how it wants to operate the internet. So I'll stop there. I look forward to the other discussions and presentations and any questions afterwards. Thank you very much.
Thank you. Thank you, Mr. Dukin. Magent, you share us a lot of WHOIS information, and also I think that's very important to make it effective to protect personal information. And now I want to ask Professor Gao, I want to change your speech later and ask Wolfgang Professor, because he will leave. Okay, so Wolfgang, yours. Okay.
Thank you very much, and thank you also for the invitation. And I think the Cybersecurity Association in China is a big player on the global scale. However, the understanding of cybersecurity has changed over the years. 20 years ago, cybersecurity was seen mainly as a technical issue, you know, how to make the devices and the networks secure. And then the understanding of cybersecurity has changed over the years, you know, with the spread of the internet. And as it was mentioned in the opening speech, now more than 4 billion people are using the internet and 800 million people in China. And this raises another category of cybersecurity issues. You know, my understanding is that you have 3 big areas for where cybersecurity plays a role. The first one is now a question of national security. So, and you know, for whatever reason, the sad reality is now that we see the militarization of cyberspace. The internet and cyberspace is a question now also of war and peace. So there is no definition what a cyber war is. There is no definition what cyber weapons are. But we have seen in the last years, year by year, more and more, that there are cyber attacks which undermine the national security of countries. And this is a big issue. And there are some intergovernmental negotiations, meanwhile, in the United Nations under the First Committee. There are 2 intergovernmental working groups. One is the so-called open-ended working group, and another one is the so-called group of governmental experts, where governments try to find solutions and to define norms for the behavior of states in cyberspace, and also confidence building measures and capacity building measures, because, you know, diplomats and other officials very often, you know, have good skills to negotiate treaties, but they do not know the issue. And that's a big problem, that if negotiators do not understand, you know, what are the technical dimensions of the issues they negotiate, then you have a problem. That's why capacity building is an issue. And you have also a number of activities on the regional level. For instance, the ASEAN countries, the ministers for communication, have adopted a number of norms and confidence building measures how to enhance international security in the region. And you have a number of, let's say, private sector and multi-stakeholder activities. Microsoft was very active in the last couple of years, and they have produced a document called the Tech Accord, which defines some norms for the behavior also of non-state actors. And the Siemens Corporation here in Germany has also created a platform which is called the Charter of Trust, which gives you some guidelines, you know, how to make the cyberspace a more secure place. And I myself, I was a member of a global commission on stability in cyberspace, and just 10 days ago at the Paris Peace Forum, we presented our final report, where we have proposed 8 norms for state and non-state actors. Because, you know, the conclusion of this commission, which was chaired by former politicians, was the foreign minister from Estonia, Madame Kaljurand, the former secretary of the Homeland Security from the United States, Michael Chertoff, and the national security advisor for India, Lata Reddy. These were the 3 chairpersons. And, you know, this former politician said, okay, we have to go beyond traditional negotiations in the UN context. We have to include non-state actors. And we have also to go beyond the 13 and 11 principles which were already adopted by the group of governmental experts in the year 2015. And we have to be more specific if it comes to, for instance, the public core of the internet. And what we have seen, unfortunately, and you know, the ethnic knows certainly a lot of these cases, so that there are growing attacks against the core elements of the internet, against the domain name system, against IP address system, against routing, against servers, root servers. And this is a danger. That means I see it really as a very risky development, because the world is dependent now from the internet. And if it doesn't function, if you hijack a domain and send emails in different directions, or you want to go to a website and it's not reachable anymore because somebody has confused or blocked servers, so this is very dangerous, and there should be an international arrangement to protect the public core of the internet, and this is the main message from our report. There is a second issue with cybersecurity, and this is more criminal behavior. So I think cybercrime is not new. We have, it was called in the 1990s computer crime, but then after September 11, the Council of Europe, together with the United States, said, okay, we need an international treaty on this, and so the Budapest Convention on Cybercrime emerged. So the Budapest Convention defined a number of cases, what can be seen as cybercrime, if you manipulate networks or computers or the so-called hacking, this is seen meanwhile as a crime. The problem with the Budapest Convention was that it was negotiated under a certain pressure to do something after September 11 in the year 2001, and some big countries were not involved in the drafting, like Brazil, India, also China. And insofar, the appetite of these countries to sign and to ratify this convention was rather low, because they said, okay, we have not been part of the drafting. Probably we would have for some articles a different idea. Russia doesn't like Article 32, and there are some other things. And insofar, the Budapest Convention has also only a limited reach. It's a universal document. Japan, Australia, New Zealand are partner of it, but some big countries like China, Russia, India, and Brazil are not members. So just recently, Ghana, an African country, has signed the convention, but it's only around 70 member states. So it's not the 193 member states of the United Nations. This is under discussion in the Third Committee of the General Assembly for a couple of years, and just recently, last week, the Third Committee decided to start another intergovernmental working group to consider or to investigate whether it would be good to have a universal instrument which would become inspired from the Budapest Convention, but would probably go beyond this by including, all 193 member states. So this is the basket of crime. And then we come to the third basket, and this was mainly the subject of your speech, and this is the personal security if it comes to data protection information. By the way, it was this country, Germany, which introduced the first data protection law already in the year 1970. That means nearly 50 years ago. And this came also, with the distribution of computers, that people, became nervous what happens with my personal data if they are in a computer. And, we had a big, also public campaign in the 1970s in Germany, which resulted in the introduction into a new article in the basic law of Germany, in the constitution, which has established the right of informational self-determination. That means this is really a fundamental right. And it says, it's the individual who is owner of the right, and not the government, not the corporations. And it's the duty of the government to protect this personal information. And in 1970 there was no internet. And so then over the years it became clear that this is really a fundamental issue. And in Europe, as you have also mentioned, was always on the forefront. It was not only Germany, a number of other countries also jumped then in the boat. And with the GDPR, we have reached now a rather high level of the protection of personal data, against the misuse both by corporations and by the governments. So that means it's the protection of the individual. I think this is the key message. And it was not the intention, but it's very interesting to see that the GDPR, which is a rather complex mechanism, you know, of a lot of different rules and specifications, has now rocked the boat far beyond Europe. So, as also our colleague from the APNIC said, you know, in Australia, in the US, in Latin America, you know, the GDPR is seen now as a, you know, important instrument. They are checking, you know, which rules are relevant for them. And this has made also clear that we need not only regional instruments, because it's for the GDPR is just for the 28 member states of the European Union, but we need a global instrument. And there is discussion which has started also in the third committee of the General Assembly of the United Nations, and in particular in the Human Rights Council of the United Nations. And there is a special rapporteur, which was, by the way, nominated after the Snowden affair, was a German-Brazilian initiative to establish a special rapporteur for the protection of personal data, for the protection of privacy in the digital age. This is Professor Katanaki, and who is very active and writes reports, analyzes situation in various countries, and he has a number of proposals how to draft a global instrument for data protection and against mass surveillance. So, but the appetite of governments in the Human Rights Council to draft a new international treaty is at the moment not so high, because there are a number of, I would say, delicate issues which are also related to content, where it's difficult to reach international agreement. You know, as the speaker has said this morning, you know, if it comes to content, different countries have a different idea what is good, what is bad content, what is illegal content, what is harmful content. Harmful is not illegal, it's bad content. How to deal with bad content? Should it be blocked? Should it be allowed? And insofar, that's slippery territory, and it's difficult to find a global consensus. And probably we have to learn also to understand other opinions a little bit better. On the one hand, you know, there's one world, one internet, and if you want to avoid a fragmentation of the internet, so you have to have also a higher level of understanding and tolerance. So that's a complicated issue, and insofar it needs more study, more research, more dialogue, more better understanding. And I hope that this workshop can contribute to this ongoing dialogue. What I've heard is that the Cybersecurity Association of China is planning another World Forum next year. So I think to have more forum like the IGF is a good idea. And I personally, you know, I would wish, so I was pushing that Germany becomes the host for an IGF for a couple of years, and I'm very happy that we have the IGF now here in Berlin, and I would be also happy to have the IGF sooner or later in China. So we were in Africa, we were in Indonesia, we were in Latin America, we had meetings in Greece, in Lithuania, in Azerbaijan. China would be a good host for an IGF, and then we can discuss the issues of cybersecurity and data protection in another exciting environment. Thank you very much.
Thank you, Professor. Thank you for your goodwill, and I hope so. in the future, I hope so. And now I want to invite Professor Gao give us a short speech.
Thank you, Chair. So today I will focus, on the different approaches on personal information protection by different countries. Before we discuss the personal information protection, I think we need to understand, first of all, what are the main interests which are at stake. And I would say that there are three main stakeholders. The first one is business, which focus on the profit. So for business, they would want the information to flow freely so that they can make the most money, they can reach more consumers, and so on. So here, that is why you see that a lot of businesses, especially big digital firms from the US, they will want to have a free flow of information. They would want to have their own say in the collection, storage, processing, and transfer of personal data. And second, you have the consumer or the users. For the users, the most important thing is privacy. And they are most concerned with the protection of personal data, avoid possible leakage, and so on. And then last but certainly not least, you have the government. Here, the government has a power. And this power can be used for good purposes like protecting personal information, and it could also be used to control the personal data from the consumers. So in parallel with these three different, the dynamics of the three different interests, that is profit, privacy, and power, we also have three different jurisdictions, the US, EU, and China, with each focusing actually on one of them. For the US, the key is the commercial profit of the business firms. That is why the US has made it a crusade to champion the cause of a free flow of information at the international level, where you see in all of these free trade agreements the US has signed recently, such as TPP, USMCA, the US has been very aggressive in insisting that it should include provisions guarantee free flow of information across the border, and also prohibition of data localization requirements and a forced transfer source code. Now, when it comes to privacy, the US does not have a comprehensive privacy protection framework. Instead, it only has a patchwork of laws and regulations. For example, in the video rental sector, so if you rent a video, if you rent, let's say, some X-rated video, you do not want other people to know that you have rented such video. So the US has a law which says the video renters like Blockbuster cannot release this information to third parties without the consent of the consumers. Similarly, in the US, everyone has a credit card, so when you apply for the credit card, they will want your credit score, and that is also regarded as very sensitive information. That is why in the US, there's another law which says the firms which provide such credit scores cannot release such information, again, without the consent. So for the US, the key is really the sector-specific protection. So in other words, it is regulated as a consumer's right. You only have your personal information or privacy protected for this sector if you are a consumer in a sector. If you see, I never rent a video, or I never apply for a credit card, then unfortunately you do not have the right under these two sectors. And in the US, the agency in charge of privacy enforcement is the Federal Trade Commission, which is supposed to enforce all these laws. And then, but the US also heavily relies on self-enforcement by the firms, rather than aggressive enforcement at the federal level. The EU has a really different approach. For the EU, privacy has become the key in the digital age, with the introduction of laws such as the GDPR, and that is really, as the previous speakers have mentioned, that is really taking over the whole world. It's like every country is now considering something similar to the GDPR. So the GDPR is different from the US approach because the GDPR has elevated privacy as a consumer right to a human right, a fundamental human right. And that is really groundbreaking because if you regulate that as a consumer right, and as I mentioned earlier, if you are not a consumer in a sector, you do not enjoy such a right. But a fundamental human right is different. So long as you are a human being, you always enjoy such a right. So that is a very different approach. And the EU, by doing this, basically gives every EU citizen and resident this fundamental right. Another feature of the GDPR is the idea of extraterritoriality, because Article 45 of the GDPR requires the countries where the information want to be transferred to have to get recognition as providing adequate levels of personal information protection. And so far, the EU, until very recently, until February of last year, there was some internal fight within the EU Commission, because in the EU you have two different DGs, divisions, Director Generals, dealing with trade agreements and privacy protection issues. Trade agreements are negotiated by DG Trade, and privacy protection, that is the GDPR, is regulated by DG Justice. So DG Justice does not want the EU go on and sign all these free trade agreements without adequate protection of the privacy. So they were only able to reach a compromise in February 2018, where they adopted this horizontal language in all future EU agreements, which basically says, first of all, we recognize that there should be free flow of information across the border and so on. But at the same time, we also recognize that the EU's right to regulate on privacy and personal information protection, since like a GDPR, that is non-negotiable. If you want to sign free trade agreement with us, you have to accept the GDPR. And also, most importantly, the EU's right to regulate is not subject to investor-state arbitration. That means that if you are foreign from, and if you come to EU and now the GDPR is introduced, you might be saying, well, this is in violation of the investment agreement. No, you cannot do that, because that is exempted from investor-state arbitration, making sure that the EU's right to regulate is absolute. Now, last but certainly not least, China. For China, the key is cyber sovereignty or cyber security. There is a strong emphasis on security, because President Xi has famously said that there is no national security without cyber security. So as we know, China has a different system whereby there's no absolute free flow of information. Instead, some information are filtered. And China also introduced regulations which requires the local storage of data and also transfer of source code. Now, when it comes to privacy, China did not really introduce any law on privacy until 2009, when in the new tort law, China started to introduce the right of privacy. Actually, a bit ironically, women's privacy was protected ahead of men's privacy in China, because in the 2005 law on women's right protection, women's privacy was explicitly mentioned as a right, but for everyone else, that is the gentlemen in the room, they only had their privacy right protected 4 years later. And if you look at the cybersecurity law of 2017, there have been some argument as to whether or not the privacy right is so absolute that you can only transfer the personal information with the consent of the subject, that is the person, the underlying person. But I doubt that this is the case, because if you look at the laws, you can see that there were other provisions in the same law where actually there are extensive exemptions for the government. For example, Article 42 of the same law says the operators can collect and use the personal information subject to, first of all, the mutual agreement with the user, that is agreement by the user, and second, provisions in the law. So if you look at other laws in China, for example, if you look at the national security law requires explicitly under both Article 11 and Article 77 for all Chinese nationals and organizations to help protect the national security. So if the government says we want to collect this personal information for national security purposes, of course that would be allowed even if the user does not give the consent. Another thing is that Article 42 only says that you cannot transfer personal information to any other person without consent of the subject. It does not say that you cannot transfer any personal information to any other organization or government without personal consent. So the government, if the government want to collect the personal information, it does not need to get the consent of the subject. So this would basically conclude my presentation, but I find the contrast between three different approaches is very interesting. I'm not saying that there is absolutely the best approach. Instead, as you can see, these three different approaches reflect the different traditions, different culture, different legal system of different countries. But of course, they would have different consequences. The US, because of all this freedom accorded to the business firms, led to the prosperity of the sector. In China, because of the strong emphasis on security, and therefore the government has a major role to play, while in the EU, because of the strong emphasis on the privacy of the users, you could argue that is one of the reasons why they do not have many digital firms, especially the big ones, because the GDPR is strictly enforced, actually would make it very hard for firms, especially small and medium-sized firms, to operate. So I think before we start to think which approach to take, we have to first of all understand the rationale of the different approaches and the possible implications from each different approach. Thank you.
Thank you. Thank you, Professor. Thank you, Professor. And I think your topic is very interesting, and I hope that you can have time to do some research about the recent years China's laws making for the privacy protection and data security management. And I think that not only from the national security, but also from the consumer and personal information protection, that we take a lot of actions, not only for the legislation, but also for the regulation. And also not only from the GDPR and for the US measures, as there's a lot of useful sectors, but also there's some limitations also. So we must think that different kind of mechanism must take the suitable framework to make this personal information protection more effective. Thank you. And now I want to invite our remote speaker, Mr. Ajay Datta, give us a speech. He's a founder and CEO of Data Hexagon. And Mr. Ajay, are you here?
Here to speak. I hope you guys can hear me.
I turn it to you. You can make a speech. Okay.
Hello? Can you hear?
Yeah, we can hear you. You can.
So I can't hear you. I am Ajay Datta, sitting right now here in India, and I want to tell you, in India, Supreme Court, which is the top court of India, has decided privacy as a fundamental right of every citizen of India. That's a big deal, because that creates lots of legal framework, lots of liability on the companies, lots of issues which were not there before 2017. This law came in 2017. Actually, I have on a chat box, I have shared the link to everyone, so that it can be shared and read about it in India, what's happening. Right now, while I am talking to you, there is a very big issue going on in our parliament. which is the top place to discuss the constitution, the policies of the country. And there is an issue which is being discussed right now about the spying through WhatsApp on private data. So if you heard the news few days before, WhatsApp was hacked, and a company which is known as NSO Group sold a spy software, and this got embedded into the WhatsApp, and it got into high-profile people of the country to take away the data. What I want to convey here is that the kind of world we are living in right now, you do not know what data is going out of your hand, who is reading the data, in spite of all the law and the framework and everything is in place. How do you really deal with that somebody is sitting in a remote country which even you have not even heard of? How do you take the remedial effect? How do you even know that you are the victim? How do you even know that you are into the situation where your data is no more private, your pictures are no more private, your data itself, what is the profile, is no more private, your phone number is no more private, everything is gone. How do you really protect that information which is there right now? Meaning thereby, this requires a lot more deeper discussion at every level. Why I was invited here to speak about little bit about our platform which we use to protect the privacy of the users, protect the privacy of their profiles in our email platform. We are the probably only company in the world who exchange and implement the permission framework whenever the information is being exchanged within the email also. So the data is encrypted, data is protected by the permission framework, and whatever is being exchanged between two people is always through the permission, not just like that anybody can access anything, even the email administrators can access anything. Doesn't happen that way. Once the data is being given, can be accessed even by the email administrator via the permission framework only. This is the need of an hour. We are sitting where I am able to talk to all of you from India. The technology is allowing to do talks remotely, exchange data remotely, share data, whatever you like to. The laws may be different in between this country and the other country, and you may be exchanging information knowingly or unknowingly, and your data is suddenly public, and everybody may not be aware about all the small terms and conditions and the checkboxes which are ticked on the website while terms and conditions are read and the conditions are agreed up, and you have no choice but to repair that problem. Another problem which we are right now addressing here is how do we really ensure that the data which we say is private is really private, not just for the third party, even for the person who is a custodian of the data. So how do you really ensure that my data, if it is with the government of India, in my Aadhaar card, which is the world's largest identity platform to identify the citizens, and we are billion plus people, how do you ensure that even my administrator who accesses my data do not really have an access to the data and use it against me or make it available to somebody else? How do you really ensure that? How do we really ensure and bring that framework out that really nobody has an access to the data, and this data protection, what are the information related to me, really protected, really ensured, and a secure environment? It is not available to the people who may misuse or who may use it for the time period. So I think with a limited time for 3-4 minutes I was given, I am able to share what I wanted to share. If there are any questions at the end, I would be happy to answer. Thank you very much for the opportunity.
Thank you, Ajay. And you share us very interesting India practice on protect for the personal information. Thank you. And now I want to invite Professor Joanne to give us a speech. Professor, you're welcome.
Well, I won't say that I can deliver a speech that I have 2 minutes. It will be the shortest presentation which I ever delivered. Good thing is that previous speakers listed the major issues. And I would just like to highlight one aspect which is extremely important for understanding of you as a policymakers and academics. There is digital interdependence in the modern world on the level of society and on international level. This was also the title of the UN high-level panel, where I was executive director of the Secretariat. Now, one of the previous speakers made really insightful survey of US, EU, and Chinese data policies. And if I can summarize in a tweet, US focuses on the economy, EU focuses on the human rights, and Chinese focusing on cybersecurity. Now, what is the real problem and challenge that we face is that you cannot easily separate this in silos. As we know, in February, EU had to negotiate trade and human rights internally within the European Union, trade and human rights aspect. What I'm seeing every day in Geneva, where I'm based, is that many countries and the international organization face a problem of dealing with data in silos. You negotiate in trade organization, it is a question of free flow of data, e-commerce, where, by the way, both European Union, China, and US and Russia are part of plurilateral negotiations. But they focus on free flow of data across national borders. Then you move to Human Rights Council and you have privacy discussion. Then you move to standard, and I'm speaking about 3 kilometers of the radius. You then move literally physically, you walk to the International Standardization Organization, you discuss standards. Another half kilometer WHO, you discuss data and health. Another half kilometer to the ITU, you discuss telecommunication infrastructure. Now, what is the real problem for many countries, and I think I would say all countries, is that they access this through the policy silos. One group is discussing in trade. Literally, you have mission in Geneva to the trade, WTO, and to the UN. The other group goes to human rights. The third group goes to technical discussions. And sometimes I have a small collection on confusing conflicts. Country argues for one position in trade, for the other position in human rights, the third position in the telecommunication infrastructure. It is going to be a huge challenge for governments, for civil society, for businesses to reconcile different aspects of the trade of data policy: economic, human rights, cultural, technical, and security. And I would say this is probably, in this really the shortest presentation I have ever made, it is probably the core message. Try to think out of the silos, try to outreach to other communities within your companies, within your governments, international organizations. Try to learn the language of other community, because it is the same issue, data, but viewed through different glasses. Thank you.
Thank you. Thank you, Professor. Professor is executive director of a Diploma Foundation, and in my memory, you set up the first UN's project for the Internet Capacity Building Program. I think that's 50 years ago.
Yeah,
yes,
I lost my hair.
Mm-hmm. Yeah, and in fact, I learned a lot of things in this program. Thank you very much. And since the time's reason, I must say sorry to Dr. Hong, and maybe we have no time to share your ideas. And I think that in the past several years, there's some major development in the Asia-Pacific region, and with regard of the privacy and the security laws, and as the flow of the corresponding information continues to grow, we are expected to see more and more changes to privacy laws in the Asia-Pacific region. And we hope that this workshop can help us all achieve clarity on some questions, and I hope that all the participants from this panel can get you anything you want. And I hope that not only in this workshop, but outside we can continue to discuss about the same things. And thank you for your joining us. Thank you for your participation. Thank you. Okay.
turn the mic on, please? Hi. We're going to start in a few minutes. It's just technical settings here with the remote participation. Yes? Okay. So, hi everyone. Thanks for coming and join us in this panel. I'm really happy in being here and share all the knowledges and also our vision on machine learning and artificial intelligence, especially related to the open data and also related to the digital design. So I will give you a very short and very brief introduction, and then we will move to the floor for our distinguished guests here. So I hope you can also join us afterwards with your question. Machine learning is leading a real data revolution. Everybody is talking about artificial intelligence. Governments are talking about artificial intelligence. Big companies, big IT companies are talking about artificial intelligence. My mom is talking about artificial intelligence. Perhaps in the future, my pets will also talk about artificial intelligence. So it's a hype topic in this day. And of course, data is a fuel for machine learning in the algorithms, and the algorithms are becoming more powerful these days. However, it's important to highlight that data is not equally available and distributed for everybody. Data may be a barrier of entry to ensure the Global South can participate in this new economy. What you are saying is that there might be concentration in data ownership. We argue that data is being extracted from the Global South and access is being monopolized by big players from the north, which is entrenching technology, Global South into a position of consumer, not producer of technology. In this workshop, we discuss how open data principles and web technologies could help to overcome some of the consequences of this data concentration and increase its quality. We also discuss how important it is to bring a humanistic approach in artificial intelligence. So we hope in this workshop to talk about open data, web technologies, and web design for artificial intelligence. So let's move to the floor. I'd like to invite Diogo Cortes to have the floor. And Diogo Cortes is a computer scientist, is also expert in the web designer. He is a researcher on the Web Technology Study Center at NICBR in Brazil, and also he teaches at the Catholic University in São Paulo. You have the floor, Diogo.
Okay, thank you. Can you please add the presentation here? All right. So I'm Diogo Cortes. I work at NICBR in the Web Technology Study Center. And I'm also assistant professor at Pontifical Catholic University of São Paulo. And what I'm going to try to do is to reply those two policy questions that we describe in the workshop, focus more in the design, okay? So first of all, we see that the artificial intelligence is touching every aspect of our life. And we start to see a lot of discussion regarding fairness, regarding transparency, regarding explainability, okay? And for many decades, artificial intelligence was a subject inside like computer science departments or mathematicians, and now we need more than this. We do not just need to build a model and put it in the world. We need to ensure if this model is okay and if it's acceptable by the society. So the first action that we need in a AI project is a diverse and interdisciplinary team. We do not need just computer science, engineers, and mathematicians, but we also need designers. That's an important concern that we bring to this workshop. We also need these people from social science, anthropology, and many areas to make sure that our model works well. And to start, I want to claim that design is much more than interface. Design is important during the whole process of artificial intelligence project. And we need to start to break artificial intelligence down in some parts. There is no such thing as artificial intelligence. What we have now, today, are different models specialized to do specific things. So we can have a speech recognition model that can recognize someone saying Apple, okay? You can have a different model for image classification that can recognize Apple photos. We can also have a natural language process for autocomplete to write the word Apple. But those are different models, completely different, using different techniques, okay? So there is no such thing as artificial intelligence. We have narrow models to solve specific problems. And basically, all those models are trained based on the data, okay? So we need to pay attention also on the data. And when you are talking about the user, we have here two main sections, two main divisions. One is the interface. So you have the user. The user will interact with the interface to input and to get output. And this interface actually will use a model, a machine learning model that could be a speech recognition and so on. And the model is based on data, but we will also need metrics. So in this workshop, I'll briefly try to explain or to discuss how design can be applied, or at least it needs to be applied on those two moments, in the interface and also in the model. So just to start, this is an article published in the Science, the scientific magazine. It's a study showing that our AI system in United States, that was used in the United States hospital, it was discriminating black people when needs to receive special treatment, okay? And it was occurring because the design of this AI system was completely based on spending, financial spending. And if you get the historical data, black people has problem to access this, the health system. So it was a strategy, a design strategy that was not good. A better strategy, a better design strategy, maybe, in this article they argue about this was we don't need financial data in this project. We just need to know how is the health of each patient. It does not matter if it's white or black. So it's one problem that's occurring. So the first thing that we need to take action is regarding data design. We need to pay attention. Okay, oh sure. We need to pay attention that the data is that what fuels the AI, machine learning techniques. So I will show briefly here an example that I give to my students. It's a data set. It's a famous data set that's used in machine learning community to test and verify all the models. It's a data set for Titanic. So you have here a list of data from travelers and who survived and who died at the accident. It's not a true data set, but it's very interesting because it's very useful to train into to set the machine learning algorithms and to do a benchmark. So you have here many, what we call in machine learning features, that's the variable. So you have the name, you have the sex, you have the age, you have the fare, you have the class, you have a lot of information. And to do that, for example, just to understand the importance of the design, I got a simple model, that's the decision tree, one of the most simple methods in machine learning, and I train using three variables, class, age, and the fare, okay? Sorry, it's in Portuguese. And the system, the behavior of the system is one. And when I decided to add a different variable, for example, sex, the system has a completely different behavior. So you see here that the sex is the most important feature in this model. So I bring this example just to show that the problem is not just on the data. The problem is just in the decisions that we make to use this data, because in this example, the data was the same, the data set was the same, and the model was the same, decision tree. But my decision to use one variable instead of the other, the system's behavior is different. Okay, that's the same thing that happened in the article published by Science. And we also need to address a question that we need additional data.
Could you conclude, please?
Yeah, we need additional data. This is an example of machine learning image recognition. And for example, those three first here, images, the system can recognize as a ceremony, a wedding, a marriage, okay? But the last one not. And that happens because the system does not have enough data about local cultures, okay? So we need to, in some way, try to get it happen. So there are some initiatives like crowdsourcing initiatives. Google has the crowdsource app that you can take photos, upload photos. It's a design strategy to get it done, okay? And just to conclude, we also need to give users, and this is an important design technique that I think that Eloisa will tell more, is also give, in the interface, give user more control of the data and of the algorithm. Here's an example, a simple example. In Brazil, in Portuguese, if you translate doctor, it translates to medical, that's the male doctor. And if you use nurse, Google translates to enfermeira, that's the female nurse, okay? So it's based on the data, on the example, but we can fix this on the interface also. So that's the fix that Google has done. Now, if you translate nurse, they will give you two options, and the user can get what he wants, okay?
Please end.
Okay, so that I have to do. Okay, thank you and sorry. Eloisa.
Okay, thank you very much, Diogo. I'm sorry of being the clock man, but it's part of my nature, so I have to do that. So let's move to Eloisa Candelo. Eloisa is a researcher on IBM Research Lab in Brazil. So please bring it and share with us your vision on design for artificial intelligence. Go ahead.
Oh, sorry, I think the presentation is not here. Let's see. Presentation is not changing, sorry. Anyway, so I'm Eloisa Candelo. I'm from IBM Research Brazil. My first degree was in design and my PhD was in computer science here in Europe, in England, University of Brighton. And I'm going to talk a little bit about our projects. So actually, like Diogo said, we have a multidisciplinary group. So we have people from computer science, we have machine learning experts, we have multi-agent experts, we have people that working with NLP as well. And I'm in the last part here, the last area that is machine teaching. So we are worried now about the interfaces, not actually only the interfaces that the users will use, but actually the interfaces for people that train the machines. The interfaces that people that are not computer scientists, are not programmers, and how they can train the machines. So this is the kind of studies that we are doing as well. Here we have several projects that we are working with conversational systems in the last 3-4 years. So we have the first one there that you have the faces is for microcredit people that they have their micro business. And we did a project with them. We did field studies as well to understand from the northeast of Brazil. We have a financial advisor, that's that green one, that's a chat, and people, they can talk to different chatbots, and each chatbot represents one investment. It's for financial education. And the other two that are for public spaces, I'm going to explain a little bit more. So, this one, it's a multi-bot platform behind. So it's the same platform as the financial advisor that I told you before. And in this platform, we have 3 chatbots. So we have 3 chatbots that they are characters from a book. It's a famous book in Brazil from Machado de Assis. Actually, the book, the plot is about a love triangle. So you have the husband, the wife, and the best friend, and the husband is very jealous. But the author of the book does not answer if the wife had an affair or not. And actually, everybody in Brazil has at least one question to ask to those characters. It was during 2 months in an exhibition space, and we studied this to understand how people, they act and interact with chatbots in public space, and which kind of features we should consider in the design of systems and machines in public space. So I'm going to show a video. So this is a guide from the museum, and he is explaining how to use it. It's Santiago because of the surname of the characters. So they add their name.
Já digitei meu nome aqui. E veja só como funciona a obra. Nós temos aqui as 3 opções, o Escobar, a Capitu e o Bentinho. Então eu preciso fazer uma pergunta e direcionar para um dos personagens. A pergunta mais intrigante do livro.
The heads represent the characters on the table.
Vamos lá ver?
So did you betray her? You betray him? and then you have a projector as well, and sentiment analysis for each phrase, so the cups are colored according to the sentiment of the chatbot. So she's very mad, and of course she said she didn't do anything, and it's like the husband does not have any reason to be worried about. But anyway, so we studied that to understand how visitors engage with chatbots in public spaces and what are the effects of the audience. So one thing that we noticed is that if people, they are observed by other people, they act differently when they are interacting with those machines. So what we saw was people that were observed by acquaintances, like, for example, family and friends, and were together, they had a different kind of interaction than the people that they were being observed by strangers, or in a queue, waiting to interact with the exhibition, or around the table, around the table in front of them. So what we saw was that people that were observed by strangers, they felt more connected with the chatbots, and they asked more questions as well. And we had something about gender. So one challenge of chatbots and machines is that people, they think that they are like oracles. You can ask about football, we can ask about the weather, and you can ask about anything. And people, they don't keep the scope of the system. So they don't ask about what actually the system knows. So what we saw that males and females, they behave differently. So we saw that males, usually they ask 50% more questions out of scope than women in that context. And we saw that when they were observed by strangers, they ask less out of scope questions. What I mean about out of scope here is like questions that are not related to the book. And we saw as well, thinking about the public space, that users observed by family and friends, they continue engaging, and they ask more questions, and users that were addressed by their name, that they could see their name on the table, they also engaged more. But if you have the two variables, like people with family and friends, and the people that see at least one name on the table, they don't engage so often, because the machine has to know that you have more people interacting in that space and not just one person, so they don't engage more.
2 minutes.
Okay.
Luisa.
So the last one that I'm going to show is like, actually is a kind of challenge, because we are going to talk about AI to children in 30 minutes in a museum space. And how can you teach children about AI? So this is a project for children 9 to 14 years old. We'll be in a museum next year. And the idea is to talk about AI and what is the minimal understanding that children can have about that. And how can we question the black box nature of many AI systems. So we did an exhibition as well, and the idea is that you have like Jeopardy, but instead of having 2 humans and 1 machine, you have 3 machines. So those heads represent the machines, actually. And we have 3 stations where children, they will be in groups teaching those machines. We have a prototype now in the lab, and the idea is what? Okay, you can give all the information to the machines, you can give a spreadsheet, and you can give a database, but the big challenge of machines today is to understand humans. So children, they will teach how humans talk. They will teach examples of human questions to the machines. So here you have an answer, like who is Charles Darwin? And they are going to add questions to the system to train the model. So the idea is like you have, for example, 38% of confidence. Children, they will see that, and later you teach the bot, and you are going to have 95% of confidence, for example. And we are doing tests with children. Yes, so the idea is AI systems use knowledge acquired from human beings. AI systems do not know everything and make mistakes, and the AI systems are corrected and improved by human beings. We used several design methods during, I'm not going to explain all that, don't worry. We use several design methods in the process of those projects. We have other projects as well. I can talk more about that later. And that's it. Thank you so much.
Thank you, Eloisa. Thanks very much. So now you're going to have a remote participation, Jamie Boyd. Jamie Boyd is the Director of Open Government at Treasury Board of Canada. And we thank her to join us because I know she's back in the time, so probably it's early in the morning in Canada, so thanks very much to join us. So you have the floor, please Jamie.
Thank you very much. Good morning, everybody. My name is Jamie Boyd. The description of my position is actually slightly out of date. I am now the Chief Digital Officer of the Government of British Columbia, which is the westernmost province of Canada. About 5 million inhabitants. It's a beautiful spot. I hope that you all come visit at some point. I'd like to share a few perspectives today on the topic of AI and open data. And I think that one of the things that I bring that is a little bit unusual in the public sector is experience in managing an open data portal. For the last 3 years, my team was responsible for the management of open.canada.ca, which is the Government of Canada's open data portal. And we took a number of AI projects to production. The Government of Canada invested quite heavily in the idea of building out ethical approaches to AI. And so we felt that in the interest of embracing ourselves as a learning organization, it made eminent sense to be shipping products. So I'd like to share with you a few experiences with regards to building out both open data and AI practices, and some of the lessons that we learned along the way around the great sense that it makes to be leveraging open data for AI and vice versa. I hope that you're able to see the deck that I've prepared, but if not, well, I'll try to be particularly descriptive in my words. So the first thing that I do want to do, just recognizing that there is a bit of a diverse audience, is a little bit of level setting around the perspective that many of us bring in governments. And that is very much one of disruption. The world has changed. Compute has never been faster or cheaper. And with that, governments are changing. The imperative of being porous to innovation has never been so great. So governments like my own, at the subnational level, at the national level, are fairly aggressively leaning into this idea of digital government, which is, of course, a government that uses modern technology as well as the culture and practices of the modern age to deliver great services that are deserving of citizens' trust. It's somewhat important, I think, in the context of talking about adoption of AI, to recognize that we are grappling with a fairly significant misalignment in citizen expectations. We are well aware of this, and we see it manifest in the data around credibility and whatnot. People around the world have never been so polarized. Their level of trust in public sector institutions has rarely been so low. And this makes sense in the digital age, right? I'm not saying it's a good thing by any means, don't get me wrong, but we have citizens who are able to click and from the palm of their hands, skip the dishes, hail an Uber, and we have bricks and mortar, waterfall-based processes built around citizen delivery, often in the public sector. These misalignments don't make a huge amount of sense. And if you're following on the deck, I'm now on slide 5. What we do then is we look at this misalignment and how it represents itself in the views of our citizens. And so I'm showing you some polling data from Canada, where you see that 60% of Canadians feel that laws and government policies are not keeping pace with changes in technology. So in that context, there are a few things that we do need to somewhat urgently do, in my view, in an effort to more effectively leverage the opportunities of both AI and open data. And I want to speak a little bit about that. So if you go on to slide 7, AI in the public sector can very much help us in delivering sound services to our citizens. And that's the true north of why we exist in the public sector, right? So the sorts of things that effective use of AI can do is it can improve service delivery. We just heard from Luciana a wonderful story about chatbots. We can also support our decision-making abilities, so we can automate a lot of the triage. I'm thinking of immediate applications around fraud detection, for example. We can support ourselves with advanced analytics, so our ability to predict outcomes, intelligence gathering, and then, of course, internal processes. And I'm going to speak to just a couple of examples to try to make this as concrete as possible. If you go on to slide 8, you'll see these are not theoretical ideas. These are things that are actively in production in our governments. So I want to make it clear that when we talk about ethical approaches to AI, this is not a hypothetical future. And these are just, a random smattering of examples that I'm personally familiar with and have been involved with, right? And so we're talking about managing our bus routes. So that's the TransLink fleet management. We're looking at predictive analytics around bus departures, natural language processing to help identify technical risks in our regulatory process, interactive court services, our ability to triage bankruptcy cases when they come into the national regulatory system, our ability to identify regulatory infractions for toys, and these are fascinating case studies, often using content that's put voluntarily by citizens online. And so we're able to triage that content much more effectively using automation. I'll give you a very specific example that I was personally involved with, and it was from this May. We within the Government of Canada, we're responsible for generating a lot of the citizen engagement around open government. The idea, of course, behind open government being around transparency, accountability, and citizen engagement. So if you go to slide 9, you'll see just a screenshot from one of the tools that we ended up building in collaboration with OpenText, which is a Canadian software company using a tool called Magellan. And what this did was it did real-time sentiment analysis of public content that was made available through social media by participants in a major event that we did. And so this kind of analysis is absolute gold for us in the public sector, right? Previously, when you wanted to know what people were thinking, what they were saying, we would go out and we would do surveys, right? And so now with the advance of AI, we are able to look at public content and have real-time analytics. And we're able to take a relatively nuanced approach, recognizing the limitations of these things. Like not everybody is hanging out on Twitter, and that is in itself a bit of an echo chamber. But we are, if you look at slide 10, you'll see that our ability to triage on the basis of the semantics that we're setting up is somewhat, it's certainly improving. We can extrapolate from this very sort of select example to broader reflections on how we can apply AI to open data. When we look at data sources that are based on open data, we have incredible availability and replicability, which is really important when we talk about the ethics of AI, right? In the public sector, we have the imperative of explainability. And within the Canadian context, we've chosen to take a fairly nuanced approach. The imperative to us as public officials to explain the functionality of an algorithm that we use to, for example, figure out which camping site you're going to be assigned when you go into our national park system. That is a lower burden of explainability and responsibility than the burden associated with using an algorithm to recommend a migratory status, for example. Right? And so taking that sort of triaged approach and nuanced approach is critical. But across the board, open data seems to be a powerful enabler for things like explainability. A second advantage of focusing on the open data space is for training purposes. We're looking at data here that is already relatively high quality in terms of data standards. Certainly within the Canadian context, we were imposing very high standards for interoperability, for example. And so having a clean data source that is interoperable across national borders is presumably a huge advantage, and that certainly is the case that we experienced. And finally, it's safe data, right? So especially at the subnational level in my current role, we manage a huge amount of fairly intimate data. I'm talking health records, education records. These are the sorts of things that you really do want to manage with a great deal of care. Open data only includes data that has already been rigorously reviewed for privacy and security. So there are lots of advantages in terms of the open data space. If you go on to slide 11, I think it's well worth thinking about how we behave in the public sector when we're looking to apply AI to our processes, and particularly leveraging the opportunities of open data. And I do want to just very briefly, in the interest of time, share with you three things that I think can support a truly humanistic approach to the application of AI in the public sector. The first is what I refer to as hygiene. We need to be courageous in shipping code early and often. We are paid by the taxpayer. It is an imperative that we provide value repeatedly, quickly. But we also have to impose on ourselves the rigor, the discipline, the culture, the governance to be able to be successful in our use of these tools. In my experience, there are three sort of categories of hygiene that are conducive to good outcomes. The first is the obsession with users, really making sure that we test our services out with real people. Secondly, being agile in everything we do, not just in shipping software, but embracing the discipline of agility and testing, iterating. And finally, being open. Yes, open data is a critical enabler, but being open in everything that we do, embracing open source code, for example, embracing transparency, building across sectors, ensuring that we have advisory committees and people scrutinizing our algorithms that are as diverse as our populations, that's critical. Slide 12, a second big category of opportunities is around building our algorithms out, embedding citizen views into the design. Right. And so on slide 12, you see the results of a survey that was done in Canada through Ipsos in 2018. And you'll see that there's a fairly clear trend here. The cultural acceptance for the use of AI really does vary given the nature of that algorithm, right? So there's a high degree of acceptance when the algorithm is supporting decision making. So you'll see the sort of top ones. And you see the level of support decreasing fairly dramatically as we get to algorithms that can have a direct impact on people's welfare and their livelihood and whatnot. So it's sort of an intimacy question. So we do have to be very, very thoughtful about the views of our citizens and design our use of algorithms on the basis of citizen preferences, in my view. And the third big category around sort of actions for humanistic approaches to AI in the public sector, in my view, are around trust and ethics. So on slide 13, you'll see I've put a screenshot of our ID card. And this is somewhat significant because British Columbia, my government, was the first government in North America to provide a unified ID card based on health and driver's licensing. And this is, I think, an important kind of behavior, and it's a signal more than anything else, because it, excuse me, it's a clear investment in building out trust. The backbone for collaboration in the digital age is trust. And we need to be building out mechanisms and systematic approaches to ensuring that the people we are collaborating with in the digital age are who they say they are. So looking at using emerging technology, so distributed ledgers and whatnot, to provide that sort of context of trust and building out ethics on top of that would seem to be absolutely critical. So last slide, please feel free to follow our work. We use the hashtag DigitalBC. And there are tremendous opportunities around the use of open data for scalability, availability, replicability, and of course, the safety and assurance that we can provide our citizens when it comes to the ethical use of AI. So I'll pause there and thank you very much for accommodating my remote participation. I'm sort of at that strange time where it's 2:22 a.m., so I'm not quite sure if I'm supposed to be going with the wine or the coffee at this point. So thank you for bearing with me on this.
Okay. Thank you very much.
Jamie Boyd, for sharing your vision on open data, open government, and the approach to artificial intelligence. So if you are in Vancouver now, it's time to go to bed. So have a nice step. Okay, so let's move quickly to Krzysztof Izdebski, and he is a lawyer, activist from Poland, and he works for, and he's also the director of Ipensk Foundation, more or less, yeah, like that. So please, it's time to, you have the floor to share your vision about artificial intelligence and also humanistic design.
Okay, okay, it's on. I'll be very brief because I see we're running out of time. So basically what I want to concentrate it, maybe taking something that Jamie already mentioned, is how you design the algorithms or AI, artificial intelligence solutions within the government in the context of the citizen-state relations. We did a report in several countries in Central and Eastern Europe, and what we have found out is basically that there's like different levels of lack of transparency, and that is a main problem which is connected with the general issue that the citizens have a lack of trust in politicians or public officials, unfortunately for different reasons. But there is this magical belief from the side of the government sometimes that we as citizens, we would believe machines created by politicians more easily, which is a quite opposite thing, because when we were talking with the people, when we were doing the report, when you have to deal with any case that concerns your life, your situation, and the government is responsible for this, you are kind of having this position of being aware of getting into the contact with administration because you're not sure about the result. Still, if the machine is deciding, because this is what you understand, the machine is deciding on you, you feel that you don't have a place to refer to, that you are actually talking with someone who has no human instinct. And I think this is always very important in terms of having the direct contact with the public officials. So I think this is something that, while at least in the countries we did the report, is completely underestimating. There's no human-centered design. There's no will of engaging citizens or any other groups that are impacted by automated decision making in the process of actual design. Not because they are experts in the fields, of course they not, but giving the possibility of this feeling of ownership and understanding why this solution is not designed to harm them, but to support them in their lives. One of the examples that we have is the systems of allocation of judges to the specific court cases. And this is a very interesting example because although it directly impacts citizens, but it builds also the mistrust between judges themselves. The system was only tested in 2 courts before it was really introduced. The effects of the test, the information of the test, were never really revealed to the judges or to the to the broader public. The judges cannot compare the data with what other judges got, so meaning I'm not really sure whether my 10 cases is less or more than my colleague have. And especially in the context of discussion on independence of judiciary or this like general mistrust to the government, these are the things that increase the problem within the trust to public administration. And although we haven't really in the terms of transparency, any discussion of using the open data, not only in the terms of the open data standards are being easy to being reusable, etc., But first of all, one of the standards that we have in open data, which is metadata. So you describe what kind of a data you're really using. So you can, from that, if you're not the specialist, you can understand more how the system was created. So we don't have this, and I'm not want to sounds like I'm blaming the governments for this. I think this is something that is still too fresh for them to understand how it's important, because what we, especially having this transparency approach, see is public officials, they don't understand how the AI or algorithm works as well. But for citizens, and this is something that is crucial, what also we saw in the interviews we had with the people, that the person would not contact the company that created an algorithm. The citizen will contact the public official, because this is a natural thing. But the public officials are not prepared for that. From the very beginning, I mean, this is a whole discussion, we don't have a time for that, how to procure machine learning or automated decision making tools in the first place. So I think the whole discussion about the human-centered design should also involve not only the groups of citizens, but also public officials, which will actually be using or be responsible for the usage. And the problems when they are occur, and the problems are occurring, of course, the public officials should be prepared at least to give this like first post of explanation of what went wrong, what are the possible solutions to the problem. Because again, one of the cases we had, it was an algorithm that allocated the children to the kindergartens, and it was like completely wrong. And imagine that if like you want to send your kid to the kindergarten and something is wrong and you're not really sure if it's like in the kindergarten or it's not in the kindergarten or it's like in the good age group or not. This is not a lot of things in the world that you are much worried about your own kid. So you don't care about that the trade secrets, the company knows how to do it, or like you have to trust because this is a machine and this is a random system. You have to remember about this human factor and build competencies around public sector.
1 more minute. You finish?
Yes.
Oh, great. Thank you. Yeah. Okay. Thank you very much, Christoph. No, you are the only one that here in one time. So now we have only 5 minutes to conclude. So I move the floor to Luis Aranda. Luis Aranda is an engineer and economist, and he works as a policy analyst for OECD. So.
Okay, well, I'm very honored to be in this panel, surrounded by such talented colleagues. It's been very interesting so far. So what I'm going to try to do today, I'm going to try to briefly, we don't have much time, so I'm going to go very quickly, and I'm going to present what we at the OECD have done in the realm of artificial intelligence, and highlight in particular the humanistic approach that we've taken so far. So many of you have probably, I'm going to start from the end, and then I'm going to move my way backwards. You've probably heard about the OECD AI principles already, probably several times this week. So you may ask yourself, what are these principles? You know, what's the whole buzz all about? Well, very simply, and as Jessica Cousins put it in her article in The Hill, 1 week after the principles were launched, she said that the OECD AI principles are the world's first intergovernmental policy guidelines in AI. So what does this mean? Well, we have a lot of other principles going around in the world, other organizations coming up with principles, ethical guidelines, etc. But so far, the OECD AI principles have been the only ones adopted by governments. So now you may say, okay, it's the governments from the OECD countries, so the rich country club, as some people may call it. Well, that's not completely true. It is true. In May this year, the OECD countries adopted them. along with 6 other countries, 5 of them from Latin America, including Brazil and Argentina. But then in June, something very successful happened for these principles, because they were, the G20 came up in Japan with their own set of AI principles, the G20 AI principles. And if you look at them and you compare them with the OECD principles, word by word, they're the same. So this is important, because what you see in the map, it's probably more than 90% of AI development in the world. So working my way backwards a little bit, I'm not going to go through this slide. I'm just going to mention the AI expert group that we formed to write these principles. And I'm going to mention this because, as I understand, some countries are trying to come up with their own set of AI principles, including Brazil. So I was talking to Diogo and Wagner yesterday. And I think the key success factor for these principles was the multi-stakeholder approach that we took. We had 52 experts. It was not OECD staff drafting the principles. It was the experts from all walks of life, including academic, private sector, labor unions, civil society. And this is what made us reach consensus with the principles. Now, I try to put them in one slide, so if you want to take a picture, this is the right time. It's, we have 5 values-based principles and 5 recommendations for policymakers. As you can see, we start with inclusive growth and sustainable development, all the way to accountability for AI actors. And in the recommendations, well, we try to make some suggestions for governments to move forward in AI. I'm not going to go through them in view of the time. And I'm just going to present to you a couple of clippings that relate to the topics of the panel today. So for instance, human-centered AI. You have principle 1.1 and 1.2 about advancing inclusion of underrepresented populations, human-centered values and fairness, for instance. Now, this is the movie trailer. It's not the spoiler. So if you want to watch the whole movie, read the principles. It's 5 pages. It's a little bit more than 140 characters, but we'll be okay, I think. If we talk about data, we also mentioned that along the principles, as we encourage governments to invest and encourage private investment in open data sets, for instance, and data trust. So what's next for us? We want to move from words to action at the OECD. We want to move from principles to practice. And so we're going to launch the OECD.ai Observatory in February 2020. And we're basically just following up on the recommendation to try to monitor the implementation of the principles by countries. Okay, and to convince you that we're taking a humanistic approach, we've included the Vitruvian Man in the logo. I'm not going to go through this. We're going to show live data points, like, for instance, AI-related news as they happen in the world. You can see my geographical location in all languages just popping up in the map. And also, like, another thing that we're going to show, it's AI research by country, how they have advanced in time. Okay, you can see it's going to be, this is Gapminder style. It's five-dimensional chart. And just to wrap it up, I was walking the other night along the Berlin Wall, and I saw this painting, and it really caught my attention. It says, "Get human," you know. And being Mexican, I know there's nothing human about walls. Yet we keep building them. So let AI not become the new wall that divides our societies between the rich and the poor, the developed and the developing, the haves and the have-nots. The time to act is now, and it's good that we're having these discussions here. Thank you.
Okay, you made it, Luis. Thank you very much for your sharing. And before finishing, I want to thank a lot for Amanda for the support she gave us. And also I want to thank to Natalia. She is the rapporteur for this whole meeting. So you are the memory of this meeting. So thank you very much. And we run out of time. So thank you very much for your presence here. And we are leaving the floor. Again, thank you for the sharing that you could have with all the panelists here. Okay, bye-bye.
have another email address. Can you check your spam? Maybe it's on your phones. Yes, I think it's. Yes. This is not mine. Yeah, okay. So in terms of sequence, yes, it's this one. Yes. So just 3 slides. So we are going to take a mic, and then we go here. We take a mic and then we go there, or what?
No, I think you can use it.
You use this one, and I follow. Okay. Can you do the next slides?
Normally the moderator, you're the moderator, right? A gentleman is a moderator. Yeah. No, I understand. I thought she was the moderator. I said, the moderator normally always close to you. They're supposed to close the door. They have somebody. One chair is missing.
No, I think we have all the speakers here.
Yeah, we all.
There is also wisdom is here.
Yeah.
Oh, wisdom is here.
I think everyone is here, right?
Maybe you can see.
Hi, good morning.
Hi everyone. Welcome to our workshop. As you can see, this session about enhancing partnership on big data for SDGs. So we have quite a few panelists here since we are going talking about the crucial issue.
Hold on.
We need a mic, I think.
Wer soll ich das denn wissen, ey?
Thank you very much. Okay. It's on. Okay. Thank you. So, in this session, we are going to talk about the crucial issue about the big data supporting the implementing of SDG, Sustainable Development Goals, as you may know. So, there are a lot of data concentration for the kinds of use which can contribute to the advancement and also the development of human life and also society kinds of aspect. So we do already realize the importance, significance of data and its contribution, how to refine, how to make most of use data to improve our life. So we are thinking about methodology or partnership, how to build this kind of partnership to improve the connection between the multi-stakeholder, different power and the different driving force. So today, we are talking about the policy, legal, and also technical issue which closely related to big data, which contributed to the implementation of SDG. So we invite the speaker from different fields, from different continental as well. So sorry, I'm gonna show you very quick about our agenda. So this session is organized by CAST, Chinese Science and Technology Association, which civil society from China. And the CAST has been actively engaged in the promotion of open data and community activity over China and overseas. So actually we have been successfully held series of workshops in IGF and other platform, different forum with the joint effort from international community. So today we are very pleased to invite speakers from the different stakeholder like private sector, academic community, and also government. So I would like to give you a very brief introduction about the speaker. Then our speaker are invited to deliver their viewpoints about the issue I mentioned, and followed by a short discussion. Then we have a current remark about our Big Data for SDG workshop. So the speaker are Professor Liu Chuang from China. She is the Secretary General of Big Data Working Group of Geographic Society of China, also Editor-in-Chief of Global Change Research Data Publishing and Repository. And also we have Dr. Andreas Bass. She is the Vice Chair of NGO Committee on Sustainable Development from New York. And Professor Ricardo Israel Robles from Mexico, and Dr. Wisdom Donker, President and CEO, Africa Open Data and Internet Research Foundation. Professor Cherif Diallo, University of Gothenburg, Senegal, and he's the head of ICT Department for Science and Technology Faculty, and the former National ICT Director of Senegal. And we also have Dr. Horst Kermer. He's from Committee of Data and the International Council for Science and Technology. Also, he is the Secretary General of CODATA Germany. And I am Zhou Xiang from the Chinese Chem Science. I'm also the member of the Coordination Board of Asia and Oceania GEO, which I'm going to talk about the regional cooperation on big data in support of implementing SDGs. So that is the brief introduction of our speaker. Then I would like to invite our first speaker, Professor Liu Chuang, to deliver his presentation, please.
Thank you. I'm so glad to have this opportunity to focus on my topic on the big data solution from governance to practices for SDGs.
Sorry, Professor Liu, can I just use this controller? I'm gonna play the presentation here for you.
Oh my goodness.
Please just wait a few seconds.
This one? Doesn't work? Where's? Doesn't work?
Yes, please.
Is there? No. No?
Yes, it is.
Is there? No. Oh, good. Yeah. Big data solutions from governance to practices for SDGs. Okay, yeah. So we, 5 years ago, we have an international workshop. We make data sharing principles in Nairobi. So we call this as Nairobi data sharing principles. So in several organizations assign these principles, 10 principles, focus on the openness. So quality, timely, open, and free, and open and standard, operational, and so on. So all these 10 principles, so is focused on the make data openly available for all. So not only for the local institute, for the national, but for the international. So this is the basic principles. How to make this principle to be action? So we work with several organizations, so make this as an example. And based on this example, we developed the guideline. So this is we focus on the global change, research data publishing and sharing. So this is the main part of the website. There are data set publishing and data paper publishing also. So this is the journal. So we make peer review all the data set and data paper, data descriptions, so all peer reviewed. Make the data quality control. So then we publish the data and make the data networking. So we call this as acting locally, networking globally. So we make all the data as DOI, give the digital object identifier. Then we link to the World Data System, and then link to the DCI, Data Citation Index. And we work also with the info developing countries. So this is the, right now there are, also we work with the journals. There are 60 journals join this partner, including in China, USA, and Japan. So this is the users. So during the 5 years, 97 countries users download the data. So you can see almost all the world, except in the African, in West African. So next time, so you join this, definitely to user can to share the data. So this is a benefit. And then I think that's many people like this. So this is the example. This really we want to know. So this got last year got the VCS prize. When this year I have this, there are some material there. This is very it's a new data set. The global coastline and islands. So this data set you can see answer these questions: how many islands, how large land areas, and how long of the shoreline in the world. All vector data in meters resolution based on the Google Earth images. So there are all this, so I said everybody can free download. I think this is not only, so we can hypothesis comes and go, but the data stay forever, and the quality, timely data. So I think this is an example. So now this last month, the CODATA International Committee on Data for Science and Technology have a meeting in China, in Beijing. So jointly developed the Beijing Declaration on Research Data. And in this declaration, the side, in the more and more research discoveries will depend on driven by the data. So the data more crucial. So in this case, so we will emphasize, we call all of you to jointly, to have to join as a partnership for enhancing the open data and the knowledge environment in the world. Thank you.
Thank you, Professor Liu. Actually, I have an unupdated name list of panelists. My fault to forget to introduce one beautiful lady as our panelist, Mrs. Janice Hafdir, from Ministry of Education, Tunisia. So she will going to talk about the capacity building and education later. Welcome. So our second speaker is, too much work for me.
Beth?
Okay, other beautiful lady. And Andreas Bass, you have the floor to speak.
Hi, everyone, and I'm delighted to be here with you today. That's the way we can talk about the SDGs. Most of the time when people heard about the SDGs, they don't understand what it means, especially if you don't work inside the UN or you don't have nothing to do with an organization working with the UN, you don't have no understanding. The SDGs, the goals, put by the United Nations to all the government first. It was distributed to the government. They said this is a goal by 2030, how we going to move the planet or move the world. And as a stakeholder and NGO at the same time, I try to see how inside and outside can work together. I'm a climate reality leader, a mentor. I work closely with former Vice President Al Gore on the climate issue and awareness. And inside the UN, I work as a Vice Chair of Committee and Sustainable Development. I work closely with all stakeholders as the way we can debunk what the SDG mean. The 2030 Sustainable Development Agenda, if you work with the UN, you understand. If you don't, the core principle of the agenda is universality, leaving no one behind, interconnection and vulnerability, and inclusiveness and multi-stakeholder partnership. And how that's going to happen if you don't know what it means? And the core principle of my organization try to make sure people understand what it is. And the agenda, we are committed for all countries, irrespective of the income levels. Because sometimes we make agenda out or the UN put the rules without understand. I don't think the agenda can work for the same way you work in Africa and the Caribbean, the United States or Europe, because we have a different income, we have different form of life. The core principle, leaving no one behind. We want everyone to be inside. I always say, you don't understand the way I work because you never be in my shoes. How we can together understand even the single mother, the student, the person working with municipality, the person working in the government, how we can together work into the same idea to go forward. That's the way the SDG can be. We have to get everything to be correct. And most of the time when we go to the annual report and data, what the civil society said and what the government reports say, they never match. Most of the time, they always got a discrepancy. How stakeholder, the government, the people, civil society, student, and the one who got to stay, how we can, even individual, but how collectively we can understand the SDGs. I always struggle inside the UN when they're talking about inclusiveness. and sometimes I feel I'm not included. And I don't think it's the only me. I think they have a lot of people, when they go to the website, or when they listen to the UNGA, when they listen to a lot of agenda, and they ask, where did I fit in? Multi-stakeholder partnership. This is the one I really love about all the 17 goals. We need partnership. We need everyone. Student, sometimes they say the student, yes, they understand. Because the era of some era, now the kids, the youth are more active in certain aspects of the society. They want to be involved. I remember when my age, I couldn't ask my parents certain questions. Now the kids is so open, and it's up to us to give them the answer and what type of answer we're going to give them. In our organization, we put all the 17 with 5 Ps. If you can remember to work with the 5 Ps, you will cover the SDGs. It's people, planet, partnership, peace, and prosperity. These all conclude the 17 goals. If you do not retain anything about what I said today, just remember, you need to be aligned with those 5 Ps: people, planet, partnership, peace, and prosperity. Including partnership and peace is a win-win situation for all of us. Because with respect with respect my right and your right, respect my need and your need, I think that's the way the SDG can probably reach the goal in 2030. Because when you put all the goals together, sometimes you say, it's not possible. Because they still have people, part of the world, who cannot eat. They still have problem with health. They still have gender equality. We're still using so much food and wasting so much food by the time a lot of people cannot eat. You got the planet, we call it emergency, and some people still doesn't understand it. How we can make that 17 goals possible for 2030? Partnership. We have to revitalize the global partnership for sustainable development. The government cannot do it by itself. We cannot do it by ourselves. And the kids can protest all they want. But if we do not use the correct data, also change our policy, our mindset towards certain goal, I don't think it will be possible. What is matters? We need everyone to come together. Government, civil society, science, academia, and the private sector to achieve the sustainable development goal. All the resources, they are online, but a lot of people doesn't think it is that important to go through them. They have a lot of clip video the UN put out each time to see how people can understand it better, how outside of the UN, for people who doesn't work inside the UN, can understand it. That's the way we can do it. Every year, they have a progress report, track data about the SDG in every country, sent to the UNGA. The UNGA is the assembly they do at the United Nations in New York, where all the government come in to give the data and what the progress the country have been doing. Most of the time, the civil society is not included on it. I encourage, if you work for the civil society, reach your local government and see how you can put the data you have, the actual fact you have, that's the way they can put it in their data. When they send it to the UN, it can be more accurate. The implementation, the SDG, is all of us. Who are the SDGs goal? We are. Because without people, they do not have SDGs. If we all of us think as individual and as collectively who the SDG was created for, who can apply it, who can implement it, I think we can move a better direction, and also we can have a better data. Thank you.
Thank you, Andres. So we still have a few speakers behind. We are a bit behind the schedule. May I remind our speaker to keep your speech in 80 minutes. If you can save time, I will be greatly appreciated. Thanks. So next speaker is Ricardo from Mexico. Please.
Take the remote. Thank you. Thank you. Thank you very much. My name is Ricardo. I am from Mexico. I'm from the university called Escuela Bancaria y Comercial. Thanks for the invitation. We talk about the legal frameworks from data exchange and in deep cooperation at regional and global levels must be developed. And I try to answer the question. Okay, how is this work? Okay, whatever. What the political consideration will legal frameworks be developed for the rational development and the use of big data for various purposes at national, regional, and global levels. In this sense, and according to my area of expertise, I will focus on the regulation aimed at education as one of the goals of the Sustainable Development Goals. Education has found on the internet a powerful tool for its proper development and use. Leaving aside the issue of risk in the use of the internet for another workshop, I will focus on the benefit of the use and regulation of big data and effective tool to obtain quality education in Latin America, hand in hand to of the international community policies. It is a fact that Latin American countries have created laws that attempt to regulate the proper use of the exploitation of data obtained from the network, and the protection of the confidential information has been one of the important goals that governments have tried to regulate. As I say, the last year in Paris, Mexican laws regulate and recognize the protection of personal data such as human rights. The same happens in large part of Latin American countries. I have noticed that the protection of human rights and the protection of personal data has been a recurring theme in several spaces in this forum. However, I consider that it is important to create laws that promote the protection of personal data obtained from the network and big data. But it is necessary to create laws that promote the use of information for the benefit of the population as a human right of access to data for their benefit. In this way, laws must be created that promote the proper use of big data as a tool for quality education. The question is, how can data exchange and big data be used to meet this goal? Thanks to the big data, different academic institutions can obtain personalized information from each of the students to make specific and special improvements. In addition, it can be guaranteed that obtaining data can be anonymous just to detect the trends and statistics of the information obtained from big data. Moreover, the academic community can participate in observing the areas of interest and apathy and design a correct strategy to increase the adequate quality of education at different levels. Among the proposal to promote quality education is the use of technological tools such as blockchain and smart contracts, that will also serve as instruments to obtain data, as well as control and protect the information contained in many virtual education platforms, include Moodle, Blackboard, WebEx, etc. This will bring peace of mind not only in the students, but to the parents of the students in case of underage students. It is a fact that the private sector has had considerable and active role in Latin America countries, specifically in Mexico. However, it is also important the proposal that the governments of the different countries of Latin America begin to create domestic laws that promote the use of the information obtained from the big data to increase the quality of the education and celebrate multilateral agreements to exchange data with the other countries in Latin America and the international community. We must remember, finally, that these political affairs and legal framework must respect always the protection of personal data and achieving quality education in developing countries, thus increasing the quality of life in society. Thank you very much.
Okay, thank you, Ricardo. Our next speaker is Wisdom. So please let me play the presentation files.
Thank you very much, Mr. Moderator. My name is Wisdom, the President and CEO of Africa Open Data and Internet Research Foundation. I'll be talking within the perspective of Africa, and then what Africa needs to do if we want to get things moving. So I'm looking at the team development of the digital economy and emerging technology in Africa. So in the context of the digital economy and then the attainment of the SDGs and then the African Union Agenda 2063. So I'll do a small reading here before I highlight some points. Okay, thank you very much. The SDGs calls for tracking progress at global, regional, national, and subnational levels, leave no one behind, with indicators for global monitoring and additional indicators for thematic monitoring, as well as regional, national, and subnational indicators. So for us to be able to do this, we need a robust data production and tracking system. Will need to be built in every country so that achievement at the national and local level can be assessed and fed into the wider global framework. These national mechanisms will need to be effective and integrated and will help countries to optimize their resources and actions to reach the goals. And yes, so the question is, has Africa as a continent done well in its developmental agendas? Yes, some parts yes, and the other parts no, and we'll be looking at it. So for us to be able to achieve the 2030 agenda, we need to align some of what we do with regards to the use of open data. And so I have this on the screen. So for us African to be able to achieve the sustainable development goal, we need to look at certain aspects of what we do in Africa. And then the first thing is strengthening census and surveys we need to look at that critically in Africa, our census, how we conduct our census, how we gather our data, how we use the data, and all that. And then the next one is utilizing administrative data. In Africa, almost every institutions, data is being underused. In the sense that, let's take in my country, for example, when you go to the Ministry of Agric, they have a lot of data sitting there, administrative data sitting there. They don't know the use of it. Even feeding this data into national policies and all that is a problem. So we have to look at that within Africa. Data disaggregation is another issue, exploring new types of data, and even not to talk about geospatial data. How do we gather our space data and all that? It's an issue. Open data, yes. Most African countries are now adopting the initiative. Citizen-generated data. We also need to look at that. Data coming from citizens and all that. Big data, yes. Data communications, managing data ecosystem is also another issue. Evidence-based decision-making, funding, and capacity building. These are all things that we need to look at critically within Africa for us to be able to reach the 2030 agenda. For us to be able to, if we're able to do all those things well, there are some expected outcomes that we need to see. The first one is data producers will be very clear about their responsibility with regards to data production for the SDGs in the short, medium, and long terms. Data users will be facilitated in finding information and will have fora where they can also interact with data producer community. And then the national statistical system will have a clearer picture of resources. These are some of the goals that if we are able to tackle very well, Africa will achieve. We'll start building an industrialized, inclusive, and resilient economy, create an equitable, healthy, and disciplined society. All these things need good data for us to be able to read the 2030 agenda. And going forward, my organization, we've done a bit of work within Africa. Then we've identified 3 themes that need to be tackled critically within Africa. The first one is addressing the data gaps. In Africa, we have a huge data gap that we need to address. The first one being administrative data. When you go to our various institutions, our various ministries, the way data are collected is poor. The way we use data is poor. Most of these institutions still use the manual way of gathering data, which is the hard copy. Everything should be typed, no electronic kind of data. So we need to look at this critically and then address them. And then the second thing is we also need to encourage data use. In Africa, we really don't, the data is not even available for us to use. Even the tech communities, the big data hubs that we have, the IoT hubs that we have, the AI hubs that we have, data is really not available. So we really need to encourage the use of data to empower citizens. And then the last thing is strengthening the data ecosystem. Yes, we also need to look at that within Africa. We need to strengthen everybody, bring everybody on board within the ecosystem and try to address some of the issues of data for us to be able to even feed this data in this SDG reporting platforms and all that. So we need good quality data. And then the ecosystem is very important. So in conclusion, so the SDG and the African Union agenda and their company indicators present both an opportunity and challenge for Africa data ecosystem. And we've increased international and national attention given to the importance of data. Data producers and users will have the opportunity to harness the moment to make lasting improvements, but must first acknowledge the numerous challenges that must be overcome. So I think this is what I want to bring forth for us to see what we can do to help Africa. Thank you.
Okay. Thank you, Winston. So I would like to invite the sheriff to deliver next presentation. Please.
Thank you very much. My name is Horst Kremers. I'm working here in Berlin, and I'm very much appreciated being invited here by Professor Liu Zhang for giving my thoughts on what I said, the topic SDGs and beyond. Challenges for partnership in United Nations instruments, operational coherence. Now, this is some buzzword in United Nations language, and I want to give you my personal opinion on the background of professional lifetime in geoinformation, environmental information, risk information, SDGs, of course. I want to structure my, I apologize for not having a formatted presentation because my invitation to this panel was a little bit short, only 2 days, and spending so much time here. I structure my small remarks in talking about the tasks, the challenges, management principles. Then you need a roadmap, what to do, and elements of governance needed. The tasks. The tasks are defined, actually, in the text of the core and neighboring United Nations instruments, like not only SDGs, but UN Habitat, UN Sustainable Development Goals, United Nations Framework Convention on Climate Change, International Platform on Biodiversity, IPBES, human rights, children's rights, we know here, and working together with United World Food Program and many others, the health system and so on. So it grows cross-cutting through more or less all the United Nations topics. What, as an information scientist and an informatics-oriented colleague, I took a special look on the requirements that is really written, at least in the recently updated and formulated United Nations instruments, is gaining or ensuring coherence. I say in a technical sense. There's a legal aspect and so on, but in a technical sense, it's information management, it's administrative legal coherence, it's about cross-border coherence, coherence with state-of-the-art professional practices, interdisciplinary standards, coherence with security and safety domains. That is my personal field of also deep action on UN Sendai framework on disaster risk reduction, which also belongs, has a big overlap in SDGs. The United Nations, with their declarations and instruments, they correspond to national or European implementation laws, regulations, and directives, acknowledge the coherence requirements, but systematically investigations, especially mutual semantic mappings, are not supported at the moment in adequate ways. Nevertheless, the task formulated is a little bit complex, but nevertheless, our work is based on existing experiences, the previous achievements in the fields of environmental information and geoinformation in detail, show that there are certain complex domains that we already have the possibility of going into the detailed data definition for a special clearance of that. The challenge is that the underlying information management efforts need to cope with the complexity of actors and organizations involved. And what I want to mention is it's not just the indicators, sorry. Indicators are the top level of the top-down approach. Those people, those colleagues who are practically working with the data on the indicators, they have their own problems at the moment with the technical definition of that indicator system. It's rather complicated, but if you start data from top down, it can be anticipated already that you run into a little bit difficulties when you come from basic data to aggregate to these indicators. So what we need to keep in mind that below the indicators, there is a real world that myriads of facts lying around in databases and needed to be made operable. The complexity of data available certainly calls for test beds of best practice to verify in different analytical and decision supporting environments. These kind of test beds, as you can imagine, from the point of view of big data, a test bed for SDG, let alone the overlap with the other instruments. A test bed of that way is not just a small venture. So nevertheless, I think it's necessary to get a little bit more belief that you have these data, and if they're analyzed on any one of the continents of any kind of research group, they can match their kind of analysis to the analysis results that other groups made. And this certainly would be something that our citizens would appreciate very much, to see that it's not just a single study, but it's a general reference frame of data that we're talking about. Then we need a systems management and engineering approach, convincingly that shows the necessity for transparent procedures of documentation, assessing, decision-making, support, action, and goal-reaching control on the data level side in very dynamic situations of highly complex actors, specifications, and boundary conditions. This allows providing comprehensible, objective, trustworthy information to all actors, and what I want to mention in special is including media, investigative data journalism, that is our control institution they are independent of the typical data organizations. Nevertheless, data journalism is going into exactly the thing to verify that everything is in order and applies to the ethical principles and so on. So the management principles applied, there is a set of management best practice methods, especially supports critical thinking, enabling extensive reporting, transparent analysis, compliance to regulations and other boundary conditions, and constructive goal-reaching control. Not just we are aiming at something, but to control it on a realistic level. These control obligations include phases of retrace, audit, re-examination, analysis, avoidance of malpractice, data malpractice. You wouldn't believe, but there is data malpractice around, so we have to be a little bit sure about it. And indications on weaknesses, vulnerabilities of the information system. Another well-known and identified challenge is the strengthening of data integration based on accepted information infrastructure concepts. and comparable to existing complex implementations. No, that is what I said. We have that experience in the field of geoinformation and environmental information. There we go really drill down until the original field measurement, not only field, but also remote sensing for satellites are so on.
Can you make it quick? Because we have a few speakers.
No question, no question. It's 8 minutes go by. Let me conclude then, to be short. The open science and open government is a culture to strengthen mutual trust and innovation through transparency and cooperation in the interplay of the institutions involved, and especially with civil society in the private domain. To strengthen the resilience of these relationships for the future, then that is a goal that these relationships will remain robust in the future and state institutions, services and infrastructures will be more appreciated through openness. Because only the steady cooperation allows knowledge and empathy between different organizational cultures. It is United Nations best practice to enable cross-organizational information availability and coherence for international, national, regional, local actors, strategies, decisions, and actions. The United Nations Data Revolution Group, you may be not aware, but there was a Data Revolution Group only in 2014. They had a very interesting report, but one of the central statements was data are the lifeblood of decision-making and the raw material for accountability. Let's do something together about it and join forces for making that an operable venture. Thank you very much.
Thank you, Horst. Next, we welcome Professor Diallo to give you a presentation. Please.
Thank you very much, moderator. Good morning, everyone. I am delighted to be here to talk about capacity building and education on big data for SDG. My speech will focus after introducing big data and data revolution. I will talk about opportunities before talking about capacity building development. The amount of data in the world is more and more increasing. By some estimate, 19% of the data in the world has been created in the last 2 years, and it is projected to increase by 40% annually by year. A large share of this output is data. We can say that quickly is big data, which is produced by data from mobile phone, credit card processing, and social media. Data is growing because it is increasingly being gathered by inexpensive and numerous information sensing mobile devices, and because the world capacity for storing information has roughly doubled every 40 years. The data revolution is already transforming society. Advances in computing and data science now make it possible to process and analyze big data in real time. The integration of this new data with traditional data should produce high-quality information that is more detailed, timely, and relevant. So, what opportunities from big data and data analysis? Data collected by the private sector will help predicting epidemic, spreading, mosquito-borne pandemic, remote propagation in social network, movement of people in riot, etc. So, big data analysis can help in saving lives. For example, from information sold by a mobile operator, for example, it would be possible to improve road safety. Then, sharing of medical analysis data could also help better refine research into genetic and non-genetic factors for the manifestation of certain disease. data is the livelihood of decision making, as he said, the previous speaker, and the raw material for accountability. Today, in the private sector, analysis of big data is commonplace with consumer profiling, personalized services, and predictive analysis being used for marketing, advertising, and management. New sources of data, such as satellite data, new technology, and new analytical approach is applied responsibly, can enable more agile, efficient, and evidence-based decision-making, and can better measure progress on the Sustainable Development Goal in a way that is both inclusive and fair. So, big data for Sustainable Development Goal, we can understand that in 2015, the world embarked in a new development agenda underpinned by the Sustainable Development Goal. As if this goal requires integrated action on social, environmental, and economic excellence. Many governments, I'm sorry, I forgot to switch slide. Okay. Many governments still do not have access to adequate data on their entire population. So big data can shed light on disparities in society that were previously hidden. For example, women and girls who often work in the informal sector or at home suffer social constraints on their mobility and are marginalized in both private and public decision-making. Most of the big data with the most potential to be used for public good is collected by the private sector. As such, public-private partnerships are likely to become more widespread. Then, what is the main goal in capacity building and education team on big data for Sustainable Development Goal? First, we can talk about fostering and promoting innovation to fill data gap, funding and mobilizing resources to overcome inequalities between developed and developing countries and between data poor and data rich people. Then, leadership and coordination to enable the data revolution to play its full role in the realization of sustainable development. We can also talk about developing and supporting projects with local resources, like universities, local business, and then developing research on big data for development and generate capacities among researchers in support of the SDG. Then building the path for SDG reporting and delivering fair access on data and tools for everyone. In this topic, we can also add work on applied big data for development innovation, including big data analysis and capacity building in close collaboration with private sector companies and policymakers. Also develop capacity among researchers, focusing on activities linked to measuring progress on the Sustainable Development Goal. Declining prices and improved functionalities of data analysis software will help to democratize data users. So in capacity building, we can also insist to promote open source tools users in order to broaden the mechanism for people to conduct big data analytics outside of proprietary and expensive software packets. For the last 2 points in capacity building topic, one must work to develop perspective on issues related to big data and marginalization, privacy, security, right, ethics, and competition. And then improve government service delivery, complement official statistics, and facilitate development in sectors such as health, urban development, transportation, and humanitarian response. To conclude, as we can see, information provided through big data can help countries overcome information gap, expand official statistical operation, and generate evidence-based policies. For example, big data can help predict optimum climatic conditions for crops, reducing the risk of economic losses for farmers. Also, the use of big data also can identify critical areas of crime or vehicle congestion, providing key information to help policymakers structure policies to address such challenges. In this way, capacity building and education on big data could help strengthen current uses and application of big data for sustainable development. To achieve this, our way would be to develop research on big data for development and generate capacity among researchers in support of the sustainable development goal. Thank you very much.
Okay, so, thank you, Chair. So next, I give floor to Ines.
Thank you very much. Hi, everyone. My name is Ines Hafayed. I am from Tunisia. I work for the Ministry of Education. Thank you very much for the invitation. This is my third time participating with the China Association for Technology and Science in a panel. So today I'll be talking to you about SDG 4, the quality education, which I believe as a teacher is a pillar to many of other SDGs. So when we talk about big data, I am talking today about the impact and challenges on education and the way forward for developing countries, as I am from Tunisia, a country which is very developed at the educational system, but economically still considered as developing country. So first, for us in Tunisia, we need to give more background and more education and more lobbying to the ministries of education, because we are still in need of a big data center. So first, we have to explain how this is a growing and promising field of knowledge, and that it has already affected many industries, and how it can affect positively the educational system. So the advantages of big data in education. So it provides a numerical representation of academic results and outcomes. So as teachers, let's imagine that you have this set of data, this huge amount of data where you can have and know what are the weaknesses of your students, for example, in language, writing and listening, in comprehension, etc. So this will help you a lot in your teaching practice. It offers the ability to focus on specific groups of students, for example, the fast learners, the slow learners, the students that we have and who have some difficulties in education, difficulties in pronunciation, and also, for example, the students who have some disabilities. It helps determine how effective certain policies and initiatives are. For example, some initiatives were made by the Ministry of Education, but we do not really have a follow-up on this. We do not really know how effective that was. Did we gain anything from that policy? Schools and universities have enormous amounts of data. So with the academic records and test results and grades, this can help the universities. For example, I teach at high school. We had my colleague from the higher education. So this can help higher education institutions to tailor actually the courses and to see what is trendy and what is interesting for the students for them to follow at university, so that they don't have too much loss of resources, for example, and of teachers. So this could help in the student learning, also the adoption of technologies, and I'm always a fierce advocate of adoption of technologies in education to improve the effectiveness of test score data analysis. This will help us as teachers to tailor education to each student's needs, his level, his pace, his speed, etc. And this also will help parents, especially at high school and primary school, to be more involved in the education of their kids. This also will help us to have better assessment of quality education. And as I am also a teacher trainer, this can also help us in better training for teachers. And for governments, of course, this will offer more organized and focused allocation of resources in terms of financial resources and human resources like teachers, etc. So there are challenges, of course, and I have to focus on this because big data is still not very well developed in the educational system in Tunisia. So the challenges have to be explained to the ministry representatives. We do not have enough big data on education yet. In the Tunisian educational context, the opportunities it provides can only be assessed judging from its use in other fields or other countries. This is also a big challenge, that you are going to the ministry to lobby about something, but you don't really have results. You're just gonna give a comparative research from other countries and other applications. And also the fact that amassing data fuels heated debates on the privacy policies, students and pupils' privacy rights. And also that we have fairly limited technical capabilities on that. So the point of my presentation today is to think about a way forward for big data in developing countries. Let me first start with a fact from the UNICEF. According to UNICEF, 60 million children won't have the opportunity to attend primary school by 2030. 60 million. It's not a number. These are students. They will not go to school by 2030, which is right here. We are 2019. And the global rate of school enrollment has stagnated since 2007. So what we need to do, promote better data gathering, improve the effectiveness of technical measures in data compilation. Big data should be applied for social and educational good. We have to show the impact of big data on the educational sphere. And using big data for mapping every school and assess its overall performance, leading to targeting the lacunae and weaknesses of the schools first in general and the students in particular. This mapping, by the way, will help a lot in allocation of resources from big organizations and companies and governments as well. We have to work on agreeable privacy policies that balance between the advantages of big data and while protecting the learner's privacy, because this is the right to have some privacy online and to be safe online. So we have to agree on these privacy rules. And finally, and most importantly, enlarging the stakeholder discussion and opening up to public-private partnerships to bridge the digital divide through big data so that it actually bridges the digital divides and does not enlarge it. I thank you very much.
Thank you, Eunice. So that's my presentation. So because we don't have so many time, so I just want to give you a very, practicing example of how we do realize the importance of open data on implementation of SDG. As you may know, Earth observation play very important roles for evaluating and assessing the performance or the progress of implementation of SDG in local, regional, or global level. So, as I mentioned, international or intergovernment international organization also very important power to promote this kind of activity. So here I would like to introduce GEO's activity. As you may know, GEO is governmental organization, which consists of more than 100 member countries and also 110 participant organizations over the world. So we have been done a lot of work on analyzing or evaluating the power of Earth observation in support of implementation of SDG. So there is the example you can see. We try to align the power of this technology to the objective of SDG, 2, 3, or 4, 14, 15. I mean, all this, the implementation of these goals can be well supported by the Earth observation data, as mentioned. And also, we have a survey on EU user for SDG by geo member country, as mentioned. You can see there is a very growing concern for all different countries. You can see from the right bottom figure, this is a very specific indicator showing for the current use observation for an SDG analysis, and there are a lot of countries they are wanting to use the observation for implementation assessment of SDG. So GEO is a huge organization, but very specifically focused on the work of Earth observation. So it has 3 priority areas. Today we are talking about sustainable. Oh, sorry, I've made the. Okay, so SDG is one of priority area, and also disaster and climate change are expected to play more important roles for GEO. So how do we link the GEO activity in different levels? Because as I mentioned, we have different phenomena or different action on a different level, global level, regional level. We found it's very effective or it's very powerful methodology to promote the implementation of Earth observation in the regional level. So because the GEO was operating the CARGOS mechanism, Asia Oceania was one of them. So we choose AO as our target. We try to build a regional level cooperation mechanism to promote of this activity at the regional level. So just like the colleague mentioned, we are focused on the improving the observing ability of this region, also promote the data reuse by develop data products and the information extraction and the processing capability. Also very important, the data sharing service to reduce the gap between the different countries. And also a network for promote the technology and method. That's very important. Very important thing for this region, every country is focused on the application of the advancing technology, especially Earth observation. So we build a structure. This is can be in a different layer. So we have a foundational task focused on the data sharing, data processing that aim to promote the ability of each country by the linked activity at the regional level. We also have some regional issue to tackle with, like agriculture, sustainable agriculture, disaster, and ecosystem monitoring. Then we choose the 3 sub-areas, like high mountain area, small island states, and also the river basin system, to try to make a representative of this research target. So we compare as this methodology, try to use observation to support in realizing SDG. So as you can see, we aligned the each goals of SDG to the activity of our regional initiative. So the concrete activity include workshop, academy, also the training workshops in different countries, like China, Laos, Nepal in last year. This year, next month, we are going to hold another training course in Sri Lanka. So there are also a lot of projects that were conducted to promote the use of utilization of the observation information, try to help the local people. So for the next, I totally agree with the proposed from our colleague. Capacity building and data sharing is very important issue for us to thinking and take a measure to go way forward. So, okay, thank you. That's my presentation. So we do have quite a lot of presentation, but we still have a few minutes for discussion. Maybe if you have a question or comments to the presentation for the speaker, please. Any question? Maybe from our panelists? Mm-hmm. Yes?
Horst Kremers, Berlin. I just want to make a statement that I very much appreciate the discussion about the educational fields that are so diverse also. I'm very happy you started from school to university to scientists. Even scientists need education in these new techniques that we still don't have. So we have a full education curricula on all levels, let alone people in administration, people in technical organizations that support disaster risk involved in climate change and sustainability issues. This is something where education is so essential that we somehow should organize a little bit more a strategic way.
Okay, Ines?
Thank you very much indeed. I believe that we are really in need of real partnerships. For example, between developing countries and developed countries, because we have a huge thing. It's called big data. It is very lucrative economically, socially, and at the educational system. But at most developing countries, we are still at the level of explaining, please, let's use big data. Please, we can find ways and frameworks for protecting the privacy of students, and at the same time, we can gain a lot from this practice. So now we are still at the level of lobbying and raising consciousness, and also we need exactly to provide education to government officials on big data. And I'm really looking forward to maybe today actually to find some partnerships to do that and to achieve that. Thank you.
Okay, thank you. Wisdom?
Thank you. Yes, I just want to add to Ines. There is this initiative, Global Open, Global Open Partnership also. I don't remember the name fully, but then that is where almost every country sign on to commit yourself to start the process of opening up your data within your country. I think once that is done, then the donor agencies can begin to look within your country and to see the kind of support that they can give you. I think the World Bank is very much supporting countries that are opening up data. So if your country has this open data initiative, you can as well be looking up to the World Bank, or the World Bank can even come to you and say, we have this amount of money for you to kind of promote your open data initiatives and all that. So I can give you information with regards to that and how your country can sign on to that partnership.
The most valuable tool we have now is the internet. And if you look at 30% of the world youth are digital. I don't see anywhere I go, even I go to the developed country, everybody have a digital phone. And that's mean it's easy to access to them, online. And we had 4 billion do not use the internet. And 90% of them are from developed country. How are we going to use data to reach out to those people? And I think that's why partnership and collaboration is very important.
Okay. Annika.
Yeah, that's actually there. From our experiences, we have 2 ways to get to be involved in the partnership. One way, we have a joint project. Or we can join the meetings, conference, something like today. This is one way. Another way, we don't know to each other at all. But that's data, product-oriented. Right now in the data publishing, we have almost 1,000 data contributors. Most of them I don't know at all. But we check the data. We communicate through internet. And then the data make us to be involved as a teamwork. And also users from 97 countries, we don't know who is who. However, the data make us together as a team. So I think as a partnership, we have a different way, an innovative way through the internet. So the data-oriented, data sharing, and the data principles make us work together. Thank you.
Okay, thank you. Any question or any comments? Okay.
Yes, I just want to add to what I just said. We also have this organization, International Aid Transparency Initiative. This is an organization that is also promoting open data. And then they have a lot of funding for countries that want to do one project on open data within that country. And also, my organization has been championing this open data within Africa for some time now. And any country that is even finding difficulties in open data policies, we can as well come in and then help. And we are currently in about 11 countries, and we are hoping next year we are going to cover the rest of the African countries and then see how we can help them kind of sign on to the open partnership, and also try to help them with other programs, capacity building programs and all that. And also, we are also open up to the China Association for partnership in Africa to see how we can help our people come out from some of the just basic things that we need to solve easily moving forward.
Okay, good. So, anyone want to say something? No? Okay, I think we have a very good and impressive talk from our panelists. If I remember right, I think we get very good points from this workshop. Firstly, I think the data, no matter scientific or technology, and the data for the different industry, even private sector. So we can think about more data should be opened widely and utilized efficiently. That means we need to develop the legal framework which can provide strong support for the data sharing, even the data sharing principle, especially for developing country, to fight unbalance, to end poverty, to support people for a better life. I think that's one first, common concern from our panelists. That means very important. Big data will play very important roles for society and economic development, and also the implementation of SDG. And the second, in my understanding, the implementation of SDG requires different level. The contribution or effort from different stakeholder, multi-stakeholder, government and civil society, private sector, even the individual. That's, it's not easy, but it's, need everybody contribute to this work. So I think our panelists propose very good methodology and solution. Capacity building, education, that's very important, still very important for the developing country. That's why, arose this issue during the IGF. I think it's a common concern as well. Thirdly, I think, as I mentioned, it's a very huge task which requires the different force to convey the different resources like investment, human resource, intelligent property, different input to promote the implementation of SDG by using of big data. So it do require some different methodology. Like I mentioned, maybe we can do it at the local level or exchange ideas or experience to enhance partnership between the different countries at the regional level, then scaling up to the global level to find a better solution for mutual development. I think it do requires everybody effort to make it happen. So I think today we have very good workshop. Even we have a very large issue to discuss, but we do analysis this issue from the legal, from the technology, from the best practice, and even some suggestion for the next step. So firstly, I will say thanks to our panelists for your very impressive and good contribution to this workshop. And also thanks everybody for your participation and interest in to this workshop. So now I will say this is ending of our workshop. Thank you. Thank you, everyone. Yes. So I would like to invite our panelists to take a group photo here. Okay.
Okay, good.
Thank you.
beautiful, but they make it difficult to see into the room. So feel very much invited to come a bit closer. We don't bite.
At least not yet. Exactly. Was können wir denn machen? Ach so. Alles wunderbar, alles wunderbar. Nein, wir schaffen das schon. Genau, kriegen wir das schon hin. Wer macht denn... Lucy, schreibst du mit oder wer macht sozusagen Protokoll? Ich kann das machen, auch mitschreiben, wenn ich fertig bin. Ja?
Beide würde ich sagen.
Genau.
Du schreibst mit und dann
Ja, und du auch.
Max kann auch ein bisschen mitschreiben, dann haben wir alle ein bisschen
mitschreiben.
Thank you.
Genau.
Thanks for it. Thank you. It's very military, that's why. I guess. What's the time?
3 Minuten vor.
58. 4 minutes.
Hello?
Hello? No. You have to click, I think, no?
Ich darf uns einfach nur reinsprechen.
I'm live.
Hello. I think, okay. The micro is quite big and long, so I'll try to do my best. Good afternoon, ladies and gentlemen. It's great to have you here, to welcome you to our workshop on transparency control of IoT devices. It's a great pleasure also to have such a wonderful panel here, which is, I would say, at least very gender diverse. We had also quite a great regional diversity, but unfortunately, due to different circumstances, we're now very Western European here. Apologies for this. My name is Ludmila Georgieva. I'm from Google. We're organizing this workshop. The idea of this workshop is to identify the best ways to ensure consumers can make informed security choices about consumer IoT devices. The question is rather not just, I don't think we will be able to find in 90 minutes the solution or these solutions, but the idea is actually to try to bring to the next level the discussion to find and to address and identify questions which maybe should be taken on board for the next IGF. We have, actually the idea was to review the current landscape, also a little in the different presentations and the different interventions to have an overview of different best existing frameworks and practices that can help to drive security standardization for consumer IoT, but also how to approach it, not only to standardize it, but also how to approach it. The question would be also to discuss and develop further ideas and schemas for transparency security IoT, one very important issue for us was to take into account the previous IoT workshop from the previous IGF 2018, and also to what we are trying to do here is, because IoT is actually a very big topic, maybe to focus on consumers and in specific to focus on smart home, well-being, and maybe also different examples like food traceability. I'm very happy I will introduce my panel, and I will start with Estelle Mas. She's Global Data Protection Lead in Access Now and also Senior Analyst in Access Now based in Brussels. I have Martin Botterman, ICANN Director, and he's also the moment to ensure continuity with last year IGF workshop, because he was the chair of the IoT workshop in 2018. On my left, I have Kristina Kubecka, or called also Chris Kubecka. She is CEO of Hypersec, and she's a cybersecurity researcher, practitioner, I would say it, and has a very heavy background in cybersecurity, but also cyber defense and cyber warfare. And on the left side, I have Armgard von Reden. She's chair of Women in International Security Germany, but she's also a lecturer and consultant on data protection and cybersecurity. Remotely, we will have also Navid Sayed. He is project manager cybersecurity services from TÜV Süd. And Navid, we already tried out his remotely, he's online. And my online moderator is Max Enges, also from Google. So, I would start, the idea was to give with this panel a bit of our input. We thought maybe at a certain moment if we can have breakout sessions, but I think this room is not really, doesn't really qualify for breakout session. That's why I would really love to engage with you and to discuss, so please raise your hand. Microphones, you have to use microphones in order to be able to be heard. So, but please feel free to jump in and to make it as possible, as interactive as possible, and not just a panel here. I would ask Armgard to give us a kind of a first overview and a bit of to set the scene, to talk a bit the IoT workshop IGF from last year, what were the outcomes, but also maybe to frame a bit a few sectors and key players. Armgard, the floor is yours.
Thank you very much, Lucy. I know we have the graveyard slot. That's always not the easiest when you have a section. And on top, we cannot see you, but you can see us. So we would really appreciate if you then use the microphones. I would like to do three little things. One is to summarize a little bit what was discussed at the last IGF and were the outcomes of a workshop there. The other thing is I would like to say what are the challenges ahead of us, and I would like to bring one example. At the last IGF in 2018, Martin was there predominantly and will talk right after me. The key findings and takeaways were the three following. IoT good practice principles must factor in at least 4 primary goals: security, consumer trust, meaningful transparency, and affordability. It will be important to revisit established and emerging principles in the future to ensure they both effectively reflect the current environment and continue to achieve their intended goals. And it is very good that we have this workshop, because we are just doing exactly this in this workshop. The second takeaway from last year was it is the responsibility of the larger IGF stakeholder ecosystem to educate, engage with public government sector stakeholders on the process of these discussions, and to receive feedback from key points made, agreed to them, and relay those points and messages back into the IGF stakeholder ecosystem. I will come to this in a second. And the third point was more needs to be done. And based on the outcome of the working group's results regarding better formulation of ethics and better understanding of activities underway towards longer-term sustainability of IoT applications in society. Now, in the last year, governments have been quite active, and so has the industry. So many groups have been active on this. The BIAC, Business Industry Advisory Council of the OECD, for example. ISO, FIDO, Fast Identification Online, which is a soft standardization bodies, you name it. I mean, it's about 5 or 10 at least who have been working on these issues. But the process and production and the management system of consumer IoT applications needs to be divided into the different steps because each of this step has basically a different requirement. So therefore, it is important to take a look on who works on what of these different steps. And the last point, consumer IoT applications and their management fall into really very different sectors. So therefore, they have completely different requirements for transparency and security. And because the industries know the requirements of their respective industry the best, it is important that we try to bring together not only stakeholders in terms of governments, but also from the various industries. And it would be wonderful if we have several representatives from different sectors here in the room who can pitch in and talk about the specifics of their industry. One point that I would like to make with regard to a specific industry is the food industry. Not necessarily something that comes to your mind if you talk about IoT and consumer products. However, when I was in the 2000s until 2011 or something, the chief privacy officer of IBM, we already started to work on a project on food traceability because we saw this as an amazing field, especially with cow diseases, etc. at that time. So now we have F-Trace, which is, although we thought it's long gone, but it's still alive, a GS1 barcode system. So you can download an app, you can see whether the product that you're buying has an F-Trace label on it. You can type in the code, and immediately you get who has produced it, when was it produced, and how are the quality standards of that producer. So that is just one example that I wanted to leave you with of how different the requirements are for the different industries. And with this, I'm very happy to give it back to Lucy.
Thank you. And don't get confused. People call me Lucy. This is very privacy protective nickname. So when they search for Ludmila, then don't find Lucy or the other way around.
I apologize.
No worries. That's fine. That's fine.
As a former privacy officer, I should have known that.
It's not a secret. Thank you very much, Armgard. I think this is exactly what we're trying to do, to see the different devices, the different applications where IoT will be actually the everyday life, but also to understand where we need what kind of security requirements, because for food traceability there is one requirement, I guess, when you go about the food chain and about the, cooling down something. This is another probably security requirement, so, hence there is a question of health issues as well. Just to give a bit of a question to throw into the audience, I think Max also already put the document online. Max?
Yeah, we're using the wiki for the IGF, the intgovwiki.org, to document what we are discussing, and we've put the comments, including the question that Armgard just raised, on the wiki page for this workshop. So if you want, we can continue the conversation and use that tool as well. Thank you.
Thank you, Max. I would now ask Martin to give us a bit of our, having in mind your function, but also your experience, a bit of the global settings of the different approaches from the different systems actually. What is the possible international cooperation maybe? Martin.
Well, thank you very much, Lucy. For basically, yes, over the last 10 years, we've been working with the Dynamic Coalition on IoT on this, and tomorrow morning at 9:30, there will be the 11th meeting of that during an IGF. The specific focus of this session on consumer IoT security is very useful, because if we look to the world of IoT, just like the internet, it started just to be used to see how it could help us make our life more pleasant, to see where it was necessary, ranging from tsunami buoy networks to see the waves coming, to the pure consumer stuff that is related to counting your steps in your shoes, whether you move enough, and things like that. It wasn't designed like the internet with the inclination to have security from the outset. And now we see it's so much permeating our environment and becomes such a crucial part of our life, increasingly so, that it's about time that we do address that, because otherwise we end up in unsustainable situations. And this is not an issue you can solve in one country, because this stuff comes from across the countries. The interaction with these devices comes across networks that span the world. And industries are from everywhere, consumers are from everywhere. How do we make this work in a responsible way? That's one thing. In that, how do we work with things going forward? How can we design future IoT in such a way that we can manage it better? Recognizing that anybody who can put a couple of chips together can create his own IoT device and hang it to the internet. The other thing with that is that there will always be already the mass of devices that are already out there. Now, the focus on consumer IoT is so useful because we can't expect consumers to manage all this complexity in a responsible way. We need to help. We need to help by informing them better. We need to help by making sure that devices that they buy are clear on what they do in terms of how secureable are you, what do you do with data, that people understand it better so they can make smarter choices. This will influence the offering of industry as well. And we need to back that up, of course, that if there's something like certification, labeling, that what is said on the label, that is what's said on the certificate, is actually true. So that's one of the elements. The second element is that even then, it's important that we consider the challenges for what they are. It's not just a challenge for the device. The device can be used to be weaponized for DDoS attacks. So it's known that not only consumer devices like cameras, but also, for instance, payment machines have been used for such a thing, generate tons of signals towards one target, in that basically stopping all possibility to interact with it. That's one element. A second element is abuse of the thing itself. Actually, I had the personal experience of having installed some cameras because I travel at times. In my house, I have some cameras that if unsuspected movements are taking place, you get an alert on your phone and you can actually see what's happening. Sitting on my couch, at some point, one of these cameras turned to me and I had changed the password. So it just shows how vulnerable this can be. And because we focus on consumer IoT, I will not go into how such devices can be weak spots in corporate or enterprise networks. So how do we help consumers? So one thing is better information on what they buy, the new stuff, so they can make smarter choices. Second, to provide more tools that help them to do that. And one of these are, for instance, captured in some of these new standards, that you cannot just use the standard password the IoT device comes with, because it asks you for a password when you want to put it online. But the other thing is also that with all these devices that are not all safe, It's good to provide the use, for instance, of a door lock in front of your home network, for instance, where you can manage all the access, like your front door. You may not have your drawer locked in which you keep your keys or your money, but at least you have the front door locked. Same thing in a way with IoT devices in the household. So there are solutions developed for that as well. And these will become more and more natural and maybe even part of the service provider offer. The service provider offers you access to the internet, to your telephone networks, to your cable TV. And that brings me to the third part of that, which is that all these service providers, starting with the one who supplies you with an IoT device, to the access provider, to the cloud provider, to the application provider, the service provider, they all have their role. And if future devices will be recognizable by the system for doing certain things and not doing other things, then you can expect access providers to block if something goes wrong there. So it's a whole series of actions that need to take place. In Canada, they've focused on consumer education, on labeling, and on network resilience. Other approaches range from in the Netherlands, where they have a complementary approach where they set standards and where, for instance, by government procurement policy, they steer towards better products to be delivered, but also legislation and to back it all up, and liability to make it expensive if you don't do your expected duty. And other examples include the UK, where it's really looking at good practice and offering that. So there's a range of things that are moving at the moment that are helping us to manage this better going forward, recognizing that this is a global thing. You cannot solve this in one country alone, but also that, yes, you can help the consumers in your country to be more aware and have better tools to deal with it, and also make all the players in the value chain of the IoT-enabled service to take their responsibility in the whole. So I think that's a sketching of the landscape, and I'm very happy to have some excellent examples here in the room as well to listen to.
Thank you very much, Martin. You mentioned consumer be better aware, and I think this is a very interesting. When we had our preparation meeting, we touched upon on what the last workshop on IGF 2018 was talking about, is exactly ethics. When we had this, our preparation panel, Estelle said actually rather talking about ethics, we want to talk about users' rights. And I would like, exactly because it's all about consumers here and them to be aware why this difference is necessary. Maybe you can elaborate on this. Thank you, Estelle.
Estelle, okay.
Sorry. Thank you. Thank you for having me. And as Lucy mentioned, I'm policy analyst at Access Now, and our mission is to defend and extend the digital rights of users at risk around the world, which means protecting human rights in the digital era, which explains why I want to focus on a human rights approach to IoT rather than an ethics one. And to do that, I'll start by explaining what's the impact of IoT with human rights and what are the safeguards that should be considered. So you probably see that almost nearly every week there is a new type of Internet of Things product being put on the market, whether it's in the form of home assistant device, a toy, we even see jewelry. There is obviously connected car, more and more connected object that you can put into your home. And while we see that there are efforts to grapple with keeping some of those Internet of Things secure, those discussions often limit to security, which is an important component, but they don't look into specifically the larger human rights impact that those products can have. And so in which way does IoT can interfere with human rights? They can do so in many ways, either actively or passively. First, there is the obvious impact on the rights to data protection. IoT often collects a lot of data, a lot of signals, which can include also private communication that you're having in your home. And if you live in a country which do not have appropriate and enforceable data protection laws, you may be vulnerable to that if the IoT product has not baked in protection into the design. And this is not just about your own right. We're also trying to figure out how modern data protection law adapts to those new technologies, because let's say, for instance, I purchase an Alexa in my home and I consent to do some of the recording of my conversation, but if I invite Lucy over, which I've not consented to the use of her conversation with me, how do we deal with this? How do you manage with IoT not only actively collecting information about you, but also passively about people coming to your home and potentially being impacted? There is also an obvious interference and risk with the rights to privacy. This is linked also often to potential vulnerabilities that products can have if external actors can enter into the device and use it against you. We just had the example from Martin of the camera being accessed by someone else and turned against him, which can be done by private actors, but also can be done by governments if there is not enough protection on the security of those devices. And then in that sense, there can also be an impact on freedom of expression. It's widely known now that surveillance and risk of surveillance harms users' privacy, but also have a chilling effect on freedom of expression. And what are the risks when we are hearing in the news that different home devices listen to your conversation, and also there are employees from those companies that can access your information? Does that mean that people are purchasing those devices will start moving more private conversation in part of the house where they don't have those devices, or that those devices will not be bought because people basically will feel like if there is no human rights-based safeguards included in the production and the deployment and sale of those products, instead of buying an IoT product, you're basically buying a surveillance device that you're putting into your home. And the solution to address those issues would be to go with human rights safeguards baked in the product. We have a few large recommendations on how to do that, which would include having data protection, privacy, and security by design and by default, which would mean that from the moment a product is being designed, there are specific rules baked into it in order to protect those rights. This goes beyond the mere compliance with existing law that may exist in the country regarding data breaches or minimum data security or minimum data rights. This is really something that we would like to see more innovation around and more product development. There is also an important part that was mentioned about the transparency and the information given to the users. And I think on that form of the issue we're seeing in the IoT market at the moment is that at some point IoT companies may be bought by others, and then rules may be changed while the users learned after that and have not been neither informed or consulted or have the opportunity to say no to this change of rules. So there must be much greater consultation with users in case a company decides to change the way an IoT system operates. And then more largely, we should also consider discussion around the right to disconnect. You might be initially purchasing an IoT device or a device that connects to the internet, but later on deciding that you no longer want that to happen. So the product should always be able to function in a way that it doesn't have to be connected to the internet, which may have some limitation. Not all IoT products could be able to do that, but to the extent it's possible, there should be a need for consumer when they purchase, let's say, a smart fridge, that the fridge still function if you plug out the internet. I want to highlight that some of those safeguards are not limited to countries who do not have privacy, security, or data protection laws in place, because in places like in the European Union, where we could see that we already have some standards to apply, there are still a lot of questions that apply, including the question I mentioned before. How do you interact when maybe there's protection for your privacy, but not the ones of others around you? What is the passive impact on the right that is also not necessarily addressed? So there might be some sectoral protection that needs to happen here. And it's not just good for users because you're protecting their right, which is a duty that companies have to do, but ultimately we think it will also be good for the IoT market, which may experience some failures if users are constantly seeing in the news that there is such and such vulnerability, that an IoT product for kids has been used to spy on children, that there is faulty design, or that software are no longer maintained and therefore their product can no longer be used. If we don't have those safeguards built in by design, there is a risk for the IoT market to not develop the way it could be and therefore hinder innovation. Coming to the ethics versus right discussion, we see a lot of ethics discussion, not just on IoT development, but also artificial intelligence and others. And these discussions are valuable, but they need to happen once we're ensured that human rights obligations are being baked into the products and protected. And when that happens, if we see that there is a gap in level of protection, let's have a discussion on ethics. But ethics should not be a replacement for human rights, because ethics are a variable concept depending on where you live, and ethics are not enforceable. So in order to better protect users, you need to have those human rights protection. I look forward to discussing those points with you. Thank you.
Thank you very much, Estelle. Now we will go to the darker side and go to a bit more examples. And I know that Chris has prepared some examples, and knowing your experience, and now that could be very scary. So I hope that still at the end of the session we'll be very digital optimists here. So, but Chris, please tell us about your experience with from the cybersecurity side and your experience on how IoT and the vulnerabilities. Please, the floor is yours.
Thank you very much, Ludmila. So in 2012, the world experienced the most devastating cyber warfare attack that has yet been known. How many of you in the audience are aware of a company called Saudi Aramco? There's a few, excellent. So Saudi Aramco is currently known as the world's most valuable company, and a good deal of the energy that comes to us right now in this room is actually produced by that company or by various joint ventures. Now, what had happened in 2012 was the IT and IoT systems and some of the industrial control systems that belonged to Saudi Aramco were weaponized because they were infected with malware, which wiped them, and they were forced, the company that is, to disconnect from the internet. And it got to the point at around day 13, day 14, the refined petrol supplies of the country of Saudi Arabia were beginning to be halted because the IoT devices that helped automatically load petrol into trucks were no longer functioning. Now, imagine if you go to a petrol station and you're told that there is no petrol. Imagine if you call 112 and you're told, well, listen, we can tell you what you should be doing if someone's having a heart attack, but currently our ambulance system and emergency services do not have fuel to come out to your location. Now, one of the challenges is anything can be turned into a weapon and used for dual use. And part of our modern world, we all depend on IoT devices. I would probably venture to guess that all of us in the room right now have smartphones, which are IoT devices that we use on a consumer basis or business basis. But we also depend on other things related to IoT to keep our modern world running. So we have things like solar panels that many of you may have on your home, and those are IoT devices. Wind turbines, either for your personal use connected to the grid or for industrial uses. IoT is everywhere. There are billions and billions of these devices, either consumer grade or industrial grade. And one of the challenges is, many cases, security is not really thought of when they are developed. They're thought of to meet a certain price point. And we also have to look at it from the case that we all enjoy functionality, we all enjoy usability, but to enjoy those things, there always seems to be a bit of a pushback on security. Now, security is not an easy thing. And unfortunately, one of the least thought of things around the world, other than the European Union, is also privacy and how that can be leveraged for security purposes and misused. Japan is about to have their Olympics in 2020, and they recently passed a law that stated that their access providers were allowed to proactively scan their networks and find weak IoT devices that could be turned into weapons in attacking the country. And one of their primary concerns is that the 2020 Olympics goes smoothly. And these different types of IoT devices could be in your very home that are suddenly blocked from being usable whatsoever. So if you have a doorbell which are very, very common more and more around the world, and suddenly you cannot answer your doorbell remotely. That is the least concern, basically, of the Japanese government, because they are looking to protect their national infrastructure and obviously their reputation. Now, last year I had the privilege of speaking at the EU Commission for an event related to the EU presidencies regarding the smart grid for the European Union. And of some of the examples that I showed that not only are industrial wind turbines very vulnerable to attack, because many times they are not secured and they use default or hard-coded credentials. But that also extends down to things like actual smart homes, smart appliances. Your fire alarm might now be a smart fire alarm. Your burglar alarm might be a smart burglar alarm. And in many of these cases, they are shipped with very little security, and they expect you as the consumer to be able to set up security, which usually requires a lot of complication. And security is difficult for everybody. And one of the examples I showed was that I could remotely get into someone's smart meter and bypass the authentication due to very poor coding practices, and then see the electricity that was being used and also adjust the price for peak and off-peak. More recently, while I was preparing for this particular workshop, I found a whole bunch of, we'll say, Zesla power walls that were also connected to the internet, and someone could script up an attack using default credentials, because most of the time they are not changed, and the interface that connects to these do not require it to be changed. So what a nefarious attacker could do is actually get into those power walls and force a mass dumping of electricity onto the grid, which could cause deharmonization of the EU power grid. Now, I am talking about kind of dark subjects, but I do want to stress that I am actually very positive about our digital world, both currently, I have a smartphone, and for the future as well. But there are certain things that we need to absolutely consider. A lot of the consumer-grade devices that are purchased right now are basically throwaway devices. They are produced at very low cost. They ship with older versions of operating systems, such as older versions of Linux, because it's inexpensive to do so. But when these items are shipped and produced in this manner, they have no secure software development lifecycle, and they are shipped with known vulnerabilities. Things that can be used, for example, for the Mirai bot, which got out of control from the original creator and turned against various critical national infrastructure and tried to disrupt various types of our everyday world. We also have a problem where even if these devices carry some sort of encryption, many times they are shipped with something called a known private key. And what this means is you can actually find these devices with a known private key, and that means that everybody actually knows your encryption key, which equals 0 encryption and 0 security, basically. So we're all looking for a good deal. I know at least in the US, and I've seen a bunch of sales around Europe as well for Black Friday, we need to consider the fact that looking for the lowest price point also, in many times, also includes looking for the lowest level of security or security testing. And in most cases, these devices are not security tested whatsoever. But I do see from both last year and working for this workshop for this year that there is a lot of opportunity to change that. And if we want to keep the modern world going in a nice manner, because I certainly like running water that's clean and electricity and all the trappings of a modern life, then we need to understand some of these risks and how they can be used, unfortunately, against us, and then try to change the way that these particular devices are regulated, and try to certify them and also make it easy for consumers, easy for businesses, because not everybody's a technological expert, not everybody's an engineer or what have you. So we need to take what we know is wrong about it and change that for the better so that these types of devices are not our enemy. Thank you very much.
Thank you very much, Chris. This is a wonderful bridge to our next speaker, who is, we have Navid Sayed from TÜV. This is in German Technischer Überwachungsverein. And for the non-speakers among us is the Technical Inspection Association. And he will be exactly talking about a bit testing, audits, and certification, and bring a bit the private sector and what is actually all their possibilities. Navid, I think you are online. Yes.
Yes, I see you here. Hi, yes, I am online. Oh, I hope I'm not on the big screen. So, hi everyone, and thank you for having me. And I will basically start with something else, not with certification from the beginning, but basically only today, even today, only a few companies are actually following the principle secure by design, which basically means, if you think about secure by design, it basically means manufacturing IoT devices in a secure way from the beginning in the areas of people, process, and technology, and of course also covering the whole life cycle of a product. If we want to go into details, if you talk about people, you of course should make sure that your people are trained in a secure way so they can develop actually IoT devices in a secure way. They have a security awareness. If you talk about technology, as mentioned right now, we should make sure that technology which is used in IoT device is secure. Of course, we shouldn't use outdated encryption algorithms, for example. And if we are talking about processes, of course, we should definitely make sure that we are following a secure development process, which then again includes, of course, security testing, scanning, of course, and maybe also attack surface detection. Of course, if we do this on a continuous basis, IoT device manufacturers can make sure that their that they identify vulnerabilities very fast and they can mitigate this risk, which of course then helps them again to reduce cost because they don't have to fix all the findings before go live. So again, if we telling you the benefits of secure by design or what is secure by design, why do I think that a certification can help? Of course, a certification will never stop a hacker or eventually stop a hacker from penetrating your system. But where certification can help is basically making sure that all manufacturers of IoT devices are basically following these principles. Because basically, for example, if you could only enter the market if you have a cybersecurity certification, we could make sure that everyone actually is following these principles and there are no low-hanging fruits anymore in your system. And that's it, actually. I wanted to keep myself very short.
That was really very short. Thank you, Navid. But you actually approach quite a lot of you throw actually quite a lot of buzzwords to us and to the audience. I think we've been all now talking about different elements. So we talked about security by design, which is basically when you start to design a product, you think about security or privacy by design, which is actually also now under the GDPR an obligation for manufacturers and service providers. The question is also about how to, we're all talking about different elements like education, what Martin mentioned, apologies, the different global dimensions of ethics. That's why, for example, the question of well-known norms as human rights and users' rights to be actually the angle how to see and to approach IoT. The question of being aware of what I have at home and what I'm wearing or using can be actually misused, but also, as Navid said, the different elements of the continuity. And I think this is something that about certification, there is always like the question of what is a certification? The question is when I see policemen and policewomen on the street, I feel secure. But that doesn't mean objectively that actually the security level is actually constantly low. So this is the same with certification. Certification is a momentum where you have requirements you fulfill as a product or service, But that doesn't mean that afterwards you're secure. Vulnerabilities could be unknown before that and then appear afterwards. So that's why I would like to challenge a bit my panel and to think about what could be. We talked about what the different perspectives right now. We tried to address the different elements for users, for private sector, for public sector, what also Chris mentioned about the question of certification, regulation. But I would like also to know what could be solutions. So anybody wants to dare, but also the audience here, please, if you have any questions. So do we have to regulate security? Is it something, it's an awareness? Is it something that we need to be constantly aware and educate nonstop? No? Okay, Martin.
Sure. The answer is clear, right? All of the above. We cannot solve this with a single solution. That's very clear. Being aware and educate is a key part. Partly this happens because of media reporting on it. You really should take care. And in this I refer back to the time that PCs came in the households, early 90s. Nobody made a backup until they became more important and people started realizing that a PC that crashes is really a problem if you lose your data. Now it's normal. We store it in the cloud at the minute that we create it. And such things will happen here too. It will take time and people need to be aware and take their measures because they become aware that phishing, for instance, is also something that you should think about. The stories in media about people being blackmailed, people being extorted because of these kind of emails help other people not to fall in the same trap. And I guess the new generation also, I hesitate to range me in the same generation as everybody at the table here, but the new generation will be more aware automatically of what these risks are, and they should be made aware. Talking amongst peers, but also in education. Producers of the IT devices will need to take their responsibility. So far, it's like the pollution. People never had to pay for the pollution that their products caused. It was never part of the price. Now you get taxation on top. Maybe the same is for making producers that deliver insecure devices pay for their failures. So in that way, you see that both standardization, certification, good practice come in. What can you expect from partners in the value chain of delivering these services that are attached to these devices? And last but not least, government will need to step up, particularly when needed. A recent example is GDPR, where for many years we talked about privacy, and insufficient action was taken. This forced the government to take measures that are far-stretching. They're not perfect, but they came because the industry didn't manage to regulate it itself. So I guess that's a call and a warning also for all of us that make money by offering services that people want, to build that now in from the outset.
Thank you, Martin. I see Amgard.
Yeah, well, we all know that laws are not necessarily the panacea that will fix every problem. However, I remember vividly that we developed lots of privacy-enhancing technologies in the late 90s, early 2000s, and nobody wanted to buy them. And the reason was that it didn't cost anything if you violated data privacy rules. On comes the data protection regulation, and all of a sudden we have this interest in privacy-enhancing technologies. How about that? Yeah? So I found that very interesting, that it was, so to speak, a catalyst for privacy by design to have this law. The other thing that we will see is that in IoT it will be very much important to see who is responsible for what, and that will be decided by courts and by insurance companies. Because the insurance companies, needless to say, are working on the question of what can you insure and what can you not insure in the whole IoT chain, especially, not, of course, in the industrial IoT, but also in the consumer IoT. So therefore, while laws are not so to speak, the fix-it-all. Sometimes it helps, not always.
Thank you very much. Great. I think I heard recently that insurance, especially, I don't want to make advertisement for anything, but cybersecurity insurance are obviously getting very popular, and that makes exactly companies force them to foresee some security processes in-house, because insurance just say we want secure you if you don't have it. So interesting that you mentioned now insurance and courts. That's an interesting checks and balances approach. Estelle, I see you.
Thank you. A little bit in the same line that it was mentioned that obviously laws and regulation are not necessarily always the answer to everything, but they were partly an answer to a failure in the market for the companies to comply with their positive obligation to protect those rights. I think not only it's useful in that sense, but also to give certainty to users that no matter if it's baked into law, that there is an obligation to protect security, data, and privacy. It provides more confidence to the users that there is at least some minimum standards that needs to be there, and if in case of failure, there is also a remedy mechanism available. And I think the point that we need to make sure is that those laws or those measures, in particular around security, are technologically neutral and not imposing specific standards, but just put a positive obligation on companies developing those products to always protect it.
Thank you. Max, do we have something on the online?
No, not so far.
I'm just asking Navid. Oh, Navid raised.
Oh, sorry. Navid just raised his hand. So
okay, thank you. Navid?
One moment. We can't hear you yet.
I think I will repeat myself a little bit, or repeat what my colleagues just mentioned. Is basically, I think the regulatory body should enforce cybersecurity for a simple reason. If you look at the manufacturers of IoT devices, the reason probably they are not pushing for cybersecurity in the development lifecycle as much as, for example, for other things is, I think, very simple, because at the moment customers are probably not asking it from them. So therefore, why should they invest the money to make the IoT devices secure if nobody, at least not the customers, are asking it from them, and it basically makes the IoT device more expensive. Of course, cybersecurity is an important topic. Therefore, in my humble opinion, regulatory bodies should push or even enforce cybersecurity into the development lifecycle of manufacturers of IoT devices. Thank you.
Thank you, Navid. Chris?
Yes. Now, one of my angles is I definitely don't want to hinder our technological advancement, but we also need to make people aware of the risks that they face with these different types of devices. Now, going on to Ludmila's earlier point about awareness, many of us are taught from a very young age different ways to keep ourselves physically safe. However, that is not done as much in our digital world, even though our digital world is taking over more and more our physical space and becoming part of us. With the advancement in technology, looking at the next type of communications protocols beyond 5G into something called 6E, that would enable IoT devices to be placed inside our bodies. And we're still struggling with how do we represent that risk to the everyday person. Now, there's a very good example that came out of the United States. It's called SBOM, or Software Bill of Materials. When you pick up a produced piece of food, such as a bag of potato chips or a bag of crisps, you see an ingredients list, where in that ingredients list, you will see certain things that are what we would say a description of the open source materials that are used, such as a carrot, such as a potato. And then you also see proprietary things that are not immediately divulged, such as flavoring agents. And one of the things behind the software bill of materials is to say, please list the open source libraries and things that make up this particular product, while at the same time you can still maintain intellectual property rights by keeping proprietary source code and elements of that source code private in a way that we could then all understand. Now, Ludmila had made a point while we were prepping for this that it would be nice to see a way that when we purchase an IoT device for even a Black Friday sale, it might have an image or an icon that shows how either secure it is or how much privacy has been baked into it to begin with, so that you know visually immediately if it's a higher risk thing or it's a lower risk thing to you. And last week I was presenting one of the keynotes at the Dutch Police Technology Days. And that presentation won't be shared publicly because of some items that I unfortunately found. The police now use body cameras. And also teachers in some countries use body cameras in certain types of schools. And one of the things that I found was quite unfortunate, but a major vendor of body cameras, their IoT devices and also their IT systems that connect to those body cameras for those images to be uploaded and processed were exposed to the internet in an extremely open manner, and also exposed actual police officers' private information. So here we think that we feel more secure by having more police officers, but because they're wearing IoT devices, that actually places us more at risk because the systems behind are not required, at least right now, to have security by design. And unfortunately, that also leads to privacy matters. So imagine if you found out that in your school, your children's school, the body cameras that a teacher might be wearing are uploading images insecurely that anybody could see images of those children. So we need to address some of these things because there are going to be billions more of these particular devices out there, more and more and more. And so we have to look at the simple fact that we all need to understand the risk in a clear and concise manner. Thank you very much.
That is already built into the Data Protection General Directive.
You want to?
I'm sorry, but privacy by design is already built into the Data Protection Directive. So that is a lack on the on the manufacturer rather than on the legal requirements. So who sues this guy?
Well, not every country that produces these devices have signed on or really agree with a lot of the EU GDPR principles, which is also a problem.
But if you sell that thing in Europe, you have to apply it to the Europeans, and therefore the data protection regulation holds.
We have just, I think Max have done something very useful, have put together some halftime conclusions, maybe just to warm you up, because I really want you guys to come up and to say something. There are a lot of microphones standing around, so just stand up and go to the micro so we know that you want to say something. Max, you want to?
Yes, thank you. So, as Lucy mentioned, I tried to distill what you said, and I don't claim at all for this to be complete, but please do point out what is missing and what we should add. If you could switch to the wiki. Yeah, so this is the wiki page that I had mentioned earlier, and it has the updated planning for today, and then down here it has some notes about the flow, and at the bottom is where I started to type, and I heard that what is needed is really a mix of different elements, right? Of governance tools, technology, awareness raising, education, literacy, were some of the things that were brought up. So I listed them a little bit, listed those below: privacy enhancing technologies, create laws that force security standards and push, so I definitely need to edit that. Punish misbehavior is what that should read. And I think what is the most viable option for a multi-stakeholder group like the one that is up here and that is happening at the IGF would be some kind of nutrition labels were just brought up, or seals. right? And then best practices in this space that could be promoted, default usernames and passwords to ensure those are of high quality, coordinated security updates, devices should be secured through automatic updates where feasible, and having an end-of-life plan. I think that's at least tidbits of what you guys brought up. So maybe now we see the first comments from the floor. Please help us. You can edit this as a user of the wiki. Thank you.
Thank you very much, Max. Okay, thank you for breaking the ice. Go ahead, just maybe introduce yourself.
My name is Bert Castell. I'm from the US, originally from Europe. What about distributed security processes? So instead of looking primarily at regulations, looking at technology to solve the problem. And what I'm thinking about is something similar to how Bitcoin blockchain technologies address banking issues and security issues, of course, introducing different ones, so it's no panacea, but still distributed access controls that are governed through consensus mechanisms that are mathematically controlled. So for instance, in your house, all your devices could be linked to your identity. The devices you're wearing can be linked to your identity and to other devices. And you can combine this with encryption, like proxy re-encryption and so on. So I don't want to go in all these technical details, but there are projects out there that are addressing security and privacy in totally different ways, leading to different challenges because they're all just being created, but there are technological solutions to some of these problems.
Thank you very much. Anybody wants to react on this? Martin?
I think you will need to look at that as we look at the internet today. The internet is a network of networks, and I think it's really about the applications that you talk about and how they deal in that specific ecosystem with security. And sometimes blockchain may be a solution, other times it may need other solutions. We already have examples today of, for instance, a car that is a combination of IoT devices with its own security system, an airplane. But I can also see for different services that this will emerge. And my prediction is that we'll have several solutions working together.
Thank you. I think on the blockchain there is still in a very experimental stage where we are, and I think one of the most of the biggest challenges of blockchain is probably the energy consumption. In order to really use it for specific, then you have to use it for very specific issues. Most of the companies are experimenting with this, but the question is then, I allow you a very ad hoc remark because we have already a gentleman here standing. So
I'm not talking about using Bitcoin and the world's energy to solve the problem, but I'm talking literally about a group of devices that are linked together and governed by the same principles.
Thank you. Please.
My name is Jacques Beglinger of Swiss Holdings, or the Association of Swiss Globally Operating Companies. And these companies, we had exactly 20 years ago already quite an interesting moment, which was preparation for the Y2K bug. And I think we can all be grateful for this event because this showed for the first time what really, and in some kind of a test case, it was an announced catastrophe, how the failure of essential systems might work out, and thankfully it didn't. But thanks to much preparation, I see that our companies are today going back to the planning, contingency planning of that time, and also they gained quite some knowledge about tackling such situations. But actually I have a totally different question to the panel, which is on open source software. Quite every product has open source elements in it. And according to the panel, who should be responsible for that?
I am at the right now, I'll be silent. So.
So I'm all for open source, and they can have a lot of different benefits, but we also have to be concerned with the fact that a lot of the open source projects that are utilized actually are not very well maintained themselves, and you also can't provide very much, if any, integrity that the open source code that is being used has not been tainted in some manner. And this is also a concern when we discuss the use of open source. A lot of IoT devices use a lot of open source because there, again, it's a cost savings. But at the same time, the average aircraft right now uses over 400 open source libraries. That's Boeing, that's Airbus, and so forth. And there are no controls on who can manipulate and taint those open source libraries.
So would you say that there is some kind of, I won't say regulation or control, but maybe self-control necessary, or?
Sometimes there is, but at the same time, the EU recently started a bug bounty program for certain key open source projects to find any sort of exploitable vulnerabilities and report them on things like open source SSL and things of that nature, because they don't want them to be manipulated because they're used in so many different devices, from your smartphone to an airplane to a car to a burglar alarm to a regular system like the ones we have on the desks. So pushing for some of that in a positive way, I think, would be one of the solutions to the security challenges and integrity challenges with open source libraries.
Okay, thank you very much. There was one question raised to the panel in between, namely how to deal with the IGF wiki. We will do this at the end. Maybe Max can explain at the end how to go to this wiki. Oh, I see another gentleman. Please.
Hi. Back on the same vein as the bug bounty for. Oh, sorry. Jack from Australia. Back on the same concept as the EU public bug bounty for open source. Given how much reliance there is on open source software, especially like OpenSSL, Boring SSL, and the like, does it make sense for it to be publicly funded so that there is proper maintenance of critical infrastructure, open source like that?
I'll take this one. In my personal and professional opinion, I would say yes, because we're so absolutely reliant on some certain core key open source projects. So yes, I would say we should start looking at public funding for some of the things that are key to our modern world.
Thank you very much. I will try to bring back, maybe, I don't see anybody. Oh, sorry, you're exactly under the light, so it's kind of like, please go ahead, thank you.
Yes, my name is Mukama from Cameroon. So whenever we talk about solving a security problem through regulation, I cringe, because we all know how we haven't been able to solve the security problem on the normal internet. And I think it goes back to the business models that the IoT providers and the purchasers of the IoT services operate around. With the exception of a very few gigs, no one goes to buy a product and the security implications is the very first thing in their mind. They just want a smart home. They want to be able to open the garage remotely. So those other considerations are secondary, which brings me to what it's not even possible. Security is a process, an ongoing process, not an event. And when we talk of regulation, we are looking up to governments. These are people who, their understanding of the things that will lead to most of the security vulnerabilities we are aware of, it's actually quite questionable. And the processes for updating regulation to meet reality is not necessarily the fastest. So I think that is not really a good idea to start trying to come up with regulations around security, which to me then says the best thing to do is education, because once people understand that, yes, even though when you go to buy something, you don't look at the security implications, it is possible to both get what you want and be secure, because privacy is as valuable as being able to, the utility, the primary utility of your product. So education and not regulation.
Thank you very much. I think you raised a very important element that actually regulation is something that only helps mostly when there is market failure. The questions on the security side, if not a peer review or peer kind of when companies are actually offering secure products, actually people will probably just have more trust on this. And I'll just want to bring back, because we're going a bit towards a very technical discussion, which I found it extremely amazing. But I would like also to go back, and Estelle already read my mind, to come back to the users and what are the user expectations? Do I need actually something to be very secure, or just buy it because it's very cheap? So this is something that maybe you, Estelle?
Thanks. I agree with some of the points that were just made, that education is an important part and regulation may be slow. But I'm not sure that regulation is only necessary when there is market failure. There are some obligations that private companies has to comply with, and we've just seen that if we don't put it a lot of time in binding obligation, they just do not happen. It's unfortunate, but that has been, at least from a European perspective, a lot of the reality. And having those, having obligation to provide security, not having detailed rules on how exactly you make the product secure, is positive for the users, but also that's actually what has led to the innovation in that sector. Arguably, we have been having a lot of the data protection rules which are under the GDPR in Europe for more than 30 years, but there was now a lot of innovation on data protection by design products. But it's only when the regulation came that there was this opportunity to be there. Nothing prevented companies to do that before, but when you create those obligations, you actually create the opportunity for innovation. And obviously education is an important part from the user perspective, but just that would put too much responsibility on the side of the users to go have a look. And so it's great to have more transparency, and there is a part of awareness that is important, but alone it cannot really work, and we need to make sure that there are some security obligations that exist.
Can I add something? Okay, Martin Armgaard.
No, just a little bit on that. GDPR, again, is a good example. It weren't that much new obligations. But what happened is that there's a real price when you get caught for not living up to it. So the risk of not living up to it goes up so much that it's worth a couple of % of your turnover to really invest in it and live up to it. So I think what you say, the basis of technology neutral regulation that comes with functional requirements of good care make a lot of sense.
I think that what Estelle actually fits with what Armgaard said at the beginning, that there were in the 90s already privacy-enhancing technology developments, but nobody really took them on board because there was not the demand on this. So, Armgaard.
Yeah, basically somebody in a focus group said to me, I think this is really useful. I will implement it if the government forces me to. Otherwise, my budget is so stretched that I will not spend a penny on it. So that was a situation back then. With regard to laws and technology and requirements, Martin is right when he says it has to be technical neutral, because laws take such a long time. By the time they're passed, the technology is way somewhere else, and we saw this with the 10 years that we spent on the review of the data protection regulation. So that was a funny thing. With regard to distributed technologies, yes, there are several things out there and lots of very good concepts. I remember we once developed something which we called the sticky policy paradigm. So once you were to define your settings for privacy, this would go with the settings or your preferences would go wherever you went on the internet. So you didn't have to each time log on and do something, but it would be, so to speak, automatically done for you, which for the users would be very helpful and nice. And like many other things, it's more of a concept than that it has seen the reality so far. So if we were to put together all the great ideas that already exist and put them into practice, we would be just fine.
That's nearly a great final word, but we still we will still discuss a bit more. I'm trying to challenge also my panel and the audience all the time. So maybe think about, I think when we're talking about all the different elements, as Martin said, please do everything what we just said before. Greta is saying just do everything what is already there. The question is the balance, and maybe when we have, I give another example in another topic where self-regulation helped a lot when peers actually set some best practices, and there were companies not actually following these practices, but the moment there is a self-regulation, a kind of a public promise to deliver on this with the code with the conduct, which is something that the peers, the companies among themselves are setting as, would be this something that could help and I fully agree with the last speaker that actually cybersecurity is it's not a final condition. Cybersecurity is a continuous process where actually you need constant monitoring, constant development and innovation, which cannot be only served by certification for certain devices. And maybe here where we're going now for the next steps, to think about that we need different approaches for different devices and for different sectors, but also to think about the different international approaches around the world, how we can solve it maybe technically without entering the question of international norms in cyberspace. So these are the different, that's why for me the question self-regulation, would be that something that would help? Also trainings, for example, would be, for example, coding should be maybe obligatory at school, so people can understand what happens and how the development. On the other hand, as we said in the panel, there was there is a lot of knowledge, and as Chris said, technological knowledge, where we don't want the user to be burdened with. So the question is, and Max, I think you have Navid.
Navid would like to come in. Can you switch the screen, please? No, the other one. There you go. Hang on,
I wanted to say is basically I would also agree that the regulation must be, let's say, technology independent, so it shouldn't tell you what to do, but it should tell you at least to follow secure by design principles. And of course, one thing which is necessary is awareness. And I think it was just mentioned that coding in school, or just basically awareness in school about data protection, about cybersecurity, and about technology, because it's not just cybersecurity is an ongoing process, technology in general is an ongoing process. So of course, there will never be the one state where we can say we are secure, and if you're following this test, then you are secure. No, we have to continuously monitor, we have to continuously test, and we have to continuously develop actually also the processes we are following and the methodologies we are following. So, and again, to one thing which was also mentioned, I think then, of course, there needs to be a risk, let's say a layer of risk where we say specific IoT devices which could harm a person needs to be certified and needs to be tested more than other devices, and also maybe continuously tested. And of course, there could be IoT devices which don't cause any harm or can't affect you in any way. Then they probably don't need as much cybersecurity assessment as an IoT device which potentially could harm you. Thank you.
Thank you very much. I see another gentleman here on the micro.
Thanks. Calling me a gentleman, I think that's probably a slight exaggeration. Michaela Nealon from Ireland, Black Knight. We're a hosting company in Ireland called Black Knight. I think this is a very interesting and worthwhile discussion, but the idea of self-regulation is possibly a little bit naive. The cost for producing a lot of IoT devices at consumer level is incredibly low, while the bigger manufacturers might be in a position to set certain standards and regulate at the level that we need. I can't see that happening with the smaller creators, the guys who are going on to Kickstarter, Indiegogo, and are going off and buying the cheapest components and using the cheapest staff to write the code. So I think the focus really needs to be on education, raising awareness, getting people to ask questions, to ask, what should they be asking these suppliers? Is the thing up to date? All of those kind of questions. But this room is full of people who are quite technically aware. How do we bridge the gap to the people who aren't technically aware? I mean, you look at the IoT devices that are being sold to us now. I mean, go on to any of the Amazon websites at the moment, and they're pushing a whole range of connected devices as part of their Black Friday sales. They are not targeting technically aware people. They're targeting the average user, the average consumer, who just wants to plug something in and get instant satisfaction. So how do you, you can train somebody to change the oil in their car, but we've all failed in industry to train users to update their laptops, keep their website CMSs up to date. Expecting them to actually ask questions about open source libraries in an IoT device is pie in the sky. I mean, it's just not going to happen.
Thank you for this for the reality check, and I like the user expectation, like getting into satisfaction. I think this is a very interesting approach, but you're absolutely right. This is actually what we actually all want to just use the service or use the product. There is a question over here. Yes, please.
Yes. Viola Schmidt, Technical University. I'm a law professor. And first, I'm a digital immigrant, and for me, a regulation of security of IoT is uncharted territory, as our chancellor once put it, Neuland. And a second statement I want to make and share with you, we live in a transition period, meaning not everything is digitized. And so perhaps now we discover the advantages and efficiency and effectiveness potentials of things of the real world of the past. And because this is uncharted territory, I want to confront you with my research on interactive toys. You perhaps know about Kyla. Mm-hmm. Yes, Kyla. So it was prohibited in Germany, and then Walmart took it from the shelves in the United States, according to my research as well. But the point is, there is the spyware in your nursery, and if governments, and in Germany, an agency prohibits the sale and usage of these toys that grandmothers buy for their children because they think we want to be up to date. This is not, and they have to destroy it afterwards, and we don't enforce it. This is not the best way how to deal with it, and that's why I want to challenge Estelle and Massi with your approach as a law professor and human rights and data protection. I'm not into data protection law only, I'm in cyber law, and then I'm in protecting human beings. And perhaps we could advance a differentiation between pro-cyber protagonists, and they simply want to take the risk with Kyla. Yes, they love it. They love it. And others who anti-pro-cyber protagonists. And we shouldn't only focus on these people that I call anti-cyber protagonists who want to have data protection. We also should include into our human rights perspective in a new cyber and AI law people who really want to participate with cyberspace on all opportunities, taking more risks, sharing more data, as a lot of people of my generation have ever envisioned before. And I don't want to, only want a differentiation as a scientific thesis and not a devaluation or high appreciation of either category of cyber citizens. But innovation, Neuland, not stymieing progress, and taking into account different kinds of people, of data subjects, of cyber citizens.
Thank you very much. We have then now certainly only 9 minutes left, and I would like also to give the panelists the final word, but we have one comment online, which I would love to hear.
Yes, so Luke Seufer recommended that we should look into security by design as an important approach, and in particular the NIS directive that might be known to the experts.
Yeah, I would start with the final words with Martin, because he has to leave 5 minutes earlier for the main stage. So Martin, if you have a kind of a wisdom at the end.
Well, it very much like what the lady said. Sorry for not remembering your name. But you're right, this is a transition period where we have to get used to an environment which is increasingly digitized. And it needs to be. There's no way back. We need it if we want to use this space we call the world together well. So it's not about do we want it or don't we want it, it's about how do we make it happen in a responsible way. I'm afraid that regulation is needed as a backend. The point here brought in by Estelle that to be technology neutral, it's like in cyberspace as in the real space in a way. There's no difference in what the real meaning of the law is to protect us as people from abuse, basically. At the same time, the risks are different in a digitized world, and we really need to realize that. And there are several aspects that we will need to address in the years to come. I think really making it risky to put people at risk that buy your products will be a good incentive for producers and for service providers to think twice of how they want to offer their products and their services. And I think that's an essential part. The other part is essential in chain thinking, because we do go across borders. We cannot solve this in one place alone. And with that, I think following the transition recognition, there will be more to address in the years to come that we are not aware of yet today.
Thank you very much, Martin. Estelle?
Thank you, and thank you for your question. I think from our perspective, when I talk about building a human rights approach into the digital age, that's not from a perspective of being afraid of those innovations, but getting the most benefit out of it and make sure that it's sustainable. And that's, I think, how the internet and a lot of technology has been built to be open, secure, and free for all, free in the freedom sense. And not everything has developed that way. And by building the human rights approach into those technologies, it's just making sure that what was intended remains in this sense. And it's not saying that when you call for human rights or you call for data protection, it means that you don't want to use those products. You want to make sure that when you use them, you're not going to get harmed by it. So I actually do think that this human rights approach is actually a perfect fit for those who want to take the full benefits from those developments.
Maybe just to add, human rights are not able to be waived. So, like Armgard mentioned, privacy-enhancing technologies is something that actually, without users to know, they are actually unable to use their rights because manufacturers built in privacy-enhancing technologies. Chris, your final words.
Yes, I should add that one of the articles in the EU GDPR actually states that they must demonstrate security. It does not stipulate at whatever level, it just must demonstrate security. On the other hand, when I was with Aramco, one of the projects that I instituted was working with our legal department to look at our contracts to ensure that the technology and our third-party suppliers also had to adhere to things like a secure software development life cycle. because we knew that the EU GDPR was coming, and we wanted to ensure as a company that we tried to be prepared as much as possible, because we couldn't just hand over the liability and risk over to third parties, which is also stated in the EU GDPR. So we do need to be aware of that. And just before I finish, I've got cards for everybody as you're leaving, or I'll try to set them out, but I have to run to another workshop as well, which all have real-world case studies. I've just changed it around a bit. And one of the things that we would like you to do is to take these back and think about them as decision cards. And I'll ask Max if he wouldn't mind later on putting them up on the wiki as well, so that everybody can see a lot of these different questions. Thank you very much.
Thank you very much. Amgard?
Yes, I would like to come back on the question of consumer education, because I think it's really an important issue. We see a lot of things on the internet as well as put out by agencies like the German Bundesamt für Sicherheit in der Informationstechnologie with the IT security agency. For example, recommendations for smart home security. ENISA has put out something on recommendations for smart car security. So there are tons out there, but you're absolutely right, it does not reach, so to speak, everybody. Now with the digital natives coming into age, that might change a little bit because of their interest, etc. However, we also do have something that is, so to speak, testing of these products already. In Germany, it's Stiftung Warentest, who just in the last edition tested wearables and smartwatches. But what we will see is consumer agencies, protection agencies with class actions. And that, I think, will make a big difference as well.
Thank you, Amgard. Navid, remote, 2 minutes.
Yeah. So basically what I wanted to say is I think the important thing is basically just making sure that more manufacturers of IoT devices are following secure by design principles, and therefore consumers of IoT devices can enjoy the digital world in a secure way. And therefore we should spread the awareness that cybersecurity is important. And yeah, I still think that regulation can help. So thank you very much for having me.
Thank you also for being remotely, so full 21st century here on this panel. I would thank you all for being here with us. Few maybe last remarks from my part. Regulation, self-regulation. So we talk about a lot of different moving targets, I would say, that depending on the different sectors and devices we're targeting, there are different requirements necessary. The question of the user perspective, from human rights perspective, from company perspective, but also the question of maybe if IoT change privacy understanding, what Estelle mentioned at the beginning, that actually when IoT devices are recording my communication, they're recording automatically someone else who is with me in the room. And then, of course, the question of data protection and privacy as well. But maybe also IoT will change our understanding. It's not a kind of a binary dimension, and I am producing something, you regulate me, but also the whole chain of software developers, of manufacturers, users, suppliers. So I think this is a lot of the question of responsibility, but also the question of cyber hygiene. We didn't mention this word today, but I think we were talking a lot about the user, what he or she can do, and also not just put the password on a post-it in front of the PC, but maybe think about it to use some different passwords or even two-factor authentication. The question also, what was very interesting for me today to hear, we talked about a lot of, in a cybersecurity, in a security workshop, a lot about privacy and data protection. So we mentioned a lot, we referred a lot on GDPR, which turns to be a technologically neutral regulation, but also that both are the two sides of the same coin, that the one is not possible without the other. I would ask, so first of all, if there anybody who wants to engage afterwards, we're still here to come to us to the panel. We will explain also the wiki. It's, if I'm not mistaken, intgov.wiki.
So it's intgovwiki.org. And I've actually put my email address next to the notes if you have to run now but would like to engage in the follow-up. In typical IGF manner, of course, we could have only started the conversation today, but I think it might be interesting to have a conversation that starts now. Also, I would like to point out that tomorrow the IoT Dynamic Coalition has its meeting from 9:30 to 11:30, if I'm not mistaken. Martin will chair that meeting, and it would be nice to build on the discussion today and to have some continuation on that level.
Thank you, Max. So, as we said at the beginning, we're just starting the discussion. We're trying to take into consideration what was discussed in the past, but also maybe to be a bit more brave and to formulate some questions and to go further the next steps, what expects to be the next future. Thank you very much for joining us.
tarafa geçecek mi? Şu ikisine geçelim.
platforms.
Big problem. You know, even for eating,
So, good afternoon, everyone. Thank you for being here and one of the last sessions of the day. But I'm sure as you are going to see it, it's a very interesting and perhaps even unique session considering the style of the Internet Governance Forums. It's not very common to find judges around and other judicial operators. And in this session, you will have the privilege to talk with 4 of them from 4 different regions. So in my far right, you have Adeline, who is a lawyer specialized on internet and technology issues from Malaysia. She will offer to us a perspective from the Asian region on those issues. Here I have the privilege to present to you Judge Darian from the European Court of Human Rights. But in his past lives, very much involved with civil society all over the world on freedom of expression and access to information issues. Judge, thank you very much for your presence. Here I have my friend, Justice Edouard Assante. He is currently the president of ECOWAS Human Rights Court in West Africa. And we also have with us Judge André Gustavo. He's a judge from a high-level appeals court in the state of Rio de Janeiro in Brazil. So as you can see, we'll be able to have an experience from Latin America, from Africa, from Europe, and from Asia in this very interesting issue of how to connect the challenges of rule of law with the ecosystem of the digital world. And we intentionally use the word ecosystem in defining the title of this session because we do believe it's not one single issue. It's a myriad of issues that are related to the work of judicial operators. Either they are judges, prosecutors, lawyers, public lawyers, private lawyers, and that is the aim of this 1 hour and 30 minutes that we have to discuss with all of you in this room. So after this session, we'll move like this. We'll start with introductory remarks from my dear colleague Cedric from our headquarters in Paris. Then we will have the presentations of our 4 special guests. And then I have the privilege to count with the presence of 3 co-organizers of this session. My dear friend Sebastian from ISOC. He is the regional director of ISOC for Latin America and the Caribbean. My dear compatriot from Brazil, Monica from Facebook, who is also offering the perspective of the private sector to this. And then my dear friend Agustina from CELE, as many of you know, a think tank based in Argentina. Okay, that's all. So Cedric, you have the floor for introducing us to this issue. Thank you very much.
Thank you, Guillermo, for this introduction. Dear Chief Justice Edouard Assante, dear Judges Darian Pavli and André Gustavo, dear Adeline, Agustina, Monica, Sebastian, ladies and gentlemen, dear members of the IGF family. For UNESCO, it's a great pleasure to co-organize this highly relevant session for the complex puzzle of protecting and promoting human rights in the digital environment. Over the past 70 years, the Universal Declaration of Human Rights has stood the test of time and demonstrated the enduring universality of its perennial values of freedom, equality, justice, and human dignity. These are the very values that must guide us in our response to the numerous challenges which arise in times of an increasingly universal internet. In a multi-stakeholder ecosystem, we should acknowledge that a particular group of stakeholders is a central piece of the puzzle for guaranteeing the rule of law. Judicial operators, judges, prosecutors, lawyers, are and will be more and more involved in the decision-making process of protecting digital rights and of solving inevitable disputes that take place in the digital arena. That's why it is a privilege to have two magistrates from the international courts, one from an appeals court, lawyers, civil society organization, and private sector representatives in this workshop. The dialogue we will have here today is one that must continue in the public sphere, is particularly relevant to better understand the challenges of the national, regional, and international systems in dealing with a growing number of cases related to the internet ecosystem. It is safe to say that at this point in time, we already have a voluminous jurisprudence underlining how the judiciary everywhere is dealing with internet cases. But are the decisions taken in line with international standards of freedom of expression and privacy? Are the key principles to guarantee a rights-based, open, accessible, and multi-stakeholder governed internet being upheld by the courts? If not, what are the challenges involved in getting better decisions? And I mean with better here in line with the international law already endorsed by the United Nations member states. Dialogues like the one that is about to start is one way of addressing these questions. We should stimulate them and guarantee that they are held on a more permanent basis. I would like to start this afternoon's workshop with good news. Judges, prosecutors, and other judicial operators are very much interested in these subjects. UNESCO, in alliance with many partners, has started a global initiative to foster the capacity building of judicial operators on freedom of expression, access to information, and safety of journalist issues, with a special focus on freedom of expression and privacy online. In Latin America alone, where the program started about 6 years ago, 13,000 judicial operators were already involved with the training opportunities offered. These results tell us less about UNESCO's merits and the one of Guillermo, who's been leading this initiative, but much more about the demand from the judicial operators everywhere to engage with these fundamental debates. I do hope and trust that your discussion today will contribute to generate fuel to keep this flame burning, and I see a very full room, so there's great interest in this particular session, and I thank all of you for joining and the panelists, of course. Looking forward to the discussion.
Thank you so much, Cedric, for this introduction, and thank you for finishing with this good news that judicial operators are interested in this issue. So we are a step ahead. We don't need to convince them that those questions are important. And I would like to acknowledge the presence of the Special Rapporteur of the Inter-American System here, my friend Edison Lanza, because the program in Latin America is very much developed in straight partnership with his office, and he does not allow me to lie alone here, that the judicial operators in Latin America are very much engaged with this training, actually demanding more. So I think this is a very important initial setup for us. So I will start with Judge André Gustavo. As I said, he is in what we call in Portuguese a desembargador, which is a title for a judge that is a member of our appeals court. He will speak first because he has an important issue that came up suddenly, and he needed to make his flight earlier than initially planned. So unfortunately, at some point, he will need to leave us because he needs to be in Rio de Janeiro tomorrow morning, 8 a.m. So it's a crazy thing, but we thank you so much for not canceling your presence and being with us here today. So, Judge, you have 10 minutes.
I think something disappeared, my presentation. I don't know. It's a bad start, but
support. We need the presentation.
Yeah.
Perhaps we did something here.
Okay. Here we are again. Okay. Thank you for having me here. It's a big pleasure. It's an honor to participate in this event, especially because it's an event that gathers people for different background. So for a judge, it's especially interesting to learn and to share the experience about internet, our perspective, and to understand the perspective of private sector, of government. And so for me, it's really, really important to be here. So I'd like to talk about, of course, internet. This is our main goal. But we cannot talk about internet without talking about freedom of expression. I think these are connected topics, connected subjects. Freedom, Brazilian Constitution, it's from 1988, have a provision of freedom of expression in a very strong way. We can read the Article 5 saying manifestation of thought is free, but anonymity is forbidden. This is the limitation of Brazilian Constitution. And expression of intellectual, artistic, scientific, and communication activity is free, independent of any censorship or license. As we can see, we have this strong statement about freedom of expression. And Article 220 reinforce this idea, saying that expression of thoughts, creation, speech, and information through whatever form, process, or vehicle shall not be subject to any restrictions, observing the provisions of this Constitution. So, as we can see, in the Constitution, we have a strong freedom of speech, a strong principle. And what is the scope of freedom of speech? Well, we talk about freedom of speech, but sometimes not thinking about it. Why is this so important for us? So, in short, at first, promotes the search for truth. We cannot develop as individuals, as a society, and find the truth if we don't have freedom of speech. It is essential for self-government. So, freedom of speech, for me, it's the main pillar of democracy. It's essential for each of us to have freedom of expression as a way of self-government. And it's important for checking government power. So it's related to freedom of press as a watchdog. It's important to have this freedom in order to check government power. And finally, promote individual autonomy. We cannot fulfill our desires, our dreams without freedom of speech. We cannot develop our talents, our gifts without this principle. So freedom of speech is very important, but it's not an illimited principle. There are limitations. And these limitations essentially are in the personality rights, because we have some inalienable rights in the Constitution, like privacy, like honor, etc. So we have to balance freedom of expression with these personality rights. In Brazil, we have what we can call the Internet Bill of Rights. It's a very modern law. We are very proud of this law because essentially this law guarantees the providers the freedom that they need in order to develop, social media, a site, etc., knowing that they cannot be held responsible or liable for no reason. For example, we have this Article 2 talking about the principles of this law. So recognition of the global scale of the network, human rights, individual development, and the exercise of civic awareness through digital media, pluralism and diversity, openness and collaboration, free enterprise, free competition, and consumer protection. And finally, the social purpose of the network. This Article 19, it's in my opinion, the most important article we have in this law, because it says that the provider it can be held responsible only if there is an action, there is a file against the provider, and he needs to be notified that some content of the internet is inappropriate, it's illegal, and then he needs to take it out, take it off. If he doesn't do that, then he can be held responsible. Only this. So it's not possible before hold responsible a provider. So talking about the limitations of freedom of expression on internet, one of the most outrageous things that we can find on internet is a violation of privacy. For example, nude photo leaks. I'm showing here two different artists. One is it's an American, Jennifer Lawrence, and the other one is a Brazilian actress, Carolina Dickman. So why they are here? Because both of them had pictures naked that they are sharing with maybe a partner, a boyfriend, etc. So they were put on internet. So it's a very, very big issue. In Brazil, this issue was so big that we create a specific law that we named Carolina Dickman Law. Because of this problem with this actress, we decided to create this law to reinforce, the privacy, to punish very hard hackers or people disseminating this kind of picture. Another problem we find on internet is violation of privacy, revenge pornography. So we have this concept of revenge pornography, the sharing of private photos or videos of sexual content of another person without their consent and with the purpose of inflicting emotional pain or embarrassment. It's a very bad thing, especially because it mainly affects women. But not only, of course, men can, of course, share some nude photos and be victim of this. And it's very hard to remove all the contents from internet. Once in internet, it's forever. It's practically impossible to remove everything. Another thing is victims usually feel fear and shame, so most of them don't report the case to the police. Fake news is another big issue in Brazil. We are about to create a law. We are discussing a law about fake news. Cyberbullying, it's especially painful for me to say that, but Brazil is the second country in the world with more cyberbullying cases. The first one, we can imagine who is this. And for me, the main topic about the limits of freedom of speech is hate speech. We can be conceptualized as the advocacy of hatred and discrimination against groups on the basis of the race, color, ethnicity, gender identity, disability, religious beliefs, sexual orientation, or other status. In Brazil, hate speech is regulated in law. It's Article 20 of Brazilian law, number 7716 from 89, that punishes the induction and incitement to discrimination or prejudice of race, color, ethnicity, religion, or national origin. The main thing about hate speech, I listed some of the problems. Where can the limits be drawn? Because when we talk about hate speech, we are talking about different kinds of manifestation, not necessarily a manifestation in which the hater tries to incite violence against a group or member of a group. It can be, for example, a racist joke. But there are a big difference between these situations. What groups should be protected? Should we ban hate speech without clear danger? Incitement is required, so we have a lot of questions about it. I know I don't have enough time to talk about the cases, but the thing is, Brazilian courts are not clear about hate speech ban. We have two cases, a very important case from Supreme Court. One of them is Elvanger case. It's about a publisher that was convicted for selling and distributing anti-Semitic and Holocaust-denying books nationally and internationally. The Brazilian Supreme Court upheld the decision. And just to finish my presentation, we have this case. I'm not proud of this. This is our actual president. But when he was a member of the parliament, he delivered a speech talking about the Quilombolas. The Quilombolas are the heirs of ancient slaves. They have protected areas. So they are talking about these people, and he compared these people as animals because he said, I've been to a Quilombo. The skinniest African descendant there weighed 7 arrobas. It's a unit of measure used to weigh cattle, equivalent to 15 kilograms. They don't do anything. I think they don't even serve as procurators anymore. So in this case, he was not convicted because they considered that this speech was a political speech, very inappropriate, but a political speech. In the former case, the publisher was convicted. So we don't have a clear standards about what is and what is not hate speech. So in my opinion, before thinking about banning hate speech, we have to think about the power of counter speech. Instead of limiting the speech, we have to fight hate speech with more speech. So for me, the solution is not impeding or stopping the speech, but giving more speech in open channels and ways for the group or the members of the group to counter speech. And to finish my presentation, I think we need in Brazil specifically a culture of freedom of speech. We need this. We are a young democracy. We have just 30 years of democracy. And we need to create standards to apply in cases related to freedom of speech, because otherwise we have to count on the good judgment of specific judges. And for me, it's not okay. We need security. We need to feel safe and know what kind of decision we can expect from judges. Thank you very much.
Thank you, the judge. So just brief some heads up of what the judge just said, and we would like also to underline, it's very important for you to know, his PhD thesis, it's about hate speech. Yeah. So who wants to later on further discuss this issue that it's very interesting and complex, I'm sure he has many other thoughts on that, but he started underlining the reasons for protecting freedom of expression, not only a right in itself, but also as an enabler of other rights. He mentioned I'm sure most of you know, the very important Internet Bill of Rights in Brazil that has changed the way judges are judging Internet cases after the approval of that law. The Article 19 of that law that is actually being challenged in the Supreme Court of Brazil right now, some parts of that article. Very polemic discussions in Brazil like Carolina Dickman law and other cybercrime issues, mentioned issues as fake news, cyberbullying, and finish with the hot problem of hate speech. So it's a very burning initial menu for our discussions. From Rio de Janeiro now we move to Kuala Lumpur to have a perspective from our colleague from Asia. So Adeline, you have your 10 minutes. Thank you.
Okay, thank you. Good afternoon, everyone. It's a privilege to be here today. First of all, my name is Adeline. I'm a lawyer practicing in the area of technology and media and telecommunications in Malaysia. So the focus of my practice has always been on internet law, internet governance, and data governance. First of all, I have to apologize for my voice because I come from a warm climate, and I think my body doesn't agree with November weather in Berlin. So I do apologize for that. Okay, I'm going to start off by first defining what the rule of law is, and I will be sharing experience in Malaysia and Asia in general towards the rule of law. I've taken the definition of the COE, the Council of Europe, in relation to, in their issues document on the rule of law. And it describes the rule of law as entailing adherence to the principles of supremacy of the law, equality before the law, accountability to the law, fairness in applying the law, separation of powers, participation in decision-making, legal certainty, avoidance of arbitrariness, and procedural and legal transparency. So there's very limited time to discuss this at great length, so I'm going to just cover 3 issues. First of all, this concept of the rule of law is quite easily promulgated when it comes to the physical environment. And that is simply because as lawyers and judges and those practitioners of the law, the law in itself is very jurisdictional and very territorial. So I only practice Malaysian law. I wouldn't know the laws in any other jurisdiction. You contrast that with the internet and activities that are done on the internet, which is extraterritorial, something that is committed in one country, maybe a crime in another country. And because of that, it becomes an issue as far as the application of the law is concerned, because something that's committed in country A may not be a crime in country B, but because of the speed and the use of the internet, things can be done anywhere around the world. So that would be the main issue, the territoriality of the law compared with the extraterritoriality of the conduct or activities on the internet. Secondly, there are also, I think as was discussed earlier, the issue of in relation to rights that arise in the digital environment. And the issue of freedom of expression and freedom of information was raised just now. On this, I'd like to discuss or share a bit about Malaysia's experience on this area. Malaysia is one of the first countries actually in Southeast Asia to put in an overarching or a holistic law on the internet. We had our Communications and Multimedia Act, which was enforced in the 1990s. It's just quite early, considering how the internet just became more commercialized in the 1990s. So in the law somewhat regulated the use of the internet within our country. But at the same time, there was also a very bold policy statement, or so I thought, as far as the government was concerned, because the government took the stand at that time that there should not be any censorship of the internet. So the position that was taken under the law is that, I'm reading the provisions of the law, is that nothing in this act shall be construed as censorship of the internet. So the government at that time realized that perhaps that internet could not be controlled and there should be more self-regulation rather than regulation by way of government through censorship. So there was a very bold statement by the government that they didn't want to censor the internet. I say it's a bold statement, firstly because Malaysia is a very conservative country. We are, I think, mostly majority Muslim country, and our way of life is quite conservative. But the internet amplifies certain ideas that may be against the moral norms or the religious norms, which usually in our society we will censor, we'll try to ban, or we try to control. So the statement by the government at that time that they were not going to censor the internet, I thought was a bit inconsistent with the way that the government had approached banning of or certain statements at the physical level. That's one point. The other thing also is that the political situation in Malaysia. We had the same government for 60 years. And the media was the government's machinery in relation to the government's main political machinery. So to say that they were not going to censor anything, I thought was, again, a very bold statement. But it was enshrined in both policy and also our laws. So the question is, were we true to our commitment? And my answer is we tried to be true. Because at the end of the day, although the provision was there that the government was not going to censor or block the internet, we did, and there was a lot of provisions or self-regulation within the law. And this is consistent, I think, with the rule of law and with how the internet should be approached. But in reality, so for example, self-regulation provisions that were put in place include things like content, the industry getting together to decide what acceptable content was within the country, as opposed to having the government impose the provisions on content. So that was the law, but in the reality, we did in the end, we had to compromise, and there was moral pressure to block certain sites. There was also political pressure. So at the end of the day, even though the provision of the law was there, the government themselves found some kind of loophole to be able to use the law, the same law that said that there was no censorship of the internet, to actually block the internet after a while. So that's just an experience in relation to how our government tried to uphold the rule of law through respecting the freedom of expression, yet at the end of the day, in reality, it wasn't so easy to be enforced. Finally, my final point is really in relation to approach to legal enforcement. I attended a quite interesting discussion a few days ago in relation to access to data by law enforcement agencies. And I found that because most of the panelists was European, there was a presumption in terms of access to data that everyone made, which is that data can be accessible by law enforcement agencies through a warrant, by a warrant only. But in countries like Malaysia, for example, although there are provisions on the use of warrant under our laws, in reality, there's a lot of use of administrative functions in trying to gain access to information. So there are different standards in different jurisdictions, and maybe Asian standards are slightly different from European or American standards. And I think before we can talk about global implementation of the rule of law or global approach to legal enforcement, these kind of standards need to be able to be standardized first. But at the same time, we can see in certain laws that we are more harmonized in our approach. For example, in relation to data protection laws rely on adequacy, which means that one country will treat information the same way as another country. So there is some form of harmonization in relation to laws. And with the GDPR, with data protection law, with the GDPR, the application, the extraterritorial application of the GDPR means that lawyers like myself, who has never really studied European laws, now have to understand European laws, because the laws would apply to Malaysian companies as well. So there is some systematic international application to certain laws, and if this were really to happen, that we have to have, we'll end with this, that if this were really to happen, we have to have some form of international cooperation to make this happen. Thank you.
So thank you, Adeline. A very interesting approach on the difficulties and the difference of applying rule of law in the physical space, in the analog world, and in the internet. But also it was a very interesting your approach on self-regulation and how the government initially, or the lawmakers introduced that as an approach towards internet, but in reality does not work exactly like that. Then the issues with legal enforcement, and this is an issue in many constituencies. One thing is the legal enforcement by a judge or by a due process of law, and the other is an enforcement made by administrative authorities that in many times are not independent regulators, so how this works. And then finally your mention on the importance of understanding and study and discuss international standard and how international cooperation can play a role here. So thank you so much for your insights. And now we are going to move from national courts to regional courts or international courts. And if I may ask Judge Darian to offer the perspective from the European Human Rights Court. Judge, you have the floor for 10 minutes.
Thank you. It's a great pleasure to be here, in particular sharing the stage with colleagues from all over the world. I think from all the panelists here, I probably had the shortest flight. So it's really exciting. And the topic is at a personal, but also at a professional level, quite close to my heart. I guess the big challenge, the first challenge when you talk about rule of law and the internet is how on earth are you going to say anything significant in 10 minutes? considering the breadth of the issues. So I'm going to try and circumscribe the topic and focus on 2 or 3 points. But let me make this introductory point is what's the role for rule of law in this debate, and I would say immense. I mean, the internet affects practically now every aspect of human activity. And that means that there are implications for the rights of humans, of individuals and groups. And at least coming from my perspective as a judge sitting in a regional human rights court, we see these implications now coming before us on an almost daily basis. The 3 sets of issues that I'd like to touch within the time allowed are the following. One is government, direct or indirect government interference, for example, in the form of blocking. Second set of issues is intermediary liability, sort of, again, a huge topic, but I'll try to see it from the perspective of my court, the European Court of Human Rights. And then thirdly, users' rights. On blocking, I believe we've sort of privileged because we're from the international courts, we're probably among those that have had the opportunity to express ourselves on matters of government interference with access to the internet or parts of the internet. We have so far 2 judgments, both involving Turkey, Yildirim versus Turkey and Chingiz and others. And they involved, respectively, the blocking of Google sites that doesn't exist anymore, I understand, but it was a big hosting site. And the second one, the blocking of YouTube. The entire platform was blocked in Turkey for a number of years. And the court took the position, which I think is an important one, that first of all, this is akin to prior restraint, prior censorship, which means that the highest level of scrutiny and the highest standards as a matter of interference with freedom of expression ought to apply. And the court also talked about collateral censorship, because what happened in that case, because of about 10 videos that were found to be degrading of the memory of Kemal Atatürk in Turkey, the entire platform was blocked. And so the court said that that is a significant collateral censorship. And in the particular circumstance of that case, what it means once it is a matter of prior restraint under our case law, that means that you have to have very strict conditions. It's not an absolute prohibition of prior restraint, but you have to have very strict definitions in your national law and very about the scope of what you can limit, and then the procedural protections. And the court found that those protections were not there. And in fact, the Turkish authorities went beyond what their own law allowed. Second set of issues, intermediary liability. Now, if you follow these issues, you know that in Europe we fall sort of in between, I think quite similar to the lines that were described about Brazil, between the US position of practically complete immunity for intermediaries for, let's call it in general terms, harmful speech, either their own, but not most of the time, 99% of the time, is not their own speech. It's the speech of their users that harms other people. And so what are the liabilities, responsibilities, a matter of criminal law, civil law, and other aspects. And in the US, we have the Section 230, almost complete immunity. In Europe, under an EU directive, and that's the model mostly in most countries, we have notice and takedown, which I think it's similar to what our esteemed colleague from Brazil described. But it's not, that's the general principle, but there's a lot of movement and discussion around it. And we've had at least one case from the Grand Chamber of the Strasbourg Court which has been a matter of a lot of debate. I'm not going to go into the facts now, but it's a case against Estonia, Delfi versus Estonia, which was about the liability of a major commercial newspaper portal. So not a mega platform, but an important national platform, and about some pretty strong comments by readers that were critical of a private individual and a private company. Not just critical, but the court considered that it was hate speech. And in that case, the court went even further than the notice and takedown, because the court said in this particular situation, given the very extreme nature of the speech, the company, it was okay under Article 10 of the Convention for the state to hold the company liable for not acting even in the absence of complaint, sort of without notice. So this raised the question, is the court throwing the entire European model into disarray? But the Grand Chamber tried to be quite clear and limit that ruling based on the extreme form of speech and other circumstances. And we've had at least 2 or 3 other cases afterwards, in 2 Hungarian cases and in Tamiz versus Google, a UK case, where the court said, for most intents and purposes, notice and takedown will be okay. That raises another question. Now, this is a long-standing debate, but many people who were sensitive about free speech issues will say that no content should be taken down without a court order. And it pains me somewhat to say that I don't think I can agree with that in the current internet ecosystem. It's just not possible, given the volume, the gravity of what is at stake. If you just look at the amount of stuff that is uploaded, I don't know, on YouTube every minute, it's practically impossible. And we've passed beyond that. If you look at the practices of the operators. And so then the next question is, if you accept that there needs to be self-regulation, then the next question is how much and to what extent, and in what conditions, what kind of internal due process. And I think there's no question now that, well, there may be a question, but my view, and I think a growing consensus, is that the platforms need to do more to limit harmful speech. And I think an important turning point, that is what happened with the US election. So hate speech affecting a number of individuals, even revenge porn, which is very serious in terms of impact on individual rights, are quite serious. But then when you presumably allow your users to interfere with the integrity of the electoral process in one of the world's big democracies, and you've had hearings in the US Congress, before the UK Parliament, the European Parliament, then that is a gravity of an altogether different scale. And I think there it's quite clear that the platforms engage in a great degree of self-regulation. I understand it's a bit of a commercial secret how many people they exactly employ for these purposes, but I think for some of the big ones it's in the tens of thousands. And that's quite an army. So they already monitor and regulate user-generated content. And for that purpose, I think it becomes increasingly important that you have due process, but due process of a different kind, perhaps. That's internal due process that creates a proper balance between the rights of the users on both sides, because you have users who are engaging in harmful speech that affects others, but you also have users who will claim that speech that was taken down violates their freedom of expression, which is also a very complex set of issues. And in both of those regards, I think we need proper due process. One possible model is the the Digital Millennium Copyright Act that they use in the US for copyright only, and that has a system of notice, counter notice, and gives the rights to both parties. And that is something that we're missing in Europe. So there is an e-commerce directive of the European Union that establishes the principle of qualified immunity, but there's no procedures there. There's no procedural safeguards. There's been a long discussion about the need, but for political and technical reasons, we're still in a situation where there is no due process enshrined in law. My time is up, I'm afraid, so I'll stop here. I meant to say a bit more about sort of what rights users do you have against the platforms as such, but if someone wants to ask that question, that will give me another minute to answer.
So thank you, Judge. The judge himself summarized very well in the beginning his main point. So the issue that the European court is already dealing with. So the issue of blocking and the governmental interference directly with the content and the internet landscape. Then he got a little bit deeper in the issue of internet liability in the different cases. The European Court already analyzed on that, and he was elaborating on the issue of self-regulation and the idea of due process in this process within the platforms and the internet providers. And I guess that part of your suggestion is very much related to the discussion of transparency and accountability related to this internal process, and how also the users will have a voice, either if they feel affected by a content or if they feel affected by a removal of a content, but also the impacts, as we all know, in the electoral processes in many countries, not only the US. So thank you very much, and I'm sure the colleagues will help with questions that will allow you to go deeper in your thoughts on that issue that is very important. So now, last but not least, on our list of initial speakers, we will have the perspective of a regional court in the African region, ECOWAS, which is Human Rights Court in the Western Africa. So Justice Asante, you have 10 minutes to share your thoughts with us. Thank you.
Thank you. I'm called Justice Edward Asante, President of the ECOWAS Court of Justice. I come from Ghana, though, but the court is based in Nigeria, so I live in Abuja and work there. ECOWAS is Economic Community of West African States. That's an acronym for the ECOWAS. It's a 15-member state organization, and the court is the main legal organ for the community. In member states, it is very certain that they have their constitutions and they have provisions of protection of human rights and freedom of speech and even of journalists in their constitutions. Countries have also gone ahead to pass data protection acts, laws on privacy, and so many laws to protect those areas so as to enhance the use of the internet. But then there are also sanctions attached regarding those who use them to do things that are not right in the society. Actually, many judges in the various countries, sometimes when these laws are passed, to build their capacity, there are judicial training institutes in those countries that take it up to try to help them have education on the laws. Therefore, in case of any such matters, they are able to deal with them very well. On the front of the court, there have been a few cases that have come before the court in respect of violation of privacy and data protection that have been very critical. And the court, being a human rights court, has taken examples from the European Court and other international human rights courts and dealt with them. Particularly the issue of right to privacy and data protection. There were top state officials who, as an example, took bribes. But then in the course of taking those bribes, they were filmed and recorded by private investigators. So they came to the ECOWAS court when they were being investigated in their home country for those allegations. They felt they could rely on the Data Protection Acts and the Privacy Acts And therefore, they came to use that as their defense. But then the court said, no, these are things that affect the public generally. The positions you are occupying are very sensitive positions for the society, for the benefit, and therefore the court whittled their right down, though the court found clearly that the mode of ascertaining that kind of, obtaining the evidence was against their rights, but the court looked at the general societal good for, particularly there's a provision by the ECOWAS community, the democracy and good governance, which looks at both ways of it. Either when you are a public servant, you need to do the best for the community, and therefore they use that to whittle it down. They dismissed their case. On the other side, when it's between private individuals, there's another one, someone just went to record secretly, called a party in a case with the intention of trying to get incriminating evidence or using the internet, used it and then tried to tender that particular evidence in court. The court said no. This one, the intention was very diabolic. You had planned to get the person to get that piece of evidence to use it in a private matter before. So therefore, these are some of the issues. Then the issue of censorship also comes into fray. In one country particularly, the government wrote to all media houses that 48 hours before the publication of any event, any activity, political activity, they should present their program to government for them to look at it, to avoid hate speech and other kinds of things. But then they came to the court, and the court said there had not been any serious proof by government that their previous programs had led to that, or that they have done that before, or that they intended to do that. And therefore, the court said this is a serious affront to freedom of speech, and therefore the court set aside that order and directed that they cannot do that. And if there's serious proof, though we know that when there's anticipation of any breaches of public morals and public health and all that, they can ask them to bring the programs or for them to look at it or even whittle down all the. But then once in this particular case there was no serious evidence by the state, the court said, no, you cannot do that. Otherwise, there's a line where they must not cross. But then looking at the state, the case as it is, there was no proof. So the court decided not to allow that to go on. Then there's this issue of hate speech, which also happened in one country. There was a matter before the courts, and in a radio program, some people took it upon themselves to warn the judges that if the judgment didn't go a particular way, they cited so many things, insulted the Chief Justice, insulted the judges, and claimed they would do certain things which had happened to certain people before. And therefore, it was a very serious matter, and the court had to deal with it decisively. What the court did, it happened in one country, that's a national issue. So they cited them for contempt of the courts and then dealt with it. So actually, they jailed the people for about 3 months each. And then they also fined heavily the radio station, the sponsors for not controlling their people. There have actually been other claims of hate speech in the sub-region, actually, by some countries, Niger, Togo, and other places. But unfortunately, they've not come before the court. There have been reports on them in media, and therefore one cannot rely. But there's one particular one which is now before the court, which I cannot speak to because it is before the court, but then the facts are very clear. Government, as usual, wanting to do their own, to extend their term of office, had opposition from certain other political groups, and therefore they shut down, they brutalized people, they shut down people's internet facilities because they were using it to broadcast things that were very inimical to the society, and or were making the government unpopular. And therefore the government had to shut down the internet, destroy certain things. These are allegations, and they brought the matter before the court. A panel is now undergoing the written procedure. It hasn't come to court for us to even set up a panel, and therefore this is basically the general issues on it. And when it comes to this, I think members here will try to follow the case and see how it goes. Generally, the court has been friendly in human rights and particularly freedom of speech matters. In Gambia particularly, there have been about 5 or 6 cases wherein the court has admitted that civil society organizations and NGOs can even have the right to come before the court to bring cases of violation of human rights, violation of freedom of speech on behalf of victims, which is a very good thing to do. Mostly it is victims, but then the court has gone further to say that these people can bring it on their behalf, which is being done now. The court has also awarded so much damages against even states and governments which have violated people's freedom. They've arrested and jailed, detained and maltreated journalists and owners of media houses. And the court has definitely even advised and directed that certain local laws which are inimical to the UNHCR, the ICCPR, and the African, the ACHPR. All these, the court directed, it is said and clear that Gambia abided, and in one case, they amended some of their local prosecuting laws, which were very inimical to these international laws. And so these are some of the things that the court has done, and I think are worthy of mention here. Thank you very much.
Thank you so much, Justice Santos. So some heads up here. The court has taken cases already on privacy, data protection. It was very interesting to see the judge underlining how the decisions are taken when civil servants are involved, and the decisions that the courts, also the Inter-American one, has taken decisions like that on special protected speeches against civil servants, because this is part of the democratic debate and doing the relationship between public interests and this allegedly affected of civil servants, the case of censorship and hate speech, and how some governments or some civil servants are using the idea of hate speech regarding anything they don't like. No? So this is a problem that we are seeing in many countries, and how the court is also creating a jurisprudence in the ECOWAS region using international standards from the African standards on human rights, but also from other courts and for other regions. And both Judge Darian and Justice Asante kind of gave us a lesson on how to apply the triple test in taking decisions regarding freedom of expression. They mentioned issues of proportionality, the discussion of legality, and the special need for taking restriction of freedom of expressions according to international standards. So now, this summary made, it's time for our 3 discussants. They will have 5 minutes each to raise a few elements from what they heard from our main speakers. So Agustina, perhaps you could go first.
Sure. Thank you, Guillermo. So first, thank you for, I know we co-organized this, but of course the central energy behind this is Guillermo. So thank you so much for pushing this agenda. It's great to see judges coming and participating at the IGF. It's refreshing. So there's a lot to unpack from the 4 presentations, I feel. I want to make 3 points that I think arise from common threads between the 3 presentations. One of them is to really underline the role that judges play and how judges have this privileged position to analyze internet governance issues while they get to see concrete cases and how policies are being applied, which I think gives them a lot of the times more time to reflect upon the legal analysis that is needed to go into these questions. In Latin America, we as a center have been monitoring legislation for a couple of years. And what we see a lot of the times is a pretty big disconnect between the legislative and the judiciary
in many cases. And this disconnect has a number of different ways in which it is shown. For one, we have interesting jurisprudence coming from the courts in some particular directions, for example, on freedom of expression and intermediary liability, and we see a lot of times congresses running exactly in the opposite direction, against what some of the courts in the region have already said. The other disconnect that we've seen is that a lot of times we see congresses and governments acting pretty much reactively before certain issues that they have huge pressures to address in one way or another. So we end up seeing a lot of bills of law that are very reactive to the moment, and that when seen through the lens of courts, definitely in their application and the granularity of applying those policies and those laws, I think you can really see the privileged position that the judiciary has regarding these issues. The second point I want to make is to underline two issues that came up in almost every presentation as challenges that the judiciary is still facing. One of them is jurisdiction. Directly or indirectly, I think you all mentioned it. Bertrand de la Chapelle is over there with the Internet and Jurisdiction Project, which, by the way, I think could really benefit from judges' input. But I think it's a common challenge that we have, and we could really benefit from getting more insights from the judiciary on these discussions over internet governance. The third and final point, I'm done, I swear. The third and final point is I still feel there's a lot of training that is needed for the judiciary. So in that sense, I think UNESCO initiative is pretty amazing. I was very happy to participate in some of the trainings, and I do see a huge demand from judges. There's a technical aspect to a lot of the issues that we're talking about that definitely require a lot more capacity building in this particular area. Thank you.
Thank you so much, Agustina. And so a few highlights. This disconnection, which I think it's also a heads up for more dialogue between lawmakers and judiciary power members. I know that we have different members of parliament here and in this IGF, so I think this could be a start of something like that. How reactive executive and legislative power are, but then, and perhaps this is later on a question for you, members of the panel, the need for the courts to do constitutionality control and, as we say in the inter-American system, conventionality control of those laws or those reactive bills that are decided by the parliament, then the issue of jurisdiction and the issue of training. So now the views of the private sector, a platform that is very much involved in many cases being decided by judges elsewhere in the world. So Facebook, Monica, you have 5 minutes, please.
Thank you, Guilherme. Well, so my name is Monica. I've been a public policy manager at Facebook Brazil for a little over 3 years now. And I just have a few comments to make based on the presentations that came before me. The Brazilian Supreme Court is currently deciding on 2 very important cases that really touch upon the last point that Agustina made, which is about how we need to foster more trainings, because more and more judges, the Supreme Court is about to decide on Article 19 of the Brazilian Marco Civil da Internet. That's the Brazilian framework for the internet, and that's the article, the provision that provides safe harbor for application providers. So that provision states that app providers, the platforms, shall not be held liable for content posted by their users unless they fail to comply with a court order. There are two exemptions to that. One is revenge porn, and another one is copyright, which is yet to be decided by a reform in the Brazilian copyright law. But basically, that's the safe harbor provision. It's currently under discussion by the Supreme Court. I hear from a lot of judges that provision overwhelms the judiciary, the Brazilian legal system. And a lot of people don't know that Facebook does remove tens of thousands of content every single day globally. It's a 2.7 billion user platform because these contents violate Facebook's community standards or terms of service. Some of those removals are really easy to spot. No one will argue that a picture is a child exploitation imagery or is not, but some of those are really, really hard to make a decision on, such as hate speech. Judge Darian, you mentioned the number of people. We currently have 35,000 people on Facebook working on safety and security, and that involves the people that do content review, as opposed to 10,000 only 2 years ago in 2017. So we've been investing heavily on this front. So we do remove whatever violates our policies, but there is a spectrum of content that doesn't violate our policies, but that might potentially violate local laws. And as a company, we believe that these decisions, we shouldn't be in the position to weigh in rights, and that these decisions should indeed be made by the local judges, and that's currently under discussion in Brazil. Another high-level case that's under discussion in Brazil is the blocking of whether the blocking of private messaging apps such as WhatsApp should be constitutional or not. And that's a discussion that involves very, very specific technical issues such as end-to-end encryption. 3 years ago, I was not aware of how end-to-end encryption works. I've been working on this issue a lot, so I can't fathom that judges who are faced with these issues will have, knowledge over these very specific topics. So, and that's why Facebook is so proud to support and to keep supporting programs such as, the one that UNESCO is doing in partnership with ISOC. I'm sure you'll be talking about it. I'm also very proud to be leading an initiative in Facebook Brazil in where my team and several other different teams within the company, we literally tour the country, and we talk to courts, and we talk to prosecutors, we talk to the federal and state police, letting them know how the platform works, how the systems for collaborating with law enforcement works. Most of the time, the feedback we get is extremely positive. We didn't know this existed. We didn't know this channel was even available. Next year, we have elections in Brazil. We're likely to have 500,000 people running for office. So, one of our big plans for next year is talking to electoral judges about our ads transparency tools, about how the platform works. There's a big difference between removing someone's whole profile, that's one specific URL, or a comment to a picture that was actually deemed offensive or that should be removed. That's a different URL. So just to give you a practical example, I'm going to wrap up before Guilherme kills me, but thank you so much.
Thank you. So it's very interesting to see the perspective of the platforms that need to go to court in some of those cases. Perhaps later on, judges and Adeline, you could comment on this specific case. It's a specific mention Monica did on how difficult it is to take decisions in some cases on very highly technical issues. No, the end-to-end encryption is one of them, but there are zillions of others. Then there is also a point that Judge Darian has has already mentioned, that is the overwhelming amount of cases arriving and reaching the judiciary everywhere, and how the system will cope with this amount of cases is everything needs to be decided by a judge, and normally we would say should be in cases that are might have limitations of rights, so how to cope with that, and also the difference between the terms and conditions of the platforms and different local laws, but also the international standards of freedom of expression and access to information. So now, thank you, Monica. Last but not least, our last discussant commentator, my dear friend Sebastian. You have the floor for 5 minutes. Thanks.
Thank you, Guilherme. Good afternoon. I'm Sebastian Belagamba. I'm the Regional Director for Latin America and the Caribbean at the Internet Society. I've been spoiled a bit. Monica already told what I was going to talk about. But I'm very proud because actually your wrap-up was excellent, Guilherme, in order to introduce what we've been doing together this year. Because sometimes it's not just how the law applies to something, it's how you make it happen. When you have something that is so different and so new and so technical, specific as the internet in between, and sometimes the judiciary system doesn't have the technical knowledge in order to make it happen in the right way. So we partnered this year, as Monica has already stated, with Facebook and UNESCO in order to create capacities among judges in America Latina and the Caribbean, basically on how the internet works. An introduction on the technicalities and some non-so-technical aspects of the work of the internet. As you might know, the Internet Society, it's a technical community organization. We've been born 27 years ago. In internet times, it's a long, long time ago. And our fathers were those engineers that developed the internet at the very beginning of the times. So our expertise that we brought to the table is our technical expertise, our understanding on how the internet works. And we created this capacity building training for judges and judiciary representatives throughout Latin America. And basically I'm gonna summarize what we did this year, and we trained 414 participants in Latin America. In a 6-module version of our Introduction to Internet Governance, which was tailor-made for this training, we basically covered 6 modules, one on Introduction to Internet Governance, one Internet actors and stakeholder groups, but the third one is Internet infrastructure, standard and protocols, how the Internet works, the Internet policy principles, Internet invariants, legal aspects of Internet governance are the 6 modules that we had. It was very impressive because there is some particular cases that make this urgent and necessary. Remember a while ago, one case, just to relate to one of your competitors, in this case, as you mentioned, your own, but a judge trying to block content on one blog. One blog, they tried to block the IP address of that blog. The judge actually ordered to block the IP address of that blog, and it was on Blogger. And they blocked that blog, as well as 40 million blogs more that were sharing the same IP address than that. I will invite you I think a good example of this training, and something that was very welcome is a paper that I think it portrays very well what we are trying to do. A paper that was released by the Internet Society like 2 years ago on content blocking. Basically, what the paper does is, from a technical perspective, summarizes all the technical ways to block content on the internet. There are 5 of them. And the problem is that the way the architecture of the internet works is that none of them is perfect, and none of them is without any damage that is not the end that you were looking for. So applying each of these 5 will have some harm, and there will be some way of circumventing it. So I have to wrap up. I got the paper. And I invite you to join us in this discussion. And just the last thing, we will try to replicate this training in 2020. Thank you very much.
Thank you, Sebastian. So this course on how internet works, and it actually attract lots of attention from judges from all over the region. There, as he said, was 414, but it's interesting that they were dispersed from many countries in Latin America and the Caribbean. So it was also interesting to see how they dialogue in the forums, their doubts among themselves as judges on those issues, the issue of proportionality on the decisions that was already raised before, and the blocking content. And this paper he mentioned is very interesting. So since they were very good students and stake to their time, we have 15 minutes for questions. So let's try to get 3 or 4 back to them, and if we have more time. So one here, Bernard, and one there, and then the 4th, and then we go back. So please try to be brief so that we can get more questions. We have mics, or yes?
Yes, we're here.
You need to queue, so
we're queued at the mic already.
Sorry, I didn't see you because we have some lights that are burning us, dear. It's like if they want to offer us for dinner later on.
Thank you, Your Excellencies. It was a wonderful panel and very illuminating. I have 2 specific questions to the panelists. The first thing, as the Malaysian speaker said, jurisdiction is a very important element in enforcing law. And on one hand, we have companies which are American and which exercise their power all over the globe, and therefore there is a serious problem for somebody like me who comes from India. Now, we have serious problems with Twitter, Facebook, and YouTube, which have a lot of hate speech on them, and then we have no idea how the internal rules of Facebook or any of these companies operate. And therefore there is a problem there, because as an Indian citizen, am I subject to the rights that the Indian state gives me, or am I subject to Facebook, which has zero accountability to me as a citizen of my country? It's a serious problem. It's not Facebook's fault, but there is need for some kind of a legal frameworks, which I would like the experts on this panel to speak on. That's the first point. Second point is, we all know that in spite of employing 35,000 people, Facebook is still very profitable. And the money that Facebook or Google or YouTube make is from the data that the users are putting into those systems. And right now, we just have an option of saying, I agree to everything that they ask us to in terms of giving up our rights over data. There are some principles on data. I'll just read one of them. This is a part of a manifesto of principles which will embody legal frameworks. And the principle says, data creating work ought to come with data rights. So as of now, if a case comes saying the data that I put on Facebook or on YouTube, what rights do I have over it vis-a-vis the platforms? And in that sense, it also is a question of the economic imbalance between the first world and the developing countries. Thank you.
Thank you so much. So, Bernard?
Good afternoon. I'm Bertrand Lachapelle, the Director of Internet and Jurisdiction Policy Network. Quick comments on the remark that was made by the person from Malaysia regarding the lack of warrants in many countries. I encourage you to look at the work that Peter Swire has done, if you don't know already, on the possibility of establishing special rules for access to e-evidence when it is a transnational request. The second thing is, courts are very accustomed with handling issues of proportionality. One of the things that came out of the Content and Jurisdiction program in INJ is the fact that there's a new dimension, which is geographically proportionate restriction. What is the geographic scope? And this is, of course, one of the things that has been discussed in the European Court of Justice on the CNIL case regarding the right to be de-indexed. I want to finish by saying there is a very interesting checklist for rule of law, as you know, in the Venice Commission. And one of the elements that is highlighted there is, of course, legal certainty. One of the challenges is that although Facebook and other platforms are publishing the criteria and their terms of service, they are very regularly updated, which is a necessity to adapt them to the environment. But when the norms applicable are basically changing every 2 weeks, it is making it difficult to really have an element of legal certainty. Thank you. And if I may, I have one question. There is increasingly extraterritoriality in a lot of national laws. I'm beginning to wonder, it's just a hypothetical, whether in terms of international law and the constitutionality of some of those laws, there might be an evaluation of the proportionality of the exercise of extraterritoriality. But that's just an open question.
Thank you. So let's get one question from each side of the room. So please go ahead.
Thank you. Steve Del Bianco, question for Judge Darian and Monica regarding intermediary liability. Judge, I thought it was so helpful the way you framed the ends of the spectrum between the US approach on the one side and Brazil. So on intermediary liability, you characterized the US approach of Section 230 as one of near total immunity. And I wonder if you were aware that Section 230 provides no immunity if the platform is accused of activity by its users that violates federal criminal law. The immunity it provides is from civil suits, of which we have too many in the US, and local and state laws. But there's no immunity at all for federal criminal violations. I'm sure you kind of knew that, but I wanted to make that clarification. And my question, Monica, is in Brazil, the notice and takedown regime that you have at Facebook, you said there were a couple of exceptions to it. I believe you said revenge porn and a couple of others. But those are easy to spot. Judge Andrade said before he left that Brazil was considering a fake news law. Now, if fake news is something that's determined by the court, that's much easier for you in a notice and takedown. But do you believe that the law in Brazil is heading towards a mandate that you have to evaluate and determine if every post is true or false or face liability? Thank you.
Thank you. One here, please.
Good afternoon. My name is Natalia Krapiva. I'm a tech legal counsel at Access Now. We're an NGO who defend and extend digital rights of users at risk on the internet. My question is for the honorable justices on the panel. Do you think that judiciaries have a role to play in cases where states use national security exemptions in the law for internet shutdowns, website blocking, surveillance, and other measures that affect civilian infrastructure and the rights of the users? Thank you.
Thank you. Raul?
Thank you. My name is Raúl Echeverría. As one comment, I heard, we hear many times that about the platforms should do more, about self-regulation, and et cetera, et cetera. I want to make a point that sometimes when we are trying to punish the platforms, saying, okay, you have to do more, you have to invest more in detecting the contents, illegal contents, or terrorist information, or whatever, as what we are doing is exactly the opposite of what the authorities or the judiciary authorities want to do. That is, they want to limit the power of the platforms, and what they are doing really is to empower the platforms when they are saying you have to solve it. So I think that that's not the solution. Unfortunately, it seems that it's not the solution either that the platforms are looking for. So there is a certain convergence here that we have to take advantage of. So I call to look for different approaches, and I know that the platforms have to do more, have to collaborate more, have to be more proactive in many things, and to be more transparent, basically. In recent elections in my country, I tried to help several candidates' teams to deal with false information, and it was quite frustrating to go through the processes to deal with the platforms, and the results were not as good as we expected, while we are conscious that the platforms have made available new tools and procedures that go in the right direction, but it's not enough. Much work is needed. Thank you.
Thank you. Last question here for this round, at least.
Viola Schmidt, I'm a German law professor, and I want to inform you about a groundbreaking decision the highest German court, the Federal Constitutional Court, rendered yesterday, and it's the first decision about the right to be forgotten. This is part of European regional data protection law, and why I want, from a global perspective, to inform you about it is maybe there is a different vision of true speech. After 30 years, it was concerning true speech of a media online archive, and the murderer had been sentenced 30 years ago. And so my question to the panel is, the right to be forgotten is any point of interest for you, question one, and the second question is, don't you see that we will have a totally different culture in one vision, in one internet? Thank you so much.
Thank you. So at least 8 or 9 very huge points: jurisdictions, data rights and accountability, citizens, users versus platforms, proportionality, rule of law, checklist, so legal certainty from Venice Commission on extraterritoriality and internal law, few questions on internet liability, fake news, national security exceptions. Then there was the risk of private censorship, empowerment of platforms, and finally, a very simple issue, rights to be forgotten. So, and we have 4 minutes and 52 seconds. So I will ask the 3 speakers to select one issue. You have 1 minute and then 30 seconds for the others, and we need to wrap up. So let's start from the other side now. So please, Judge, 1 minute.
Thank you very much. On the use of national security, it's a bit a dicey situation. National security always hide behind things that go against the state. And therefore, they try to clamp down on people's rights using national security reasons. But then the court must be satisfied. That's why you come to court. The evidence must be there. They just cannot come and parade as national security and then you allow everything to go. For instance, in some countries, they need court orders to even go to telecos for evidence on calls that were made and all that. So the court needs to be satisfied. So they use those ones, fine. But then when you come to court, the court will investigate and find out and know the actual evidence. If it is evidence that the court must support in terms of protecting national security and public safety, the court will do that. Otherwise, the court will whittle down whatever they've done. Yes, in my view.
Thank you so much. Judge Darian?
Yes, I mean, there was one direct question about criminal immunity in the US. I certainly do not consider myself an expert on the US framework. I just wonder, I would have seen it in the news. When was the last time that a senior executive of the platforms was held criminally liable in the US? I must have missed that. I know a little bit about the civil liability, in part because I had to give a talk recently about the US and European position. And one of the cases I picked up is Caraccioli. It's a case decided in California. And I won't name the platform. They've already come under a lot of criticism here today. I think you can look it up yourself. But this was one platform that refused to remove a fake profile of a man featuring sexually explicit videos of images of him. I mean, I think from a European perspective, any balanced perspective, one would say, why on earth would this platform refuse to do that? And I think the answer is because they can. As a matter of law, they can. So that's the effect. But as a point, I mean, are we empowering platforms? Yes, to some extent we are, if we're giving them the responsibility. But what's the alternative? And what I'm concerned about is not that Facebook or Google may have to hire another 10,000 or 20,000 people to do the moderating. They're fabulously rich, and they have a global reach, and with that comes global responsibility. That's not my concern. My concern is the incentives that we provide. So if we tighten the incentives beyond what's proportionate and reasonable, then we're going to have more speech censored than is necessary. And it's a very, very delicate balance, and that one would need to look at even on a national basis. At the end of the day, is policy making by every country, but with cross-border ramifications, of course. And on the right to be forgotten, just one sentence, yes. Very interesting to hear about the decision by the German Constitutional Court. I don't know if it's the same case, I doubt it, that was decided by the Strasbourg Court recently. It's ML and WW versus Germany. That's a right to be forgotten case. But it's similar. It's about a murder that happened a long time ago.
Thank you, Judge. Adeline, your comment on one issue that you want to...
I wanted to actually address the issue of the right to be forgotten, because thank you for sharing it. This is the first time I've heard of it, and I had to Google and look for it just now. But I think rather than it being an issue where there are different interpretations of the law and different ways that the law is being enforced, I think decisions like that will promote more consistency overall globally in terms of as far as the law is concerned. And the main reason is because of the GDPR. It has extraterritorial jurisdiction. It applies to non-EU entities. So countries like Malaysia, we're actually having to draft or amend our data protection laws to be more consistent with the GDPR. So these kind of decisions are more, would promote a global harmonization of laws in relation to the protection of information.
Thank you. I know, Agustina, that you have a plane to catch, so I don't know if you want to use your 30 seconds now and you are free to leave.
Sure. No, just want to agree with what Judge Pavli was saying. I think the two main issues here are access to justice and jurisdiction and accountability, whether we're talking about self-regulation or regulation. The judiciary has a big role to play in the entire conversation, and it all ends up adding up to a question of proportionality and clear-cut rules, whether self-regulated or regulated by Congress.
Thank you so
much.
Thank you. So, safe travel. Sebastian, do you want to use your 30 seconds?
Less than that. It's a call to action to work together. If we don't do this together, all parts involved, we are not going to make it. So let's collaborate on that, and the solution is gonna be there for all of us.
Thank you. Monica, I know you were mentioned several times.
I don't feel I have enough time. So I'm not going to answer everything, but just try to address a few of them, the highlights. Facebook's been working really, really hard on being more and more transparent. The way our rules work, our community standards, our terms of service, we've been working hard on making that language the most accessible possible, yet allowing people to go into detail on how we take decisions. And look, I'm not saying we get everything right all the time. We don't. And because we acknowledge that we don't, we're creating the External Oversight Board, which will, it's an independent body that will be able to make decisions on Facebook's decisions over content removal. Decisions by this board will be binding on Facebook. Facebook will not be able to appeal. And this board will also be providing Facebook with input on its own internal policies. And that leads me to Bertrand's questions. Yes, we're updating a lot. I'm happy we're updating because that means we're taking input. My team is responsible for working with a team in MPK that consults with experts every single week so that we can make our policies better. Maybe that's too much information, but we're maybe erring on the side of being more transparent. But I understand your point on making it difficult, it's difficult to have legal certainty because at the end of the day, we are, and finally, just on a comment on intermediary liability, I'm sorry I didn't make myself clear, but we do not have a notice and takedown regime in Brazil. Even for copyright law, it's under discussion. The law needs to be revised. What we do have is a system in which companies are liable only if they fail to comply with a court order. And regarding fake news, there are over 30 bills of law proposed currently in Brazil that try to criminalize fake news. And actually, a lot of those try to impose the responsibility for deciding what's true and what's not on the platforms. We fight those bills. I don't want to live in a world where Facebook has to decide what's true and what's false. We should not do that. And if you look into Facebook's terms of service and community standards, you will not find a regulation that says you are not allowed to post fake news, because if we were to say that, we would be putting ourselves in that position. The way Facebook works with fake news and disinformation is by working with external fact checkers, and we don't remove the content, we demote the reach that that content gives, and we try to give people more information. So if you choose, for instance, to share an article that has been marked as false by a third-party fact checker, they're all internationally audited and certificated by Poynter, then we'll show you a screen that says, look, this article has been marked as false. Are you still sure you want to spread that? And we find that people, when they have more information, they make better decisions. So no, we do not want to be the arbiters of the truth, for sure.
Thank you. Just perhaps a clarification that it's important to understand the Brazilian scenario regarding fake news and judiciary and law is different for many countries. In Brazil, the regulation of elections is made by the judiciary. So as you have labor judges, civil law judges, family judges, criminal law judges, there are electoral judges in Brazil. And with the same scheme, you have lower courts, appeal courts, a federal Supreme Court for electoral things, and they are in the same scheme of career. So, of course, in that case, it's even more complex, because the judges during the last election, they were actually receiving thousands of requests to take decisions if this is fake news or not fake news. It's not very the same case in other countries that you have an electoral authority that's not connected with the judiciary power as it is the case in Brazil. From our side as UNESCO and the other co-organizers, we should only thank you very much for being here such late in the night. Thursday, I know you have a party in a few minutes, but I think the amount of people that came during the session, I'm seeing many people here that deals with strategic litigation, jurisdiction issues, lawmakers, the other parts of internet community, which shows that we must continue with this interaction between judges in the internet governance community and other judicial operators. UNESCO will continue with this judges initiative, which is a global program. As Cedric already said, we have been already involved in training 13,000 judicial operators in Latin America, 2,000 in Africa, and the program will be expanded to Asia and to Europe soon. So I hope if you are interested, you can join the initiative. I'm sorry I couldn't accept the other questions, but I'm sure the panelists can stay a little bit more if you have some issues to discuss with them. Thank you very much. Have a good evening, and let's keep meeting each other during IGF.